Okay, madam. Hello.
ಶ್ರೀಪಾಲ್ ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಹಲೋ.
ಕೇಳ್ತಾ ಇದೆ.
Okay, sir. Thank you, sir.
ಅಲ್ಲ ಇದು ಸರ್ ಇನ್ನೊಂದ್ಸಲ ಸರ್ ಡಬಲ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ನಿಮ್ದು.
ಇಲ್ಲ ಸರ್, ಅವರೇ
ಇಲ್ಲ, ನಾನು ಯಾವ್ದೋ ಮೊಬೈಲ್ ಹಚ್ಕೊಂಡಿದ್ದೆ, ಮೊಬೈಲ್ ಹಚ್ಕೊಂಡಿದ್ದೆ, ಅದಕ್ಕೆ ಡಬಲ್ ವಾಯ್ಸ್ ಕೇಳ್ತಾ. ಈಗ ಈ ಸರಿ ಕೇಳ್ತಾ ಇದ್ಯಾ?
ಸರಿ
ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ?
ಎಡಿಟ್ ಡಿವೈಸ್ ಅಲ್ಲಿ ಕನೆಕ್ಟ್
My lord, ME for posting.
ಕಳಿಸಿ ನೋಡಿ. They are going to settle it. Date got, settlement ಅಂತ ಒಂದು date ಹೇಳಿ ಕಳಿಸಿ.
Monday, 17th. Madam.
Pay for the climate in this case.
17th.
ಕೊಡಿ ಕೊಡಿ.
ರಿಲೀಸ್ ಅಪ್ಲಿಕೇಶನ್ MP ಆಗ್ಬಿಟ್ಟಿದೆ, ಸುಮ್ಮನೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬಂದಿದ್ದಾರೆ ಮನೆಗೆ, ಅದಕ್ಕೋಸ್ಕರ ರಿಲೀಸ್ ಗೋಸ್ಕರ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ರಿಲೀಸ್ ಎರಡು
ಅಂದ್ರೆ ಅದರಲ್ಲಿ ದ ಡಿಸೀಸ್ಡ್ ಹ್ಯಾಸ್ ಅವೈಲ್ಡ್ ಎ ಹೋಮ್ ಲೋನ್, ದೇ ವಾಸ್ ನಾಟ್ ಏಬಲ್ ಟು ಪೇ ದಿ EMIs.
ಇದು ಮಂಡನೆ. Monday.
That much I wrote on 16/11/2023. It was agreed that the matter be heard when I put the maintenance application, the matter be heard. So the honorable court was pleased to hear for hearing. There are 3 other maintenance applications. The office is decided for hearing, we can't post the maintenance application. For last 2 years, maintenance is not given.
Is it for hearing on IA?
I have filed 4 applications thereafter.
Is it for hearing on IA or final hearing?
I want only hearing on IA of maintenance.
ನೋಡಿ ಚೆಕ್ ಮಾಡಿ hearing on IA. See, we are not taking up new final hearing matters.
Only I am not.
My lords,
Then in another matter.
final hearing.
Which was admitted, there is a custody to be
Again,
given to the
17th
father.
hearing.
By virtue of admission, Lord, she is not allowing the father to see the child. And the
Number
pastor died to be present before the court, my lords, on 3/6/2024. Unfortunately, the matter was not posted. Therefore, the matter is not posted, was posted but was not taken up.
It was posted and
I wanted to, any day, the next week also it's all right, but I'll inform my client.
correct. What we are saying is we are not taking up final hearing matters, only we take year wise.
Get the
We
child.
cannot give you any preference over the other people.
She has not allowed the father to see the child for last 5.
You file an application for that.
Use direction to hand over to me. There is no.
Mr.
stay.
Counsel, now there may be a stay here. Then if there is no stay, you could have executed it.
Please, not executing would be too harsh for the child. I would not force it, mother. Let us bring it in the.
Correct, then you file an application for visitation.
Please, Lord, I'll make an application.
Adjournments, page wise, page 1, cell number 1 and 2, page 2, cell number 3 to 7, page 3, cell number 8 to 11, page 4, cell number 12 to 16, page 5, cell number 17 to 23, page 6, cell number 24 to 27, page 7, cell number 28 to 37,
That's serial number 29.
30?
29.
It is your matter only. You want adjournment? At least notice could have been ordered, no? IA one for direction, we'll pass orders on that, wait.
page 8, cell number 38 to 40, page 9, cell number 41 and 42,
My lords, page, serial number 42, my lords. I need, I praise for 2 days adjournment, my lords.
You only have moved it. Let us
Yes,
see when the
yes,
matter
yes.
is called.
Yes, yesterday only I filed the Okalat, my lords. I'm a counsel, new counsel on record. Just to,
Let us call the matter, any then the note, no, have you filed any application?
no, Your Honor, not yet. That's why, and I have to file.
See. No, notice was also not ordered, we'll see.
page 10, cell number 43 to 46, page 11, cell number 47 to 49,
My lord, serial number 49, my lord. I appear for appellant, my lord. Weeks accommodation may be granted, my lord.
Have you informed the other side?
Please, madam.
Yeah, informed, Geeta Menon.
Gita, madam. Yes, madam. I have texted her.
Send at the request of the appellant's counsel.
Any
Yes.
date, my kind.
page 12,
Adjourned, 2022
No, ma-
final
My
hearing.
lord, we
matter.
need to file an application, my lord.
You file it,
Yes.
then it will come.
page 12.
My lord,
cell
kindly
number-
date, may kindly be fixed, madam. Next week.
ಎಲ್ಲ ನೀವ್ ಹೇಳ್ದಾಗೇನೆ ನಾವು ಬರೀಬೇಕಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
Now,
application.
Today the matter is fixed, we are not ready.
No, madam, we need
now
to file.
adjourning it.
No, my lord, we need to file application.
Application register will list that.
My lord, it is come up for final hearing, my lord. Final hearing members
Correct.
conference.
ಯಾರು ಹೇಳ್ಕೊಡೋದು, ಯಾರು ನಿಮ್ senior?
Please, please.
page 13, cell number 51 to 53, page 14, Cell number 54. Page 16, cell number 55 to 57, page 17, cell number 58 to 60, page 18.
My lords,
cell number
serial number 59,
61.
my lords.
59, there are connected matters. means-
Serial number 59, my lords. I have moved an
Whom do you
application
represent?
for proposed amendment.
Whom
Appellant.
do you represent?
I represent the appellant, my lords.
Hmm.
I have
So
moved
you
an
are not
application.
ready?
I have moved
No
an
application
application.
is- No
Today morning, I
application
have
is
moved an.
listed. You have submitted an application in the registry?
Yes, my lords. Yes, my lords.
Where did you move the application?
Today morning, my lords.
Where?
I
Where
have
did you
filed
move the application?
to the registry, my lords. Today morning.
Adjourn-
Sought for
Just a-
amendment of the appeal
Appellants.
memo.
Yes. Adjourn-
Adjournment.
Yes, ma'am. Please, my lords, please.
Copy is served on you. Other side counsel is saying the copy is not served on him.
I'll get it served, my
Is there
lords.
any urgency for you?
Next week.
Is there any urgency for you? That's 2024 matter, sir. Adjourn at the request of the appellant's counsel.
Page 18, cell number 61 and 62.
62, Mel. Your lordship may kindly see, the child is supposed to be as per the orders of this honorable court. Child has to produce at 10:30
The
today.
director to appear before the court along with the child.
No child. Last time also they did not adhere to term orders of this honorable court. Today also they have not ordered. They are taking for granted orders of this court, Your Honor.
Really?
Your lordship. No, when the honorable court is retiring to the chamber, then they came.
Given by the coordinate bench, the parties are present.
And direction to produce them, they are not properly following the orders of this honorable court. Kindly. And also they vacated the house without informing us. When we went there on Sunday, nobody was there.
I no, don't pass over man.
But
Serial
number 62, my lord. Serial number 62, matter may be referred to local.
62.
For the appellant in this case, my lord.
Refer ಮಾಡಬಹುದಾ?
Please, madam, sir.
As requested by both side, matter refer to local. ಆಮೇಲೆ ಮೇಡಮ್ ನೋಡೋಣ.
Frauders, cell number 1, Purima HS.
For the appellant, my lord, I have filed a memo of retirement in this matter, my lord.
Issued the notice?
No, my lord, notice has not been issued.
Not permitted. You should issue a notice of retirement and then retire.
My lord, 2 weeks, it may be listed after 2 weeks, my lord, I'll do the needful. Parties are not traceable, my lord.
File the retirement.
I'm
However,
not
the
receiving
same is not
instructions from them.
accompanied by proof of service of retirement notice on the appellant. Now consider for the appellant seeks time to issue notice and retire. List after 2 weeks.
Grateful, my lord. My lord, a date may be fixed, my lord.
Then you first that then date ಹೇಳ್ತೀರಾ? ಆಯ್ತು date ಹೇಳಿ.
Very well, my lord.
2 weeks.
27-8,
Obliged, my lord.
You issue
27.
notice and get an acknowledgement.
27-3.
Obliged, my lord.
Cell number 2, P. Pradeep.
Please wait time, my lord. It's accept steps for
Two. 2022 ಕೊಟ್ಟಿದ್ದಾರಾ first time ಬರ್ತದೆ?
first time ಕೊಟ್ಟಿದೆ, second time.
Incomplete
Incomplete.
address. But at request 2 weeks time is granted to the next. Yes.
Cell number 3, Padmavati Uttur, MS Sudhir Kumar.
For appellant, filing memo, notice to respond number 7 may be dispensed.
Who is respond number 7?
Lordship, appearing for the respondent, there is an interim order dated on 16th to 11/2022.
Sir, he was respond number 1 before the tribunal. Owner of the vehicle?
Please, my lords. There are 2 vehicles involved in the accident, my lords.
Hmm.
The respond number 7's vehicle is insured with National Insurance Company, my lords.
It's a contributory negligence, Your Lordship.
Delete for today.
There is the interim order dated 16/11/2022. Still it is not complied and the acknowledgement is not filed before the court.
Interim order regarding payment deposit of the amount.
Deposit 50% of the award on the based on lower court. Still on 16/11/2022, the interim order has been passed. It's been 2.5 years. Still, the acknowledgement is not been.
My lords, the amount is deposited before this honorable court on 6/12/2022, my lords.
You have produced the proof also?
It is deposited before this honorable court.
Correct, ಅದ್ರದ್ದು collect ರಿಜಿಸ್ಟ್ರಲ್ಲಿ ಹಾಕಿರೋದ್ರದ್ದು ಏನಾದ್ರು ಇಲ್ಲಿ ನಮ್ಮದು ಹಾಕಿದ್ದೀರಾ ಅಥವಾ 6907 ಅಲ್ಲ ಇದು?
6/12/22 produced.
Office has not raised any objection for that. 612?
6/12/22, my lords. I have deposited 5,39,466, my lords.
22 ಅಲ್ಲ?
Please.
5,30,000
612 ಅಲ್ಲ?
ಇಲ್ಲಿದೆ ನೋಟ್ ಇದೆ, they have deposited.
ಅವಾಗ ಬಂದ್ರೆ ನೋಡಿ.
5,39,466. What is ಇಲ್ಲಿದೆ? ಇಲ್ಲಿ ಇದೆ.
They have challenged the liability. My lords.
It's a 50% liability, your lordship.
What is their liability?
It's a contributory negligence.
ಅದನ್ನ ನೋಡಿ, first they have deposited the amount, whether it is sufficient to cover up 50% ನೋಡ್ಕೊಳ್ಳಿ. 5 lakh ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? What 50%?
50.
It is contributing, it is more than that of the
First
50.
10 lakhs, 10 lakhs and 5 lakhs and above ಆಗುತ್ತೆ.
But in the prayer, they sought full set aside of the award.
Then counsel for the applicant submits memo for distinction of notice to respond number 7. It is submitted that insurer of the vehicle of respond number 7, that is respond number 2, has satisfied the award. Considering the same, notice to respond number 7 is dispensed with as straightforward. Contest ಮಾಡಿದ್ರ ಮಾಡಿರ್ಲಿಲ್ವಾ ಅವರು?
ಎಲ್ಲರಿಗೂ serve ಆಗಿದೆ. Only for respond number 7 it is not served, my lords. I have filed dispense.
Contested there or not?
Lordship, still trial court record is not been placed. It's a matter of 2022, your lordship.
No, it seems that he has not filed a statement of objection. What is next stage? Now you can. Furnishing PF. It is not yet admitted, but we are disputing the negligence.
Negligence as. My lords,
Admit
that,
call for TCS.
please.
List after receipt of TCS.
Till number 4, SV Hedde Mulkan. Yes, Suresh Kumar for R1.
For the amount, madam, a week's time may kindly be granted to take steps to respondent number 2.
No
Lord,
such person ಅಂತ ಬಂದಿದೆ.
Lord, in this case, your lordship are pleased to direct them to pay 80 lakhs on the last day. The award amount was 1 crore 60 lakhs, out of which 40 lakhs we have received. Lordship may please to direct the
What's
registry
the direction on which date?
on 23/3/2023, my lords.
23/3/23, no?
Oh, yes, my lords. My lords.
My lord, we have deposited the amount, 80 lakhs we have deposited. And my lord, they are permitted to withdraw 43 lakhs, my lord.
The other 40 lakhs, my lords, I may be permitted to withdraw because he is in dire states, my lords.
Now we have taken 40 lakhs.
Yes, my lords, we have taken 40.
You said he has not complied.
No, complied with the order for taking steps to R2, my lords.
That request will pass peremptory order against.
Lord,
That request finally.
But I appeal for the appellant, my lord.
Correct. If you do not take steps against respondent number 2, it will be dismissed as.
Respondent number 2 is the owner of the vehicle, my lord. I will take steps, my lord.
But you should take it within a reasonable time.
Yes, my lord.
Finally, 2 weeks time is granted to the needful in respect of respondent number 2. Failing which appeal against respondent number 2 shall stand dismissed. List on date hearing any matter. Weeks are
25.
25/3.
Still number 5, Ravindran P.
My lordship, last time the process issued by RPD.
Hmm.
Yes, she is present.
Is the respondent, what is your name?
Kavita.
You have your ID card or something like that?
Yes, ma'am.
Show us your address.
It is attached with the process.
Hmm?
It is attached with the process. Other card is attached with the process. Which has.
Process fee,
Yes.
Report, for report it is attached.
Yes.
Third personally.
Otherly ಇದೆ ಅವರದು ಆಧಾರ್ ಕಾರ್ಡ್.
Dalil wala. No, it's not here.
Along with that, Shara,
No, it's not here.
then let her produce.
ಇದೇ ಲಾಸ್ಟ್ ಪೇಜ್ ನಮ್ಗಿರೋದು. ಅವ್ರಿಗೊಂದು ಬೇರೆ ನಮ್ಗೊಂದು ಬೇರೆ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ ನಮ್ಗೆ ಸೆಕೆಂಡ್ ಕಾಪಿಯಲ್ಲಿ ಅದನ್ನ ಅಂಟಿಸಿಲ್ಲ.
ಅದರಲ್ಲಿ ಇದೆ ಆಧಾರ್ ಕಾರ್ಡ್.
ಸರಿ ಹೇಳ್ಬೇಕು ಕರೆಸ್ರಿ ಅಂತ ಸರಿ. ಅವಾಗ ನೀವು ಹೇಳೋದು ಮತ್ತೆ ಕರೆಸ್ರಿ ಇವಾಗ ಇದನ್ನ ಪಾಸ್ ತೆಗೆದಿಟ್ಟಿರಿ ಫೈಲ್ ತೆಗೆದಿಟ್ಟಿರಿ. ಇವನ್ ಆರ್ಡರ್ ಶೀಟ್ ಅನ್ನ ಸೈನ್ಡ್ ಆರ್ಡರ್ ಶೀಟ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ. ಹೇಳಿ ಸಾಕಾಗಿದೆ. ಹೇಳಿದ್ರೆ 1 hour ಕುತ್ಕೊಂಡು ಅದಕ್ಕೊಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬರೀತಾರೆ. ಟೈಮ್ ವೇಸ್ಟ್ ಇದೆ ಅದರಲ್ಲಿ. Yes, you have your.
I need some time to engage my
Shows your Aadhaar.
Yes.
Let's put. What up, sir? Let's go.
My lordship, there is a 59 days delay. Petitioner, appellant hearing.
Family court, Bangalore, response is served. Please.
A date may be fixed.
This is the copy of her Aadhaar card. There is a copy of the. She seeks time.
A date may.
Please, a copy of the appeal memo and.
Yes, two
Yes, sir.
eyes.
Check whether there is appeal memo and judgment copy. What is that IA? How much? IA for?
I one is
Authorization
for
of-
the interim custody, that is during vacation, half of the vacation. That is summer vacation, half days, it's very.
Granted visitation right.
Thereafter, the,
Correct. Now this visitation arrangement is going on or not?
she doesn't provide. She, whenever the children needs the money for buying cycle, full school fee, then they will.
Correct. You say it is not being, we'll
She is
record
not
that
providing,
itself.
she is not providing. Listen to them.
This you have to follow.
Yes, ma'am. They're following, they're communicating also, and I have no issue with that. No issue at all.
But my
They just
thing is, now I am bearing, paying them the
Officers
maintenance.
I will hear you later because first there is delay in your appeal. Let her file objections through.
A
your
date may be, any date may be.
Appellant's counsel, sir, the copies are on her. Okay. You should file your objection on the next hearing date.
Yes, ma'am.
As requested by respondent, list on, take her signature on it.
Yes, ma'am.
List on 2 weeks on date.
On the date may.
2 weeks are 26/3.
That's okay.
Signature.
Yes, ma'am. Martha, good.
Till number 6, Ajit Shetty, Bimbadara HM.
TCS, only my photo number.
January. 30th January call.
Call ಮಾಡಿದ್ದಾರೆ. Registration secure the TCRs on telephonic reminder. List after 2 weeks.
Cell number 7, Sudhaji, case Harish.
Appear for the respondent, my lord, in this
Appear
matter.
for appealant. 5 lakhs deposit ಆಗಿದೆ.
Waiting service of notice on respondent.
My lord, I am entering appearance on behalf of the respondent. At the,
261 days delay.
let them serve a copy of the appeal memo, my lord.
Copies are not served.
Notice ಇನ್ನೂ ತಲುಪಿಲ್ಲ, my lord.
They have
Anyway,
taken
now-
steps.
Yes,
let
sir.
them-
ಅದು
Then how did you appear without notice?
ಅಲ್ಲ
No, my lord, we had filed an execution petition, my lord, wherein they had produced the order saying that the proceedings have been stayed as against deposit of 5 lakhs rupees as the only issue involved is regarding the alimony. My lord, the divorce has been granted within January 24. Now, my lord, the lordship has granted interim order of stay of execution proceedings against deposit of 5 lakhs rupees.
They have deposited that.
They have deposited, that's what the intimation is.
So give them the copies. ತಗೊಳ್ಳಿ ಇಸ್ಕೊಂಡು ಒಂದನ್ನೇ.
ಅದಕ್ಕೆ I have been asking, requesting my learned.
Original, I mean, copies they send for the other side.
Correct.
They
That
might
will
have
be-
gone to the.
By post it, we might receive shortly, my lord. But my request, my lord, it's a short point for regarding the alimony, my lord.
Appeared. Correspondent, the question of awaiting the notice does not survive. Okay. He submits the received by him. Appellant's counsel shall serve him a copies. 261 days delay ಆಮೇಲೆ ಹೇಳ್ತೀರಾ?
A delay, I will leave it to your lordship, my lord. I may not, because it's only a question of alimony. I am in need of money. I have a daughter, my lord, 17 years age. I do not have any other source of income. The 15 lakhs has been awarded and last 1 year that has not been paid, my lord.
Yes, what do you say?
At least if they agree for
5
release.
lakhs deposit today. Notice is not received. Only uh, 21/1, my lord, mother is expired.
Considering the reasons assigned to explain the delay of 261 days. the
25.
public appeal is condoned in the interest of justice. I number 1 of 2025 is disposed of accordingly. You, ಅಂದ್ರೆ records ಬರೋದ್ ಬೇಡ್ವಾ? You want to settle it?
My lord, that's up to my learned friend, my lord. Now 5 lakhs is in deposit, my lord. If she
Keep on
agrees for
settling.
release of that money, my lord, at least some.
Next hearing.
You
My-
keep the parties, your party.
My
present.
scene is,
parties-
What he is doing?
my scene is outstation, my lord. Next hearing.
You are not aware of, you don't, you are not acquainted with the facts of this case?
No, my lord.
ಇಲ್ವಾ? You should read the file. ಏನ್ ನಿಮ್ ಪ್ರಕಾರ what is he
Allah,
doing?
15 lakhs alimony has been awarded.
What is he doing? He has challenged that order.
He is gainfully employed. He has lot of immovable property. That is the observations given.
Gainful employment.
Gainful employment, he is
ಅವ್ರಿಗೂ ಗೊತ್ತಿರಲ್ಲ, ಸುಮ್ನೆ ಜೋರಾಗಿ ಹೇಳ್ಬೇಕಷ್ಟೇ.
he is employed in a software company. Present status, I am not aware. 2015 litigation is going on.
Admit call for TCRs.
Lordship may kindly have a short date because only alimony issue is involved.
Records ಆದ್ರೂ ಬರ್ಬೇಕಲ್ಲ.
ಆಗ್ಬೋದು. ಅಲ್ಲ, divorce I have not questioned.
Both shall call for records, both parties shall be present before the court on next hearing date. List down.
24.
No,
24.
because her senior is not there ಅಂತ.
Short date may be given. I am without payment also, my lord.
Records ಬರ್ಬೇಕು.
ಆಗ್ಲಿ ಬರ್ಲಿ sir.
There is a 5 lakhs release ಮಾಡೋದಕ್ಕೆ order
Adi,
ಮಾಡ್ತೀವಿ.
if my learned friend agrees, let there be an order to that effect, my lord. That will at least
Because
give me
if
some.
15 lakhs, daughter's maintenance is not awarded.
No, it's consideration is daughter's education also. 15 lakhs award mado. Para 53, my lord. Para 53 of the
This
judgment.
15 lakhs includes the daughter's.
That's what the court has said, my lord. She has to take care of the education of the daughter. Therefore, 15 lakhs is reasonable.
My lord, next year release money. Please.
Madam, it is his child's maintenance. Out of 15 lakhs, we have ordered to deposit only 5 lakhs. That is one third of the amount awarded. You admit the relationship, then if not for her, for child, he has to pay. Why, your senior could have appeared virtually also. We'll deposit, clerk response submits that. A delay consideration on learn counsel for the applicant seeks time. Learn counsel for the response submits that child's maintenance is also not paid. Therefore, the amount deposited may be released to the respondent. After I admit call for TCR's trial court, executing court. It is deposited for executing court. Where you had order?
In the High Court, ma'am.
High Court.
Registry of the High Court.
Registry shall digitally release the amount in deposit to the respondent and furnishing the required records. Okay, list on.
24/4.
Grateful.
Hearing on IS, seal number 8, Jaikar Shetty H.
For the cross subject.
Same set I have filed today, my lord.
Notice hogilva in cross.
The case of death, my lord, I have not received. There is a conditional order to deposit. At least I may be,
Madhulu, you serve the copies on him. Your cross subsection copies.
please.
Yeah, filed cross subsection in 2018 copies are not yet served on him.
No, I have not received, my lord.
ಇಲ್ಲ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿಲ್ವಲ್ಲ ಇವ್ರು ಅದಕ್ಕೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಿಫೋರ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ನಿಮ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಏನಿಲ್ಲ. ಹೌದು, ಬಟ್ ದರ್ ಇಸ್ ನೋ ಸಿಗ್ನೇಚರ್ ಆಫ್ ಎನಿ ಅಡ್ವೊಕೇಟ್ ಆನ್ ದಿಸ್. ರಿಸೀವ್ಡ್ ಅಂತ ಯಾರ್ದು ಇಲ್ಲ. ಇಲ್ಲೊಂದು ಅದು ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಟ್ ಫ್ರೆಶ್ ಕಿಟ್.
I will serve, my lord.
ನಾನು ಕನ್ಸಿಡರ್
And I have
no notice is also ordered to the other respondents.
filed second set, my lord,
One ನಿಮಿಷ.
today.
Liability is not challenged, my lord, only,
Then you file a memo at least to dispensation of notice to them.
please.
He appears only for respond number 2. Kodi memo kodi learn counsel for respond number 2 submits that the copies are not served on him. Appellant's counsel, cross objectors counsel shall serve the copies on counsel for respond number 2. Counsel for respond number cross objector submits memo for dispensation of notice to respond number 1. Liability is not questioned, only
No.
Not watch.
Only on quantum, my lord.
under the.
And second set I have
Ex
filed.
parte also, the records show that respond number 1 had not contested the matter before the tribunal. Under the included order, liability to pay compensation is fastened against respondent number 2. 1 and 2 are jointly and liable ಅಂತ ಮಾಡಿದ್ದಾರೆ.
In the meanwhile, my lord, at least deposited amount may be ordered to be withdrawn.
ಇಲ್ಲಿ ಹಾಗಿಲ್ವಲ್ಲ, ಬೋತ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 and 2 ಹ್ಯಾವ್ ಟು ಡೆಪಾಸಿಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದು ಬೇಡ.
ಅಲ್ಲ, ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೇ ಕೊಡೋ.
Not that trial court's order. What is the matter before that tribunal? ಅದಾದ್ಮೇಲೆ insurance liability to pay the compensation is not under dispute. But third, accepting the reasons assigned to explain the delay of 15 days in filing the cross objection is condoned in the interest of justice. Records ಇನ್ನು ಯಾವ್ದ್ರಲ್ಲೂ ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
Connected matter.
ಅದು ಅಂದ್ರೆ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದಿತ್ತ
ಅದು ಸಿಂಗಲ್ ಇತ್ತು,
Second set.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿದಾರೆ.
No, no, if records are not summoned, called at least in our cross objection, we can call for the records. ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ. ಇನ್ನು admit ಆಗಿಲ್ಲ.
ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ.
Second set.
ಅಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಬಿಡ್ಬೋದು, ಓನ್ಲಿ ಲೈಬಿಲಿಟಿ ಏನು?
Notional income or is it a case of notional income or any concrete?
Only 9,000 has been taken, my lord.
And
On
two
the bill.
grounds, my lord. He is not entitled under the loss of estate. 50,000 has been awarded. And another head, my lord, loss of low and head of loss of low and protection, 1 lakh has been awarded.
There are two claimants, alva. How they are related?
Son and wife, my
Wife.
please. Check, my lord, the
Kindly have it on any day, my lord.
9,000, my lord, on the
Loss of dependency, loss of estate 50,000, ಅದು 50,000 ಬರೋದಿಲ್ಲ, 15,000 now as per the
Loss of
structured
consortium, 1 lakh has been awarded.
consortium, ಅದು 88,000 ಬರುತ್ತೆ.
Loss of low and protection also awarded as per the
But
judgment of
15
Supreme Court.
expenses, funeral expenses and ಇನ್ನೊಂದು ಯಾವ್ದು ಬರುತ್ತೆ ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಅಷ್ಟರ ಮಟ್ಟಿಗೆ ಎಷ್ಟು ಲೋಕ ಅದಾಲತಿಗೆ ಹೋಗ್ತೀರಾ? ಕ್ಯಾನ್ ಬಿ ಸೆಟಲ್ಡ್ ಇನ್ ಲೋಕ ಅದಾಲತ್.
Can be, but they
ವಾಟ್ ಇಸ್ ಇಯರ್
now, my lord, is in
2016
badly in need of money, my lord. Nothing has been.
500 ಇತ್ತು ಅವಾಗ ಇನ್ಕಮ್ 9000 ತಗೊಂಡಿದ್ದಾರ.
How?
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
Future prospect ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿಲ್ಲ.
ಸೆಟಲ್ ಮಾಡ್ತೀರಿ ಅಂದ್ರೆ ರೆಫರ್ ಮಾಡ್ತೀವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಬಿಕಾಸ್ ದಿಸ್ ಆಲ್ ಸೆಟಲ್ ಲಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ 8.1 ಇದರಲ್ಲಿ ಕಾಲ್ ಫಾರ್ TCS
Petition only number
8.1 at request 2 weeks time is granted to submit the second set.
In the meanwhile, my lord, 50%, my lord, because liability is not challenged. What?
ರಿಲೀಸ್ ಆರ್ಡರ್ ಮಾಡಬಹುದಾ? ವೇರ್ ಇಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್? ಇಲ್ಲ ಏನು ಇಲ್ಲ ಎಲ್ಲ Mr. Shetty, you could have referred it because all these things are
Please,
settled now.
First
ಲೋಕ
time
ಅದಾಲತ್ಗೆ ರೆಫರ್ ಮಾಡಿದ್ರೆ ಮುಗಿದೋಗುತ್ತೆ ನಿಮ್ದೇನೆ ಎರಡು
post ಆಗಿರ್ಲಿಲ್ಲ, ಹಾಗಾಗಿ next
ಮಾಡಿಸ್ಕೊ 2018 ಮ್ಯಾಟ್ರ್. You are ready?
ಮತ್-
All these things are settled now.
yes, yes.
You will get if future
ಅಲ್ಲಿ
prospects.
ತಾವು ಒಂದು ರಿಲೀಸಿಗೆ ಆರ್ಡರ್ ಮಾಡಿ, in the meanwhile we will settle.
You are putting so many conditions for us. Challenge ಅಲ್ಲ ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋಗ್ತೀವಿ
2018.
and list after 2 weeks on it.
Second set also filed, my lord.
You have to file the
Today,
other purpose. 2 weeks ಅಲ್ಲ. Learn counsel for the appellant submits that second set is filed in the registry. Registry shall verify and list on. ನೋಡೋಣ ಅಷ್ಟರಲ್ಲಿ if you want you can file an application.
Please,
let him serve a copy of the crab.
I will serve.
27-3.
27. ಆಮೇಲೆ ಕಳಿಸ್ಬೇಕು. ಅದೇನು ಎಷ್ಟು ಸರಿ ಹೇಳಿ ಕಳ್ಸೋದು? ಯಾರು ಬಂದಿದ್ದಾರೆ? ಜಯಶ್ರೀ ನಿಮ್ಮವರು ತುಂಬಾ ಇರಿಪರಬಲ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಮೆನಿ ಟೈಮ್ಸ್ ಐ ಆಮ್ ಸೀಯಿಂಗ್ ಫಸ್ಟ್ ಸೆಟ್ ನಲ್ಲಿ ಹಾಕಿರೋದಿಲ್ಲ, ಸೈನ್ಡ್ ಆರ್ಡರ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ಐ ಆಮ್ ಸೀಯಿಂಗ್ ಮೆನಿ ಟೈಮ್ಸ್. ಬಟ್ ಅವ್ರಿಗೆಷ್ಟೇ ಹೇಳ್ತಾ ಇದ್ದೆ ಇಷ್ಟು ದಿವಸ, ಇವತ್ತು ಅಷ್ಟೇ. ಈಗ ಹೌದು, ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಅವ್ರಿಗೆ ತಪ್ಪು ಮಾಡೋರ್ಗೆ? ವಾಟ್ ಆರ್ ಡೂಯಿಂಗ್ ಟು? ಈಗ ನಾವು ನಿಮ್ ರಿಜಿಸ್ಟರ್ನ ಕಳ್ಸಿ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕೋವಾಗ ಅದ್ರಲ್ಲಿ ಏನಿತ್ತು ಕಂಪ್ಲೀಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕೋದಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ಈಗ ಅವ್ರ ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರೆ ಆಧಾರ್ ಕಾರ್ಡ್ ಕಳ್ಸಿದ್ದಾರೆ ಅಂತ, ಆಧಾರ್ ಕಾರ್ಡ್ ಅದ್ರಲ್ಲಿ ಹಾಕೋದಿಲ್ಲ. ಫಸ್ಟ್ ಸೆಟ್ ಅಲ್ಲಿ ಕಾಪೀಸ್ ಹಾಕ್ತಾರೆ, ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ಹಾಕಿರೋದ್ರಲ್ಲಿ ಇನ್ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ.
Cell number 9, Manjula Tejasvi, Sharad Gowda GB.
Appearing for the respondent number 1 and 3, your lordship. They have to file amendment cost title, your lordship.
ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ, ಇವತ್ತೇ ಫೈಲ್ ಮಾಡಿ ರೆಡಿ ಇದೆ.
Why do you want time for that? For non-amendment of cost, even amendment is not carried out.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. Fact, your lordship. There are some,
You should have some junior colleagues with you.
yes, one junior colleague was there. Or there are
ಕೂತ್ಕೊಳ್ಳಿ,
some,
ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ ಮೊದಲು.
family issue ಇತ್ತು ಅಂತ ಸ್ವಲ್ಪ ಅವ್ರು ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. I'm searching for another colleague, your lordship.
ಎಷ್ಟು ಜನ ಸಿಗ್ತಾರೆ ಪಾಪ ಫ್ರೆಶರ್ಸ್.
I'm ready to take him. Only ಅಂದ್ರೆ ಅವ್ರು ಆಫೀಸಿಗೆ ಬರಲ್ಲ, ಹಂಗೆ ಹಿಂಗೆ ಏನೋ ಕಂಡೀಷನ್ಸ್ ಹೇಳ್ತಿರ್ತಾರೆ. I should just look into it and then.
ಹಂಗಂದ್ರೆ ನಾವು ಇಲ್ಲಿ ಕಂಡೀಷನ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತೀವಿ ನೋಡಿ. If you do not encourage the youngsters.
ಇಲ್ಲ lordship, I'm for that, to encourage the juniors only. Really amendment application ready.
1 week time is granted to the.
Your lordship, kindly date may be fixed, your lordship. And the withdrawal application is Swami.
List on?
No withdrawal. Your lordship.
ಅವ್ರಿಗೆ ದುಡ್ಡು ಹೋಗಿರೋದಿಲ್ಲ.
Today it's easy. I'll comply to you. In fact, on the other day, I was ready with this application or quota number 6 ಮುಂದೆ ಬಂದಿತ್ತು, ಅದು ಹಂಗಾಗಿ adjourn ಆಗೋಯ್ತು. Otherwise I could have filed it on that date, your lordship.
ರಿಜಿಸ್ಟ್ರಿ ಅಲ್ಲಿ ನಮ್ಗೆ ಹೊಸದೆಲ್ಲ ಹೇಳ್ಕೊಡ್ತೀರಿ. ರಿಜಿಸ್ಟ್ರಿ ಅಲ್ಲಿ ಹೋಗಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೋದಲ್ಲ.
ಕಾಪಿ ಒಂದು ಸರ್ವ್ ಮಾಡಕ್ಕೆ
ಅಮೆಂಡ್ಮೆಂಟ್ ಫಸ್ಟ್
amendment ಇವಾಗಲೇ ಕ್ಯಾರಿ ಆನ್ ಮಾಡ್ತೀನಿ ಸರ್ ನಾನು. Right now I will do it. I may kindly be permitted to carry out that amendment to date. Now it's
no, these insurance company people think that they are unquestionable.
no,
ಹೇಗಿದ್ರು they
definitely
are
not, your lordship.
financially strong. Yes, matter is pending since 2022. They have not received any money. They are the widow and children of the
Yes,
deceased.
ನಾನು
Amendment ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ they
latest
oppose the withdrawal applications in all cases, most of them. And they do not do the needful.
ಅವ್ರು ಡೆತ್ ಆಗಿದ್ದು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದೆ ವೆರಿ ರೀಸೆಂಟ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಇನ್ 2025 ಒಳಗೆ ನಾವು 28 January if I am right, your lordship.
ಹಾಗಾದ್ರೆ ನಾವೀಗ again you want us to go through the
ಇಲ್ಲ,
records,
ಇಲ್ಲ,
how much
ಹಾಗೆ-
time you have taken ಅಂತ ಹೇಳಲ್ಲ.
ಅಲ್ಲ ಈಗ ನಾನು ಅಂದ್ರೆ ಲೇಟೆಸ್ಟ್ ಆಗಿ ಡೆತ್ ಇದಾಗಿ
As a final chance, this time
20th March.
20th.
obliged
24th November 2023, ma'am. Seal number 10.
22 ನಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ ಈಗ. Yes.
Copies of receipt ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
ತಗೊಳ್ಳಿ.
Seal number 10, Dwala Kumar, Syed Akhtar Pasha.
But I appear for respondents claimants word. File an application for release of amount.
My lord. And for the appellant, my lord. Liability is in the
Hmm.
question, my lord.
ನಾವೀಗ ಹೇಳ್ತಾ ಇದ್ವಲ್ಲ ಹಿಂದವ್ರಿಗೆ ಯಾರ್ದೋ ಹೆಂಡತಿ ಮಕ್ಳು ಅಂದ್ರೆ ಮಕ್ಳು ಗಂಡನೋ ಯಾರೋ ಸತ್ತೋಗಿರ್ತಾರೆ ಇವ್ರಿಗೇನು ಕರುಣೆನೇ ಇರೋದಿಲ್ಲ. ನಾವು ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀವಿ. ಮಾಡ್ಲಿ ಬೇಡ ಅನ್ನೋದಿಲ್ಲ, ಮಾಡೋದನ್ನ ಬೇಗ ಮಾಡೋದಿಲ್ಲ. ಇದ್ರಲ್ಲಿ PF ಕೊಡ್ಬೇಕು 2 and 6.
ಕೊಡ್ತೀನಿ 6 ಕೊಡ್ತೀನಿ 2ಗೆ ಅವ್ರು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಬೋದು ಅನ್ಸುತ್ತೆ.
Respond number
Two-
2.
Owner.
ಅಲ್ಲ ಓನರ್ ಅಲ್ಲ ನಿಮ್ಮ ಮಗ.
Respond number 2 is
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಸೆಕೆಂಡ್
he was petitioner number 2.
ಪಿಟಿಷನ್ ನಂಬರ್ 2.
21. They are also all petitioners only.
ಹೌದು
Others
6
2 to
ತಗೋತೀನಿ.
5. You are appearing for only 1 and 3 to 5.
ಅಲ್ಲ 1 to 5 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಐಎನ್ನಲ್ಲಿ.
3 to 5 ಹಾಕಿದ್ದಾರೆ. ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ದ
then I'll pay the price.
ಯು ಕ್ಯಾನ್ ಅದನ್ನೇ ಹೇಳೋದು ಇನ್ಶೂರೆನ್ಸ್
ಗೊತ್ತಾಯ್ತು.
ಮೊದಲೆಲ್ಲ ಪ್ರಿಡಿಕ್ಟ್ ಮಾಡಕ್ ಶುರು ಮಾಡ್ತಾರೆ ಅಂತ. ಯು ಹ್ಯಾವ್ ಮೂವ್ಡ್ ಇಟ್.
ಅವರೇ ಮೂವ್ ಮಾಡಿ.
Is that in dispute here? Why are you
Legally,
disputing the
But
liability?
according to me,
As per the medical records, disease was hit by a two-wheeler. Police records indicate that car was involved in the accident. For that, we have summoned the MLC records and discharge summary. All those things clearly indicate that the pedestrian was hit by a two-wheeler.
Final chance. If you don't take the steps, it will be disputed. That's right. Finally.
But meanwhile, my lord, interim application may be my
But
lord.
he says
Please,
he is
amount.
disputing the involvement of the vehicle.
Allah, really.
ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ ನೀವೇನ?
ಮಾಡಿದ್ರಿ.
ಇಂಟರ್ನಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಸ್ ಮಾಡಿಸಿದೀರಾ?
Charge sheet is laid against my lord the
There's nothing
cab
when
driver.
I have examined the
One and RW2. Who are those witnesses?
medical records summon ಮಾಡಿದ್ದೀನಿ.
Used to certain evidence. That it was finally 2 weeks time granted for the needful. Failing which appeal against respond number 2 and 6 shall stand dismissed. List on 2 weeks.
I'll pay the process today.
28-3.
Much.
Seal number 11, K. Srihari.
Delay of 20 days in filing the claim petition, appeal, my lords. This case of death.
ಇನ್ಶೂರೆನ್ಸ್ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ.
ರಿಲಯನ್ಸ್ ಸೆಂಟ್ರಲ್
ಹೌದು.
ಇನ್ಶೂರೆನ್ಸ್. And ಇನ್ನೊಂದು ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್. 2 vehicles are involved.
ಹೌದು.
ಯಾರು ರಿಲಯನ್ಸ್ ಅವ್ರು ಯಾರಿದ್ದಾರೆ? ಯು ಆರ್ ಫಾರ್ ನ್ಯೂ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಅಲ್ಲ? ನ್ಯೂ ಇಂಡಿಯಾದವರು ಕಿಶೋರ್
Reliance.
ರಿಲಯನ್ಸ್ ನವರೊಬ್ರು.
Reliance, HS Singraju, Malti TN, Ashok and Patil, B. Kirby, B. Vijay Kumar, XC Betsu.
ಇನ್ನೊಬ್ರು ವಿಜಯ್ ಕುಮಾರ್. ಮತ್ತೆ 4 ಯಾರಿದ್ದಾರೆ? ನ್ಯೂ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
India Padmavathu, Pradeep, P. Ravishankar, Manjunath Esri ಅವರು ಇದ್ದಾರೆ.
ಮಂಜುನಾಥ್ ಯಾರು?
ಮಂಜುನಾಥ್ Esri.
ಮಂಜುನಾಥ್ ನೀವು ಇದೀರಂತಲ್ಲ ನ್ಯೂ ಇಂಡಿಯಾಗೆ. ಶ್ರೀ ಪದ್ಮಾವತ್ ಫಾರ್ ರಿಲಯನ್ಸ್
ಅಲ್ಲ, Malti TN for
ಮಾಲ್ತಿ TN, ಶ್ರೀಮತಿ ಮಾಲ್ತಿ TN and ಶ್ರೀಮತಿ ಮಂಜುನಾಥ್ Esri, learned standing counsel for respond number 2 and 5 respectively are requested to accept notice for those response. Appellants counsel shall serve the copies on them and they shall file a wakalat in the registry for the said response. If needful is done, the registry shall show their names in the cause list accordingly. What about other respondents? 1, 3 and 4?
My lords, they are the owners. There is a dispute regarding the ownership of the vehicle.
Agata?
ಅಲ್ಲ ಬೇಕದು. There is a dispute, so notice.
Notice to respond number 1, 3 and
Please.
list on
4, 6.
4, 6. ಇಂಥದ್ದೆಲ್ಲ ಬಾರಿ ಹುಡ್ಕೊಂಡು ಬರೀತಾರೆ. ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಓದಿ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ತಪ್ಪಿದೆ ಅಂತ ಬಿಗಿನಿಂಗ್ ನಲ್ಲೇ ಬರ್ತಾರೆ. If there is error in the award, the appellant is not appellant or appellants are not responsible for the same. Therefore, office note stands deleted. ಅದಾದ್ಮೇಲೆ ಉಳಿದಿಲ್ಲ.
Bill number 12, F.S. Sabali, Shripad
My lord,
Vishal.
I am for respondent in KSRTC appeal and appellant in connected matter. It's a case of death. I filed an application for permission to withdraw the amount deposited by the KSRTC before the tribunal. A case of death, my lord, a wife and two children, minor children and parents are the claimants. Exchange is of the year
It's all
2000.
there in the your application. What Mr. Dabali says, we'll hear him.
Here, madam, we have disputed not the nexus between the injury and death because he died not after lapse of 3 years and 4.5 months because of cardiac arrest.
Just medical expenses ಎಷ್ಟು ಅದ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅದೇನಾದ್ರೂ ಕೊಡ್ಬೋದಲ್ಲ?
ಅದ್ರ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಏನಿಲ್ಲ ಇದು.
Medical expenses 43,000.
43,000 ಇದೆ ಅಷ್ಟೇ.
Miscellaneous expenses 5. Funeral expenses ಅದು ಬರೋದಿಲ್ಲ ಅಂತ ನೀವು. Whom did you examine? You have examined a doctor?
Yes, yes, I examined
but he
CW1.
is not treated. There is chances of cardiac arrest.
Cause of death.
Cardiac arrest. PM report not shows.
Then in their appeal there is delay 161 days. What do you say for that? Connected appeal ಅಲ್ಲಿ 161 days delay ಇದಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿ.
ಅದನ್ನ ಕಂಟ್ರೋಲ್ ಮಾಡು.
ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್. ಏನಿದೆ? CCD ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಏನೋ ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಿಂದ.
Records have been received note.
Why CCD particulars are received from the trial court ಅಂತ ಬರ್ದಿದ್ದಾರೆ? ಎಲ್ಲಿದೆ ಅಂತ? ಅರ್ಕಲ್ಗೂಡು TCRs ಎಲ್ಲ TCRs ಬಂದಿದೆ ತಾನೆ?
TCR ಬಂದಿದೆ.
ಅಲ್ಲ CCD particulars are received ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅವ್ರದ್ರಲ್ಲಿ. ಡೆಪಾಸಿಟ್ ಮಾಡಿದೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಲ್ಲ. We are not called for any particulars of CCD. Why the trial court has sent this message?
An order made by this court, by the His Lordship Malad Justice Shastri. There is an order.
ಯಾವಾಗ beginning ಅಲ್ಲ? All for trial court records.
19-1-124.
19-1.
19-1-124.
Conditions imposed while granting entrance to which was for depositing. Subject to resist ascertaining the correctness of the sales statement. ಹೇಳಿದಲ್ಲ? ಆಲ್ಫಾರ್ ಅಂತ ಮಾಡಿಲ್ಲ, ಇವ್ರು ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಂಡ್ರೆ
learn for the respondents 1 to 5 insist for the release of the amount in deposit. Learn counsel for the appellants submits that the cause of death nexus between the death and the accident is disputed. The TCRs are already received. Therefore, the I-1 of 2024 is referred for consideration. Next, 12.1 ನಲ್ಲಿ heard accepting the reasons. ನೀವು ಒಬ್ಬರೇ ಇರೋದು ಕನೆಕ್ಟ್
ಒಬ್ಬರೇ
considering the reasons. Considering the reasons assigned to extend the delay, delay of 161 days in filing the appeal is found in the interest of justice. I-1 of 2021, 24 is list on 24.
Divorce is granted.
Cruelty both. ಅರ್ಜಿಯನ್ನು ಸದರಿ ಅಧಿನಿಯಮ only 13, one EA is allowed. ಒಂದ್ ಕಡೆ 13 EA ಅಂತಾರೆ, ಒಂದ್ ಕಡೆ 13(1). ಎರಡು ಸಕಾರಾತ್ಮಕವಾಗಿ ಅಂತ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಅಂಡರ್ ಬೋತ್ ದ ಹೆಡ್ಸ್.
Respondent, appellant mother, brother, my lord.
Issue notice to the respondent, interim stay of the.
I ready to join, my lord, rejoin.
Till next hearing date, interim stay till next hearing date, list all.
4-6. Cell number 14, Bharat Yal.
For the appellant in this case, my lord.
My lord, I am for the appellant and senior is out of station. Please have it next week.
You have read the file? You have brought the file?
No, ma'am.
Files? She had contested or not contested? Evidence ಆಗಿದೆ RW 1 to 3. Third, issue notice to the respondent, interim staff, judgment and decree till next hearing date. Tell your senior you should collect the file next hearing onwards and read the file and come here.
Okay.
4-6. Interim stay till next hearing date is granted.
And next date, my lord?
4-6. 4-6. Cell number 15, Mamta Ji Kulkarni, Sushmita Ji.
My lord, for the appellant.
Appear for the
Lord,
court
this
guardian.
thing is for condonation of delay, my lord. I have taken back my the allegations I have made against the advocate I had engaged before the MSCT, which was part of the earlier affidavit, my lord. Now I have filed a fresh affidavit for the same.
You have filed the fresh affidavit?
My lord, the additional affidavit.
Have you said in that you are withdrawing your allegations?
Yes, my lord. I have prayed your lordship to permit me to take back all the allegations made against the advocate on his back.
Just we'll read first affidavit. Additional affidavit. On oath, he makes two types of statements, contrary to each other. On oath, he makes two statements which are contrary to each other. Yes, what do you say for condonation of delay? 61 days.
My lord, it may be condoned with, let the appellant deposit 50% of the award amount, my lord, and respondent be permitted to withdraw the same, my lord, because the father is, he's been deceased and he's the only breadwinner of the family. Minor children are there. Hence, the father has been deceased, my lord. I mean, the father has, he's
Died,
been,
huh?
yes, my lord, in the accident.
Court guardian.
No, my lord, I'll do it, my lord. So two minor children and mother, my lord. So literally there will been put on the streets, my lord. Kindly, the appellant may be,
Then if
My lord,
you-
I have deposited 7 lakh rupees, my lord, with great
then
difficulty.
if we pass order for release, how do you reach them?
I will contact, my lord. I'll find out the number.
Do that, then we'll consider this.
Yes, my lord.
My lord, this is a paradox of poverty, my lord.
But, learned counsel for the, Mr. Registrar has placed the additional affidavit filed by learned counsel for the additional affidavit of the appellant filed by learned counsel for the appellant in support of file number 1 of 2024. The records show that the appellant makes allegations against his counsel who represented him before the tribunal behind his back, and the allegations, unfounded allegations in the matter. And again comes up with some other explanation. Considering the cost conduct of the appellant and the other material on record, it's appropriate to condone the delay. Will impose cost on your client
My lord, he is already poor.
on payment of
Uh,
cost of ₹5,000 payable to the, ನಾವು ನಿಮ್ಗೆ ಕೊಡಿಸ್ತೀವಿ ಏನದು advocates welfare fund payable to advocates welfare fund within 2 weeks.
My lord, even that will have to be borne by me.
Load
That is the situation.
Delay of 161 days is condoned in the interest of justice, subject to appellant paying ₹5,000 as cost to the advocates welfare fund. Okay. IA1 of 2024 is disposed of accordingly.
Kindly,
You take
date may
instruction.
be fixed, my lord.
This on you take
My lord, it
instruction,
may be
right?
disposed today itself, my lord, considering the facts that it doesn't have.
Pay first ₹5,000 cost, your delay is condoned
Along with-
subject to that. List on
1-4.
Yes.
Much obliged, ma'am.
Obliged, my lord.
Cell number 16, FS Tabali.
instead of that, madam, we can argue the main matter so that we'll transmit the amount to the tribunal.
On the next hearing date, I'll do it, my lord.
And if you can contact, then you can call.
Yes, ma'am. Please, ma'am. Much obliged.
Delay.
This is appeal by the corporation on case of death matter mainly made on the ground of negligence on the part of the appeal has been filed.
21,27,000.
Yes, ma'am.
Issue notice to the respondents. Interim stay of the execution of the interim award till next hearing date, subject to appellant depositing 50% same before this court within 6 weeks from the date of this order. 6 weeks on the date.
4-6. Cell number 17, GM Srinivas Reddy.
Plus there is a delay in 93 days, my lord, filing.
93.
Claimant's appeal.
Who is
Only on the ground, my lords, the income has taken, my lords, the tribunal is low. The 2023 accident, my lords, they have taken 14,000. So, but there is a delay, my lords, 93 days.
Only superintendent of police, HCP can be taken, directed to take notice. You know, the Karnataka government insurance. I think for both of them,
Police vehicle accident again.
correct, but for both of them, HCP
Yes, yes,
can.
yes, please.
ನಮಗೆ ಯಾರು ನಮ್ಮ ಆಫೀಸ್ ಕೇರ್ ಬರ್ತಿರ್ತಾರೆ ಹೇಳಿ ಸುಬ್ರಹ್ಮಣ್ಯನ ಮತ್ತೆ ಇಲ್ಲಿ HCP ಯಾರನ್ನು ಅಲಾಟ್ ಅಸೈನೇ ಮಾಡಿಲ್ವಾ ನಮ್ಗೆ ಹಾಗೆ HCP ಶಾಲ್ ಡೈರೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತೀವಿ
Yes, madam, I'll send the
ಆಫೀಸರ್
copies.
HCP is directed to take notice for respond number 1 and 2. He shall file memo of appearance in the registry within 2 weeks. Appellant's counsel shall serve the copies on him. Registry shall show his name in the cause list for response 1 and 2. List after 2 weeks.
Please.
Cell number 18, Shankar HS.
For petition, my lord, appellant lordship, claimant appeal, my lord, case of injury, lordship, there is a 848 days delay.
Just 848 days.
No, my lord, it is a used delay.
Why any of them are minors or why so much delay?
My lord,
ಯಾರು ಇಲ್ಲ minor ಇಲ್ಲ only one.
Hello, one.
Case of injury.
Case of injury.
You know what is the disability?
My lord,
All right. ಯಾರು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಶ್ರೀಕಾಂತ್ ರಾವ್ ಯಾರಿದ್ದೀರಿ
ANR, lordship.
ಯಾರು ಇದ್ದೀರಾ ಇಬ್ಬರೆಲ್ಲ ಒಬ್ರು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇಬ್ರು ಇದ್ದೀರಾ ಯಾರು ತಗೊಳ್ತೀರಿ ನೀವೇ ಡಿಸೈಡ್ ಶ್ರೀ ಯಾರು ಬಿ ಶ್ರೀಕಂಠರಾವ ಎಲ್ ಶ್ರೀಕಂಠರಾವ್ letter standing also correspond to is direct to accept notice
My lord,
correspondent.
in respect of respondent number one, my lord, I am permitted to file, my lord, dispensation memo.
Or copy sir ಮಾಡಿ ಉಳಿದೆಲ್ಲ ಹಾಕೊಂಡ್ರೆ letter counsel for the appellant submits memo for dispensation of notice to respondent number one. ಇದರಲ್ಲಿ liability is against respondent number two, ಅದು ಒಂದು contest ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತೀನಿ. Dispensation. Respondent number one had not contested the matter, same ಅದೆಲ್ಲ ಹಾಕೊಂಡು therefore dispensed with. Or copy sir ಮಾಡಿ because
Please.
there is a
Further.
long day,
Further.
at least after 2 weeks.
Oblige.
Bill number 19, Samarth Prakash.
Of the appellant in this matter, my lord, it's a claimant's appeal, my lord. One of the claimant's appeal facts are such that, my lord,
Hey, your Ostra is changed.
no, my lord, it's a law officer of KSRTC itself.
Yes, it is. Who is the respondent
The
here?
respondent here is one of the claimants, my lord. Actually, the deceased happened to be her brother. I'm
You
seeking,
talk here, na?
I'll explain the facts, my lord. In fact, notice will not be required. Here, there was an award of 40 lakhs that was granted. First, I beg your pardon, my lord, about 53 lakhs compensation was granted to me. I am the sister. So I am seeking that, if your lordship,
Who are all the claimants? Petitioner number one.
my brother's wife,
Children.
children, and subsequent,
Sister.
yes,
uh,
my sister-in-law, my
Nephews.
nephews and nieces. And my father and subsequently all of us are the relations, brother and sisters,
Others 2 or 4 and 5 are
brother
the
and
parents.
sisters.
No, 4 and 5 are the parents claimants.
Please,
You were respond number 6.
6, please, my
Age
lord.
50 years.
Please.
Married daughter.
Please.
And
My lord, I am not, your lordship, just please look at, I had paid certain medical expenses for his treatment. I am only seeking that be reimbursed to me.
nothing is given to you there.
Nothing is given to me there.
Your evidence, what is
At
that?
page number 27, if your lordship could,
Shakuntala, you entered the witness box.
I entered the witness box. I'm PW2.
You had filed statement of objection. Counter
Please,
to-
please, I was sailing with them, my,
List of witnesses none anta ಇದೆಯಲ್ಲ.
ಇಲ್ಲ.
See this judgment annexure.
At page number 31, my lord, I'm PW2.
Petitioner number 4 is examined himself as PW1.
If your lordship could please look at page number 27.
The petitioners have examined so and so. The petitioners have also examined so and so. In order to prove the defense, respondent number 2 did not choose to lead evidence. So petitioner, you were not petitioner number 4. You were petitioner number
6. I'm
Six.
petitioner number 6.
correct. But the ಹೆಸರು ಇಲ್ಲಿ ಕಾಣ್ತಿಲ್ವಲ್ಲ.
Alla, at page number 31, I am PW2, my lord.
ಶ್ರೀರಂಗ ಶ್ರೀಮತಿ ಶಕುಂತಲಾ, you are right.
So I have, in fact, I led evidence as PW2 and subsequently produced my bank statement also, indicating that I have made payments, which was marked as exhibit P6.
P6. Your family members are not ready to give that to you?
No, they are not, we are not in talking terms, my lord.
Your parents?
Nobody is agreed. So that is why I'm before this court seeking that 6 lakhs.
They are alive, no parents.
Parents, please, my lord.
Some amount is ordered to be paid to them also.
Yes, please, my lord. About 10%.
2 and 3 are the children, 15.
10%.
10%.
10%.
Oh, nothing was allotted to mother died by.
Please, mother passed away, my lord.
Notice ಬೇಡ ಅಂತ ಹೇಳ್ತೀರಿ, notice ಕೊಡದೆ.
Notice only to respondent number 1 to 4.
For dispensation.
I'll file, my lord.
Whom you are seeking?
5 to 10 may be dispensed with. Because I'm not seeking that the compensation be enhanced. I'm only seeking that the amount that was granted for medical expenses, which is an amount of rupees 6,60,000.
Respond number 5 to?
5 to 10, my lord.
Father died or mother died?
Mother died, my lord.
ಮತ್ತೆ ಇಲ್ಲಿ ಕೃಷ್ಣಮ್ಮ ಅಂತ ತೋರಿಸಿದಿರ ಹೆಸರು?
Krishnamma, Srimati.
Correct. 4 ಶ್ರೀರಂಗಪ್ಪ and 5 is Krishnamma.
Krishnamma who passed away.
Dead ಅಂತಿದ್ರೆ hospital ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಾ? You have made her also a
I
party.
made her also, yes.
But
the legal heirs are already on record. That is.
correct. But you should mention that
Yes, my lord.
the order of the trial court also does not indicate ಇಲ್ಲ ಅದು. But only in apportionment ನಲ್ಲಿ died ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
Please.
Respond number 5 is dead ಅಂತ ತೋರಿಸ್ತಾರೆ.
They did not show it in the cost title also.
Father is alive, mother is dead.
Mother is dead, please, my lord.
Correct. You should mention it in the cost title.
I'll make a mention.
Now counsel for the appellant submits that respondent number 5 is no more. She died pending the proceedings before the tribunal. He shall amend the cost, I'm sorry, and she is survived by the other claimants slash appellants slash respondents. He is permitted to amend the appeal memo and furnish the copy of the amended appeal memo accordingly. Further, he submits memo for dispensation of notice to respond number 4 and
6 to 10, my lord.
6 to 10. 6 to 10. Okay. As no relief is sought against them in the appeal. Prayer in what is your prayer in the
Set aside as far as award me medical expenses.
set aside and modify? No relief is sought against the said response. Notice those responses dispensed with as paid for. Iವ್ರಿಗಾದ್ರೂ ಹೋಗ್ಬೇಕಲ್ಲ notice. Notice has to go to these.
Notice has to go, my lord. My lord, they're seeking that the amount has been deposited. Now they are seeking that
much
amount be
is-
withdrawn. Amount of 6,60,000, that is stayed. It would be sufficient, my lord.
Is there any appeal pending?
No, my lord, they have not filed any appeal, my lord.
Total amount is 53,28,000.
Please, my lord.
But the medical expenses ಕೊಟ್ಟಿರೋದು ಕಡಿಮೆ ಅಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ
6,60,500, my lord. At page number 28.
28. 6,60,500.
Oh, please.
Issue notice to response 1 to 3. 1 to 3. Interim stay for release of a sum of 6,60,500 to claimants 1 to 4. ಫಾದರ್ದು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಹಂಗಂದ್ರೆ
Please, my lord.
ಫಾದರ್ದನ್ನು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ?
Because we don't know how they apportion that amount. So 6 lakhs.
ಫೈಲ್ ನೋಡಿಲ್ವಾ ನೀವು?
Please, my lord.
ಫೈಲ್ ನೋಡಿಲ್ವಾ ಅಂತ?
Allah, father has got 10%. But
ಫಾದರ್ದು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ ಈಗ?
how, please, it will be
They are
better.
not selling with your father also?
No, they're not sharing it with me. That's the thing. 6,60,000, if that amount is stayed, that's enough.
He was aged 80 years. Why is she?
Please, my lord, then I'll apportion it from.
ಆಯ್ತು 1 to 4 ಇದ್ರೆ ಬರ್ತಾರೆ. 1 to 6,60,000. 1 to 4 till next hearing date. Based on 4/6.
Much obliged.
20, Pawan Chandra Shetty.
Advocate for appellant, my lord. My lord, liability fastened against the insurance company, respondent number 2, my lord. Respondent number 1 placed ex parte. I'm filing a dispensation, ma'am.
Counsel for the appellant submits memo for dispensation of notice to respond number 1. ಇದರಲ್ಲಿ 1 is ex parte as well as liabilities against the insurer. What about who is respond number 2?
Magma HDI General Insurance.
Magma ಯಾರಾದ್ರೂ ಇದಾರೆ?
Magma Pradeep Shivanegowda, Jane Krishnaswamy.
ಹೌದಾ? ಪ್ರದೀಪ್ ಕೊಲಿಗುನು ಯಾರು ಇಲ್ಲ ಇನ್ನೊಬ್ರು SBI ಅಗ್ರಿಮೆಂಟ್ ಮುಳ್ಕೊಂಡೇ ಎಲ್ಲಿ ಕಾಣ್ತಾರೆ ಇನ್ನೊಬ್ರು ಯಾರು SBI ಅಗ್ರಿಮೆಂಟ್
B Pradeep BC Shivanegowda, Jane Krishnaswamy.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಬಿ ಪ್ರದೀಪ್ ಅಷ್ಟೇ ಬಿ ಪ್ರದೀಪ್ ಲರ್ನ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕರೆಸ್ಪಾಂಡ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಆಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಕರೆಸ್ಪಾಂಡ್ ಆಗ್ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಂಡ್ಬಿಡಿ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ ಸರಿ ಡಿಲೇ ಇದೆ ಅಲ್ಲ ಆಫೀಸರು ಮಾಡಿ
55
ಡಿಲೇ
days.
ಇದೆ 55 days 55 days
55 days delay, ma'am.
list of the 2 weeks
Please, ma'am. Much obliged, ma'am.
Seal number 21, Hemant R. Rao.
My lords, this is my lords. There's a connected matter, my lords.
which is that connected matter
My lords, it's not been listed today. It's
Filed
a
by
fresh matter.
public?
Yes, ma'am.
you should tell us when the case was called
It's a connected matter, my lords, and let it be posted together, my lord.
appellant submits that correct so and so
In that they have produced, they have filed wakalat also in that matter. my lord. The
list
respondent-
both the matters together
20.
any date is given in that case
No, my lords, this is the first matter.
together
My lords, tomorrow or day after tomorrow.
20th 20th not
Admission.
tomorrow day after tomorrow
Number 22, D. Vijay Kumar, Shruti SP for
My lord, I am for the appellant, my lord.
My lordship, in this matter, last occasion in this honorable court is directed to release the amount, but amount is deposited before this honorable court. Directed the tribunal to release the amount. So hence, direction.
Plus, no?
Yes, my
50% of 50% to be deposited.
ಅದು ಅಮೌಂಟ್ ಇಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿ ಇದೆ, ಅಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ LCR ಅಲ್ಲೇ ಇದೆ, LCR ವಾಪಸ್ ಬಂದಿಲ್ಲ.
Correct. Last time when the order was being passed, you should have told us that.
They are also confused.
Just see.
They are non-filing of paper book and it is by mistake, I think. By mistake, they have officers mentioned it as a non-filing of paper book.
No, 25 lakhs, 25,000 plus 6 lakh. 6 lakhs 25,000. How much? 62 lakhs.
Yes, my lord. Other 50% is to be ordered to be released. Because you have totally denied the negligence and also quantum of compensation.
Both counsel submit that on the amount is deposited before this court and on date of order is on
26.
28/1/2025, my lordship.
Under mistaken impression that the vehicle amount is deposited before the tribunal. The order was passed directing the tribunal to pay the deposit, release the amount. On verification of the records, it is found that the amount is deposited before this court. Therefore, registry is hereby directed to digitally release 50% of the amount in deposit.
50% of 50%.
In the ratio of 70% to claimant number 1 and 30% to claimant number 2, and furnishing required documents subject to result of this appeal. Okay. The order is order dated 28/1/2025 should modified accordingly. Records. ಇದನ್ನು ಹೋಗಿಲ್ವಾ TCS ಗೆ ರಿಕ್ವೆಷನ್ ಹೋಗಿಲ್ವಾ?
ಅಲ್ಲೇ ಇದೆ my lordship, ವಾಪಸ್ ಬಂದಿಲ್ಲ.
ರಿಕ್ವೆಷನ್ ಕಳಿಸಿಲ್ವಾ ಇವರು? Registration secure the TCS and telephonic reminder list.
Let it be clear, my lord, 50% of 50%.
ನೀವು ಕೇಳ್ಬೇಕಲ್ಲ ನಾವು ಹೇಳೋವಾಗ.
ಸಾರಿ ಅಲ್ಲ, ಅದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಕನ್ಫ್ಯೂಸ್ ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ. ಯಾಕೆಂದ್ರೆ ಸ್ಯಾಲರಿನೂ ಡಬಲ್
ಅಟೆಂಟಿವ್ ಇದ್ರೆ ಇರುತ್ತೆ, ನೀವೇ ಮಾತಾಡ್ತಾ ಇದ್ರೆ ಹೇಗೆ ಕೇಳುತ್ತೆ ಹೇಳಿ. ಎಷ್ಟು ಪೇಪರ್ ಬುಕ್ ಹಾಕೋದಕ್ಕೆ ಯಾಕೆ ಆರ್ಡರ್ ಆಗಿತ್ತು?
ಅದೇನೋ ಬೈ ಮಿಸ್ಟೇಕ್ ಎಲ್ಲೂ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
Return the TCS to the tribunal to facilitate.
ಆತರ ಆರ್ಡರ್ ಏನಿಲ್ಲ.
ಇದು ಮೊದಲು ರಿಲೀಸ್ ಮಾಡೋದಕ್ಕೆ ಅಪೋಸ್ ಮಾಡಿರೋದು. Now counsel for the appellant is appearing through video conference and respondent is physically present. 10 days time is granted to the learner counsel for the appellant to paper book containing copies of claim, petition, statement of objection and deposition exhibits. Order was passed on 31/2024. Since the TCS themselves are called for filing of the papers, book is dispensed with. List all. Previous order ಏನಿತ್ತು ಅದನ್ನೇ reiterate ಮಾಡಿದೀವಿ.
That I think it is not necessary. I don't know, ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಸ್ ಆಗಿದೆ ಅದು. It is not required. Anyway, records are there. Records are there.
28.
Kindly recall that order, my lord.
ಎಲ್ಲ ಮುಗಿದೋಯ್ತು, ನೀವು ಕೇಳಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಹೇಳೋದು. We do not know you do it deliberately or inadvertently.
ಏನೋ ಒಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ನಮ್ ಕಡೆಯಿಂದ.
We said we only checked the records and dispensed with the paper books. You do not listen to us at all.
ಅಲ್ಲ ನಾನು ಕೇಳೋ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ ಅದ್ರಲ್ಲಿ. I don't know how the order came to be passed. Because why should I?
Counsel, ನಾವು ಪೇಪರ್ ಬುಕ್ ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಮಾಡಿದ್ವಿ, ಅದನ್ನೆಲ್ಲ ನೋಟಿಸ್ ಮಾಡಿ ಅಂತ. You are not hearing us. After passing the orders, you keep on talking.
Please, man. Sorry.
Number 23.
But you have to correct it at one point of time. Day in and day out.
That is why I'm telling you, I'm sorry.
Next question.
My lord,
I am appearing for the petitioner, my lord.
Yes,
arising out of a GNWC, my lord, kindly we see page number 24. And prayer is at page number 30, my lords. Lordship got it.
yes.
I have no objection to grant the custody of the child. But somehow, my lord, without taking note of all these things, maintenance and some medical expenses
the
been
final order?
awarded.
He had filed two memos, my lord, in the
Allah,
GNWC
memos,
petition,
my lord.
saying that
One second. Order
in page
challenge
15,
is
sir, in page 15, sir,
GNWC 30 of 2017. We'll call for the
para
records.
2, sir, para 2.
15/4/2023.
Kindly, my lord, what happened? The petitioner has
Where is the
played a
final
fraud.
order?
In page 15, sir.
Petitioner
Sir,
has
counsel, where is the final order?
In
Show
page
us.
15, sir.
final order
In
is
page
at 15, my
order
lord.
sheet.
15.
In page 15, sir.
15.
Para 2
15
only.
is the order.
He had filed two memos, sir, allow madadike petition.
ಪಿಟಿಷನ್ ಅಲೋ ಮಾಡೋದಕ್ಕೆ ಗಾರ್ಡಿಯನ್ಶಿಪ್ ನ ಅಲೋ ಮಾಡೋದಕ್ಕೆ ಹೇಳಿದೀವಿ. ಮೇಂಟೆನೆನ್ಸ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಲ್ಲಿದೆ?
Copy is at page number?
24. Prayer is at page number 30.
GNWC. ಹಾಕಿದ್ದ.
IA4, an application was filed.
Yes, ma'am.
For stay, my lord.
Maintenance.
Litigation expense of rupees 30,000.
Alternately, holy.
Had filed the application under which provision?
Filed a provision
provision?
under
ಯಾವ
GNWC
provision ಹಾಕೊಂಡಿದ್ವಿ?
7.
We are asking you one question. The application was filed under which provision ಅಂತ?
23(2) and 20.
ಅದನ್ನ ಹೇಳ್ತಾ ಇರ್ತೀರಾ?
Application filed under section
Application
7,
copy
17 and
is at
25 of the and section 10 of the GNWC Act, my lord.
Okay. Yes, ma'am. Guardians and wards. 25 power ಇದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ ಮಾಡೋದಕ್ಕೆ. Section 25 ತೆಗೆದುಕೊಳ್ಳಿ.
Yeah, provision, you know.
So assets and life statement for us.
He did not contest the matters.
My lord,
No,
what
application-
happened in this case, my
Only he
lord,
has filed
respondent,
objection and filed
Allah.
two memo
They
to
are
allow the
trying to
petition.
see what is the objection or in objection.
Objection ಹಾಕಿಲ್ಲ.
This child medical condition were any disputed?
ಹೌದು sir.
my lord,
That
total
he said
bill
that operation
were
is not
produced
taken place.
before the trial court itself is 37,599.
Whether objections to the application was filed? Where is that objection in the appeal memo? They had filed objections to IA4?
No, sir. He has not filed objections.
Had you
Allah,
filed the
what
objection?
happened, my lord? The respondent being an advocate, the petitioner was misled by his own advocate, my lord, and got memo signed.
Sorry.
And we don't know, my lord, how the memos are came to be filed.
What action you have taken against the said advocate?
Allah, my lord,
If we had betrayed the trust of the party, what action you have taken?
Allah, my lord, being an advocate, my lord, we are under an impression that, my lord, something it is a fraud has been played to the petitioner.
So you are suspecting, not your
Appellant.
client. You are
Allah, my
suspecting-
client itself, my lord, it is an
Correct, if that is
instruction.
the case. See, your client cannot make allegations
Allah,
against
because
a-
he is not even aware
against-
of the order which is
against
passed.
against a professional behind his back. If he makes allegation, he should be responsible. There should be some material to show that he has taken some action. Where
Allah,
have you
because
stated-
he has got signed the memo and filed it before the court, my
where
lord.
have you stated in the appeal memo that your advocate has cheated you?
Huh?
Where have you stated in your appeal memo that your advocate has cheated you? Have they taken up that contention?
No, no, madam.
No, my lord, no such contention is raised. No such
Mr.
contention has been
Counsel,
raised.
Then how can you urge those contentions in your arguments?
La, my lord,
You are not a
looking to the
freelancer,
face
you are
of
a
the order.
responsible court of Mr.
I'm
Counsel,
aware
not
of
a
that, my
freelancer.
lord. I'm
You
aware
are a
of that,
court
my lord.
officer.
Yes, my lord, I am
Huh.
aware of that court
If you are
officer.
aware, then why are you making such irresponsible statements?
Allah, my lord, looking at the face of the order itself, my lord, an inference can be drawn. My lord, petitioner is only an AC mechanic, my lord. And respondent is an advocate, practicing advocate.
Unless law provides, we cannot draw any
Allah, that
inference.
is true, my lord. And there is no record as such to show that there is a that much medical expenses has been spent.
Application number 710.
Application under
710.
section 23(2) and 20 of the Protection of Women and Domestic Violence Act. of-
DV Act ಇಲ್ಲೇ ಬರುತ್ತೆ. Your application was under section 710 ಅಂತ ಎಷ್ಟು ಹೇಳುತ್ತೆ.
ಹೌದು sir.
ಹೌದು.
ಏನು ಈ ತರ it should not be.
On 6/9/2018, I had filed the application.
There is mention in the order ಯಾವ provision ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ ಅಂತ 7.
ಇಲ್ಲ, provision mention ಮಾಡಿದೆ.
ಅಲ್ಲ section 7 ಎಲ್ಲ ಹೇಳಿ IA4
With section 7 of the Family Courts Act.
section 7 of the Family Courts Act. Family Courts Act ಇರ್ಲಿಕ್ಕಿಲ್ಲ ನೋಡಿ G&W Act ಇದೆ.
G&W is in ಹಾಕಿರೋದು.
You have the copy of the application, please. ಕೊಡಿ ಅದನ್ನ.
24.
and 20 of your people also do the same thing, no?
ನಾನು
Your counterpart.
yes, madam. Yes, madam. I'm really sorry.
How can they invoke 23 and 23, 2 and 20 there?
La,
Anyway,
ever-
it seems there is a provision, even parties are Hindus, no?
Yes, madam. Yes, madam.
Parties. Petition was for, petition,
He
original.
was
petition-
thrown out of the house in 2017.
Original
madam.
petition was under section?
16. Section 7, 1725 read with section 10 of the Guardians and Wards.
ಇದು ಬರೋದಿಲ್ಲ, ಇದು ಎರಡು ಬರೋದಿಲ್ಲ, ಕೊಟ್ಬಿಡಿ. Original petition was under section 7, 17 and 20. So now how much is awarded?
My lord, the medical expenses 8 lakhs And 30,000, my lord, I am an AC mechanic. Even there is no income proof.
Correct. You did not dispute the medical condition of the child. You only said you have not filed objections.
Allah, my lord, kindly look into what is my status. I had no income.
But and then what is your responsibility towards your child?
Allah,
You do
that
not
is true,
dispute
my
the
lord.
paternity.
Allah, the total medical bill which is produced, my lord, during the course of the evidence itself is 38,000, my lord. That was not.
There is delay also 64 days. What do you say?
64 days it is condoned, my lord.
It was condoned.
Condoned.
It was condoned.
The child has gone the heart operations. The whole it to heart ಅಲ್ಲಿ 24 mm.
Allah, 38,000 ರೂಪಾಯಿ ಬಿಲ್ ಇದೆ ಕೆಳಗಿನ
Along with
ಕೋರ್ಟ್
the
ಒಳಗೆ.
application, I had produced the documents.
Yeah.
What were the documents produced by you? How
Trial
he
court
says
ಅಲ್ಲಿ.
you
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
records-
38,000
because we
ರೂಪಾಯಿ
don't
ಬಿಲ್
have the
ಕೊಟ್ಟಿದ್ದಾರೆ.
records.
We have taken the
We don't
certificate.
have the records with us here.
ಅಲ್ಲಲ್ಲ.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ ಹಾಕಿದ್ರ
ಇಲ್ಲ ಅವ್ರು ಹಾಕಿಲ್ಲ.
ನೀವು
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
IA4 ಹಾಕಿದ್ರಲ್ಲ ಕೊಡಿ ನೋಡಿ.
ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್ ಇದೆ.
ಕೊಡಿ
37,000
ಆಗಿತ್ತು.
37,550.
medical report.
ಹಾ.
What was exhibit P3 is at page number. ಇದ್ರಲ್ಲಿ ಇದೆ ಅದು exhibit.
ಎಲ್ಲ ರಿಸಿಪ್ಟ್ಸ್ ಎಲ್ಲ ಇದೆ.
ರಿಸಿಪ್ಟ್ ಅಲ್ಲ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ exhibit P3 ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಹಾಕಿದ್ದೀರಿ. ಎಲ್ಲ ಡೆಂಗ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಒಂದು ಆರ್ಡರ್ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತು ನಮ್ಮ ಡೆಪಾಸಿಟ್ ಸಕ್ಸಸ್ಫುಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಅಂತ ಇದೆ. ಕೇಸ್ ರೆಕಾರ್ಡ್ we are not able to find it here. Really, very voluminous. ಅದ್ಯಾವುದು ಪರ್ಟಿಕ್ಯುಲರ್ ಅದನ್ನು ತೆಗೆದು wanted to see whether that was subsequent to filing.
No, sir. Before filing
For
of the-
filing of the petition.
Before 2017, the operation took place.
ಅದ್ರಲ್ಲಿ ಹಾಕ್ಕೊಡಿ ನೀವು.
ಹಾಕ್ಬಿಟ್ಟು ಇದ್ರಲ್ಲಿ ಮಗುನ ತಗೊಂಡು ಅದಾದ್ಮೇಲೆ ಆಪರೇಷನ್ ಆಗಿರೋದು.
ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ ತಾನೇ ಅಲ್ಲಿ. You should not come in the row if you have to argue. Heard. Heard both sides. No matter request detailed consideration, admit, call for TCRs, interim stay of the impugned order, subject to appellant depositing, what is that order?
Exhibit silver, exhibit P3.
ಇಲ್ಲಿ ಬರೀ 80% ಆಫ್ ದ ಟೋಟಲ್ ಎಕ್ಸ್ಪೆಂಡಿಚರ್ ಅಂತ ಮಾಡಿದಾರ. ಅಮೌಂಟ್ ಹೇಳಿಲ್ವಾ?
ಇಲ್ಲ ಹೇಳಿಲ್ಲ. ಕೋರ್ಟ್ ಬರ್ಲೇ ಇಲ್ಲ. ಕೋರ್ಟ್ ಬರ್ಲಿಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಲಿಲ್ಲ, ನಮ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿಲ್ಲ.
ಅಲ್ಲಿ ಡಿಪೋಷನ್ ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ. ಅಂದ್ರೆ ಒಂದು ಹಾರ್ಟ್ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು ಅನ್ನೋದನ್ನ ಒಪ್ಕೊಳ್ತಾರೆ. ಕರೆಕ್ಟ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಸೇಸ್ 80% ಆಫ್ ದ ಟೋಟಲ್ ಎಕ್ಸ್ಪೆಂಡಿಚರ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಷ್ಟಿತ್ತು ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. ಯು ಹ್ಯಾಡ್ ಮೆನ್ಷನ್ಡ್ ಇಟ್, ದಟ್ಸ್ ವೈ ವಿ ಆರ್ ಆಸ್ಕಿಂಗ್ ಯು.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಮಗು ಬೇಡ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ನಾವಿಷ್ಟೆಲ್ಲ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಮಾಡಿದ್ವಿ ಮಗುಗೆ. ಈ ಹ್ಯಾಸ್ ಅಂಡರ್ಗಾನ್ ಆಪರೇಷನ್, ನಾನು 8 ಲಕ್ಷ ಖರ್ಚು ಮಾಡಿದ್ದೆ ಅಂತ ನಾನು ಹೇಳಿದ್ದೆ. ಆಮೇಲೆ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ. ವೇರ್ ದಿ ಆಪರೇಷನ್ ಹಸ್ ಟುಕ್ ಪ್ಲೇಸ್ ಇನ್ ದಿ ಮಹಾವೀರ್ ಜೈನ್ ಹಾಸ್ಪಿಟಲ್.
ಎಲ್ಲಿ? ಯಾವ?
ಬೆಂಗಳೂರು ಇಲ್ಲೇ ವಸಂತ ನಗರದಲ್ಲಿ.
ಕರೆಕ್ಟ್.
ಅದು ಹೋಲ್ ಇತ್ತು, 24 mm ಹೋಲ್ ಇತ್ತು ಮಗುಗೆ ಹಾರ್ಟ್ ಅಲ್ಲಿ.
ಕರೆಕ್ಟ್. ನಿಮ್ ಪ್ರಕಾರ ವಾಟ್ ಇಸ್ ದ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಇನ್ಕರ್ಡ್ 8 lakhs ಅಂತ?
She has incurred 7 to 8 lakhs ಅವತ್ತಿನ ಕಾಲಕ್ಕೆ. And not even a single pie has been paid.
Surgery had taken place
2017.
2017. ಅದೇನೋ ಒಂದು ಎಕ್ಸಿಬಿಟ್ P4 ಅಂತ ಡಿಪೋಷನ್ ಅಲ್ಲಿ ಇದೆ. ಅದೇನಂತ ಅದ್ರ ಕಾಪಿ ಯಾವ್ದಂತ ತೆಗೆದು ಕೊಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ನೀವೇ
Total medical bill, my lord, according to me, it is produced, my lord, along with exhibit P3. is
medical report ಅಂತ ಇದೆ.
38,000 around.
All right, you tell us how much is required for a heart surgery.
Allah, my lord, Mahavir Jain Hospital is a free hospital for child.
Give
A
evidence
free
ಮಾಡಿಲ್ಲ
surgery
ನೀವು.
has been,
You did not file objections to IA4. You did not lead evidence.
Allah, that is true, my lord, that is the
Cross examination
fate.
ಮಾಡಿಲ್ಲ.
Allah, that is the fate, my lord, and 30,000 has been awarded even without there being a prayer.
ಸಿಂಗಲ್ MP ಅವರ ಎಜುಕೇಶನಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಆಗ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಇವತ್ತು.
But ಇದರಲ್ಲಿ this is about the child was born with a defect itself.
ಹೌದು. ನಾವು ಮಗುನ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಪಡ್ಕೊಂಡು
Date of
ಹಾಸ್ಪಿಟಲ್
admission.
ಅಡ್ಮಿಟ್ ಮಾಡಿ ಆಪರೇಷನ್ ಮಾಡಿಸಿದ್ರು.
Date of admission, date of discharge. Date birth ಇಲ್ಲ. ಇದರಲ್ಲೇನು date of admission, date of discharge ಕಾಣ್ತಾ ಇಲ್ವಲ್ರಿ? How long the child was in hospital?
1 month.
1
ಅಲ್ಲ ನಾನು on next date of hearing I'll produce all the records.
80% over 4 ಲಕ್ಷ deposit. Interim still subject on the head work. Subject to the appellant depositing a sum of is 4 lakhs before this court and gone paying maintenance to the child at the rate of rupees 10,000 per month before. Only 4 lakhs before this court is within 4 weeks from the date of this order and gone paying rupees 10,000 per month before 5th of each English calendar month. List after the receipt of
Admission ಇದೆ ಸರ್. ಸ್ಕೂಲ್
on
ಅಡ್ಮಿಷನ್
such, you can file application if you want.
ಇದೆ.
On such deposit, the same the said amount shall be released to the respondent / mother digitally and furnishing required.
My lord, even it can be referred to mediation also.
ಮಾಡ್ತಿದ್ರೆ ಕಳಿಸ್ತೀವಿ ಈಗ ಮೊದಲು ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡಿ 4 lakhs rupees and this thing. At this stage, learned counsel for the appellant submits that matter may be referred to mediation. Let him appear first before us, then we'll refer it to the mediation.
Hakodu.
The party should be present before the court on this before this court on date.
2 weeks.
2 weeks only. Australia ಇದೆಲ್ಲ compliance.
Before.
Allah, 4 weeks has been, time has been granted to deposit me.
All right, after 4 weeks ಹೇಳ್ತೀವಿ.
ಆಗ್ಬೋದು.
16/4.
16.
ಮಚ್ಚು.
Bill number 24, Sachin BS.
Let's I am for the respondent.
For the appellant, my lords.
24 and 24 number.
For having served the counsel. You have received the copies, no?
We have not received the copy.
My lords, I'll give them the copies, my lords.
You have not served the copies?
No.
Yes, my lords.
In 24.1, we are the appellant. And in 24 and 24.2, we are the respondent.
ಆಯ್ತು, ಅದರಲ್ಲಿ ಅವ್ರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಬೇಕು. There is only one respondent in the first matter.
Yes, ma'am.
Counsel shall serve, appellant shall serve the copies on the counsel for the respondent. ಅಲ್ಲ served unrepresented ಅಂತ ಇದೆಯಲ್ಲ, ನೀವು ಯಾರು undertaking there now?
Yes.
Vinod Kumar.
Vinod Kumar.
ಆಗಿದೆ, I'm sorry.
We have filed the wakalat also.
Standard counsel undertakes to appear for the respondent. He is permitted to file the wakalat in the registry within 2 weeks. His name shall be shown in the contest. Accordingly, the appellant's counsel shall serve the copies on him. Copy serve ಮಾಡಿ ಅವ್ರಿಗೆ. Then non-filing of acknowledgement ಅಂತ ಇದೆ. Matter was referred to mediation. What is this mediation? ಈ ಕೇಸಲ್ಲೇ ರೆಫರ್ ಆಗಿತ್ತಾ?
Yes, my lords.
ಸರ್ವಿಸ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಕ್ಕಿಂತ ಮೊದಲು ರೆಫರ್ ಆಗಿತ್ತಾ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ one case was for alimony, my lords. ಅದು 8804 of 2023, my lords. That matter along with this matter ಎಲ್ಲ connect ಆಗಿ it was referred to mediation.
Matter is referred to mediation center. This was on ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ರೆಫರ್ ಆಗಿದೆ.
Yes, my lords. 8804 of 2023.
ಇಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡಿದ್ದಾರೆ. ಏನಾಗಿದೆ mediation?
Mediation has failed, my lords.
Were not able to come to an agreement. As per the mediation center report, the parties who the settlement did not materialize. The same is taken on record. Connected with 24.1, you appear for the respond here. Shri Sachin BS, Learned Counsel, you undertake to
Yes.
appear? Undertakes to appear for the respondent. Same adrele shall file vakalat, etc. You serve the copies under. IA1 for interim maintenance. List after 2 weeks. You can file objections.
Well, still then I'll file affidavit. They have not filed affidavit for assets and liabilities in the matters.
Both of you have not filed.
Yes, my lords, in the trial court.
Trial court allo hakilla.
Hakilla.
5133 alli innond barkombi. The party shall file their affidavit regarding their assets and liabilities in terms of the judgment of the Supreme Court in Rajneesh versus Neha. List after 2 weeks.
Obliged.
Cell number 25, Raghunath MD, Monica Patil.
Stay there.
For the
24-3, one nimisha. Mr. Counsel, there is another matter, previous case. There are 3 cases. Vinod Kumar M.
Total, there are 3 cases.
24 and 24.2, what get the same part.
24 and 24.2.
You undertake to appear for them.
Yes, my lord.
In
And
both.
24.1.
All right.
I undertake to appear for the.
Yes.
Cell number 25.
Lord, husband's petition for divorce is rejected.
Hmm.
On the last occasion, we submitted that both the parties are senior citizens. My lord wanted their presence before this honorable court on 21/9/24 itself.
Not
please, my lord.
place IA1 of 2000, even as per the registration of appeal is intact. What was the order previously?
My lord, kindly take order dated 13/9, my lord.
13-9.
No, 13/9. To keep the parties present at 1:30 on 21/9 anta. There was no sitting on that day.
Need to interact with the parties. List
Please,
of
my lord.
21.
Subsequently, matter is not listed. If my lord fixes any date, I'll keep my party present.
My lords, both the parties are senior citizens. The
That is not
husband,
it.
my lords, date of marriage 1977, my
By
lords.
looking at that only, wait.
Please, my lords. She is undergoing cancer treatment, my lords, and
Even the appellant is not in a good health condition.
Do you go to the local
ಇಲ್ಲ Bangalore.
Bangalore?
Bangalore.
ಅಲ್ಲಿ mediation center ಗೆ ಏನಾದ್ರು ಹೋಗ್ತಾರಾ?
I doubt.
please, my lords, I can verify.
You did not try to convince them, both of them?
My lords,
I
not
tried
both
to
of them.
convince
I
my
only
client.
entered
He
appearance
wanted.
recently, my lords. I think he is very adamant. Mediation sessions have failed.
I could this.
He has not
Does
paid
not
her
make such
maintenance.
submissions.
See, wherever it is not possible in the mediation, it could be done by you also.
Please, my lords.
If
Correct, madam.
possible.
In
ಇಲ್ಲ
fact-
ಆಮೇಲೆ ಇಲ್ಲ ನಾವು ನಿಮ್ಮನ್ನೇ ನಂಬೋದಿಲ್ಲ ಅಂದ್ರೆ ತಗೊಂಡೋಗಿ ಫೈಲ್ ಅಂತ ಹೇಳಿ ಕಳಿಸ್ಬೇಕು ಅಷ್ಟೇ.
In fact, before preparing the appeal itself, I said, it's not a strong ground to file an appeal, but he is not in a position to pay maintenance or take care of himself.
Yes.
2 daughters.
Permanent alimony is not granted here.
Illa.
There are separate maintenance procedures.
And he is paying maintenance every month, 5,000.
5,000
He has
to the
not
children.
paid.
Wife.
Only to the wife.
Wife.
Both the daughters are married, they are residing separately.
Huh.
They are not supporting the appellant, supporting the mother only.
Correct. Even if the decree for divorce is granted, assuming that the judgment is reversed, still a permanent alimony will be granted.
He has no source of income. He is a retired person, class 4 employee.
Mention
Retired RBI
Pension
employee.
15,000 ಬರ್ತಿದೆ.
ಎಷ್ಟು ಬಂದ್ರು ಅದರಲ್ಲೇ ಕೊಡ್ಬೇಕು.
ಅದರಲ್ಲೇ ಕೊಡ್ತಿದೆ. In that itself, he is paying 5,000 as our maintenance also.
Now
Not that he has
has
stopped.
not challenged that 5,000 quantum.
No.
He has not challenged.
Quantum she has not challenged, my lord.
Then he has to pay that also.
He has paid, please. He is paying also. In fact, even now he is
Then
paying.
why he wants divorce?
He doesn't, he wants peace of mind the last days. That is the only grievance of my client.
Anyway, living separately.
But that tag as wife is still there.
My lords, if I may, my lords, until 2015.
Sorry to say so.
Happily, my lords. 2016, she is diagnosed with cancer, and 2017, he files this petition for divorce because her treatment expenses, etc., he doesn't want to bear. Very unfortunate case, my lords.
Children are not supporting her.
My lords, the 2 daughters are there. They visit her. They live in their respective matrimonial houses, my lords.
Maybe they may be living in their respective
Please,
matrimonial
they
houses.
don't live together, but whatever support she has to be taken care of, that is being provided.
Children
in
are
a
sailing
moderate
with him
manner.
or with her.
My lords, one daughter is sailing with her. The other daughter has
There is also partition.
alienated herself from the issue, my lords.
Alienated. Now there is partition there also.
That is the difficulty, please.
We understand.
Please.
As they grow older, the rigidity will be there. But if
But differences are more here. Otherwise, in the last days of their lives, it should be better that they are together. That this is what.
ಮತ್ತೆ ಬಂದಿತ್ತು ಇದೇ ತರದ್ದು ಹಿಂದೊಮ್ಮೆ ಯಾರು ಏಜ್ಡ್ ಇರೋರ್ದೇನೆ We called and asked that, told that party, if she or you die at this age, case gets abated. What are we going to get?
Correct.
If we keep this matter pending, then they settled the matter. ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ಅವ್ರಿಗೆ.
ಅಲ್ಲ ನಾವು
Now
ಹೇಳಿದೀವಿ.
she is suffering from cancer ಅಂತ ಹೇಳಿ.
Yes.
He is
And
also aged.
He is
If
also
any
aged
of
and
them leave
with
this
all,
world-
with all ailments also.
If any of them leave this world,
Yes,
this matter gets over.
automatically.
That they should realize.
Either way, please, my lord, I will keep him present.
ನಿಮ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ನೀವು ಹೇಳಕ್ ಸಾಧ್ಯ ಇಲ್ವಾ?
Please, my
ಆಗ್ಲಿಲ್ಲ.
lords, I
Otherwise-
not explode it, please.
You
You can.
try to.
We'll interact,
is-
my lords.
What is there for her to explore now? There is nothing for her to explore. You have to.
Either accept or
ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇನೆ.
ಅಲ್ಲ, if my lord directs us to keep them present, I shall keep them
He says
present.
she is suffering from cancer. You produce those records and we'll see. Your party comes before us. At least we'll tell him what is this
I can-
position.
I can keep him present, that is
Please.
not.
ನೋಡಿ ನೀವು ಅದು what are the records you produce it. If she is not able to appear, then we'll say only party shall be present. Next time we can produce this document.
Please.
Both counsels seek time on the ground that appellant and respondent are old age people and suffering from ailments. Okay. Looking at their medical condition, party shall appear before this court on next hearing date.
Please.
List on
Please.
2 weeks after. 2 weeks.
2 weeks.
25, 25/3.
Oh, bless.
Wait for-
Till number 26, Sudhindra Bhatt.
ಹಿಂಗಲ್ಲ based on medical condition ಅಂತ ಮಾಡಿ.
Sudhindra Bhatt.
Your lordship permits,
Yes.
my lord, I filed the,
In both cases, notice is not yet ordered.
not, my lord.
Both your petition is dismissed.
Yes, my lord, my petition is dismissed. And the respondent petition is RCR. It has been
Restitution.
allowed, my lord.
Other petition was for restitution.
Yes, my lord.
Will issue notice. What is the age of your parties?
My party is right now 32, 35, my lord.
ಎಲ್ಲರಲ್ಲೂ ತಗೊಂಡು. Issue
And
notice to the
petition,
respondent.
respondent age
All
is also same,
parties.
29, my lord.
Common judgment ಅಲ್ವಾ? ಹಿಂಗ್ ಮಾಡ್ಕೊಳ್ಳಿ. First matter ಅಲ್ಲಿ third admit call for TCR issue notice to the respondent. Second matter 26.1 ಅಲ್ಲಿ issue notice to the respondent. List on
4/6.
4.
Much.
Till number 27, Vijay Shetty B.
The section 9 petition filed by the wife has been decreed. Not she has stayed with the appellant only for 3 months. And her demand is not the appellant has to come and stay with her residence, her parents' residence. So that was the dispute, my lord. Only 3 months she has stayed. And he is the only son for his parents. He cannot.
Respondent is directed to join the company of the petitioner and lead marital life with the petitioner within 2 months. What was his house?
He is the agriculturist, he is staying with his parents.
Vide Narsipur.
Howdu.
Yeah, had you produced any proof of his residence?
My lord, it is undisputed, my lord, he is
Undisputed.
undisputed. It is he is residing along with his parents, doing agriculture in this.
In the
Where?
cross-examination, whether or in the evidence they had, she had asserted that she stays only if he makes a house in Chikmagalur.
ಅಲ್ಲ ಅವರು ಹೇಳ್ತಾರೆ ನಾನು ಬರ್ತೀನಿ ಅಂತ. ಇವರೇ ಹೋಗಿ ಅಲ್ಲಿ ಡಿಮಾಂಡ್ ಮಾಡಿದ್ದಾರೆ ಬನ್ನಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಅಂತ. She herself admits in the cross examination. Kindly see the cross examination dated 6/7/2023.
Issue notice to the respondent, call for TCRs, intents. Heard admit, call for TCRs, issue notice to the respondent, intents to have the execution of the impugned decree till next hearing date.
Please.
List on date
4/6. Till number 28, L. Shrikant Rao.
The present appeal is by insurance company challenging the liability to pay.
ಎಲ್ಲಿ ಅಂತ ಏನು ಬರ್ದಿಲ್ಲ.
Appeal by the insurer challenging the liability to pay the compensation. The liability, the point of liability is with regard to the driver of the insured vehicle was under the influence of alcohol beyond the permitted limits And your lordship knows about Supreme Court judgment, a large judgment of Supreme Court where it has held that the insurer doesn't incur any liability in such cases.
ಏನಾಗಿದೆ
If court case ನಲ್ಲಿ larger bench judgment ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ.
You have that judgment now?
ಈಗ ತಂದಿಲ್ಲ. So I have referred to it in the 12/4/21 if court versus the Pearl Beverages Limited at page 11 ನಾನು ಹೇಳಿದ್ದೀನಿ ಅದು ರೆಫರ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ.
Citation ಹೇಳಿ ಇಲ್ಲ ಪಾರ್ಟೀಸ್ ನೇಮ್ ಬರೆದು ಕೊಡಿ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ತೀನಿ.
ಕೊಡ್ತೀನಿ.
Issue notice to the what evidence you let to show that he was charge sheet was filed against him for drunken driving?
ಹೌದು ಇದೆ ಎಲ್ಲಪ್ಪ ನಾನು FSL ಇವ್ರಿಗೆಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೀನಿ.
You have examined?
FSL ಆಫೀಸರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೀನಿ. Who clearly stated that it was beyond permitted limits.
Issue notice to the respondent.
ಇದು ತಂದ್ಕೊಡ್ತೀನಿ ಕಾಪಿ ತಂದ್ಕೊಡ್ತೀನಿ ಸುಮ್ಮನೆ ಕೋರ್ಟ್.
Subject to appellant depositing 50% of the award amount before this court within 4 weeks from the date of the receipt.
ಅಲ್ಲ 6 weeks ಮಾಡಿ ಸುಮ್ಮನೆ ಡಿಪಾಸಿಟ್ ಲೇಟ್ ಆದ್ರೆ 6 weeks.
From the date of receipt of copy of this order ಮಾಡಿ 6 weeks ಮಾಡಬೇಕು. 6 weeks ಆದ್ರೆ from the date of order.
ಅಲ್ಲ ಅದು
From the date of this. Okay. And I have 1 of 2024 to dispatch of according to list on
5/6.
5/6.
Number 29, Shivraj and Nerali.
ಇದೆಲ್ಲ ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ. What is this? IA1 for direction. What is that IA1 you have filed? G and W. Petition is dismissed. Petitioner is reverted to initial execution proceedings to execute the compromise decree in MC number so and so for visitation rights. What is this IA1 for direction? Direction against the child. How can we grant direction against the child? Mala. Issue notice to the respondent. And then call for TCS and issue notice to the response list on.
5/6.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಏನೋ ಹಾಕೊಂಡಿದ್ದಾರೆ ಶಾರ್ಟೆಡ್ ಬಿಫೋರ್ ವೆಕೇಶನ್.
21/4. Seal number 30, Geeta Mishra, SPP.
Milords, appearing for the appellant accused Milords, who is being convicted for offences under 302 IPC Milords. He's been sentenced for a life imprisonment and a fine also Milords.
For IA Milords, I pay time Milords to file objections. For admission Milords, I don't have any
You
objections.
want to file objections?
For IA Milords,
During
suspicions.
trial he was in custody or on bail?
Milords?
During trial he was in custody.
Yes, Milords. He's been in custody for the last 6.5 years as of now, Milords, from
That means
2018.
his bail application was rejected during trial.
I think so. It was put once, Milords.
Direct case is based on direct evidence or circumstantial evidence?
Milords, on nothing, Milords. The prosecution has not been able to
There is
prove its-
nothing, then there could not have been a charge sheet.
Milords,
According to them,
Milords, the prosecution witnesses claiming to be the eyewitnesses are not eyewitnesses at all, Milords.
he wants to file objections to. Why it was not served on you? Copy was not served?
It was, Milords.
Milords, it was,
Why do you want time? When this application is filed?
Milords have filed it on 10/2, Milords, 2025.
on office objections, it came on 22/2025 Milords. So on office objections, it came on 22/2025.
Milords, the office objections were only with regard to 1 or 2 pages that was left off of the trial court order,
And
Milords.
when is directed to take notice?
No, I have to take Milords.
So 1 week time is granted for compliance. That was on 22/2025.
I have to take notice Milords.
Thereafter, now it is listed now only.
Now only Milords.
Then let him file objection. Learned SPP 6 trying to file counter to I number 2025, no? Well, 2025, list all. Let him file objections.
Milords,
Let him file objection if any objection is.
date please, Milords.
20th March.
23.
Grateful, my lords.
Bill number 31, Ravi Kumar GH.
My lord, it is a wife appeal, my lord.
Hmm.
The ex parte decree of divorce passed by the family court Bangalore is under challenge, my lord.
Expert decree in COVID period of the
No, my lord, recently.
2024.
Yes, ma'am.
Why were you not served?
Notice is served, my lord, but unfortunately she has appointed an advocate. So she has filed a maintenance petition before the trial court in Vodalkere, my lord. She has, after receiving the notice, she has approached the local advocate. Then that advocate has taken the wakalat and sent to the Bangalore. But unfortunately here, advocate who has been appointed has not appeared, therefore placed ex parte. Then
Every day we keep hearing these kinds of allegations only. What is your community responsibility?
what is the, because the instruction is
ಯಾರು
that
ಬಾರ್ ಕೌನ್ಸಿಲ್ನವರು ಬಾರ್ ಇದ್ರವ್ರು ಯಾರು ಬಾಡಿಯವ್ರು ಯಾರು ಇಲ್ವಾ ಇಲ್ಲಿ? What kind of allegations we keep hearing against lawyers?
but the,
That too, when it comes up in appeal, lawyers themselves draft those things. ಯಾರೋ ಸೀನಿಯರ್ಗಳು ಏನ್ ಶಂಕರ್ ರೆಡ್ಡಿ ಅವರು ಏನ್ ಮಾಡ್ತೀರಾ ಈ ತರದ್ದೆಲ್ಲ? ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಪಾರ್ಟೀಸ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು, ರಿಟೈರ್ ಆಗ್ಬೇಕು. Heard admit call for TCS, issue notice to the respondent. Interim stay of impugned judgment and decree till further orders. I1 of 2025 is disposed of accordingly. Please strong dating. Interim stay.
my lord, I am seeking remand of the PD.
Notice of perfect.
Yes, ma'am. Date may be given, my lord.
5-6.
Much obliged.
Bill number 32, Ravi HK.
For appellant in this matter, my lords.
ಮುಂದೇನು ಕಂಟಿನ್ಯೂ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ರಿಟೈರ್ ಆಗ್ಬೇಕು.
Bill number 32.
This appeal is filed by the wife, my lord. The wife had filed a petition seeking to declare the marriage between herself and the respondent as null and void because the marriage was solemnized as a result of force and coercion, my lord. The respondent husband, my lord, to cover up his illegal acts, formally filed a counterclaim for restitution of conjugal rights. The trial court has rejected my petition as well as his petition for counterclaim, my lord. Therefore, my lord, the trial court has created.
Only one case, MC 82 of 2012,
Yes,
22.
yes,
Petition filed under section 12(1)(c) is rejected ಅಂತ ಇದೆ. Counterclaim ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಇಲ್ವಲ್ಲ?
In the just above that, my lord, there is a reference to the counterclaim for restitution.
Point for consent. Whether petitioner proves that consent of the petitioner to the marriage was obtained in force, whether response proves that section is different.
Kindly see, my lord, para number 33 at page number.
So that point number 2 was also answered in negative.
Negative, my lord.
But the petitioner is
My
entitled.
contentions insofar as declaration of marriage to be null and void.
Correct.
Yes,
But in the
madam.
operative portion of the order, there is no mention about this counterclaim.
Yes, my lord, there is no mention. There is a discussion. However, there is no mention in the operative portion.
Admit call for TCS. Issue notice to the respondent. List on
5-6. Bill number 33, Urmila Pulak.
The appellant wife, my lord. In this matter, divorce was granted to the husband on the ground that cruelty has been proved against me. The main contention was that I was harassing him because of his adulterous relationships, my lord. The peculiar, his adulterous relationships. Peculiar facts of this case, my lord, are that
he himself concedes that you were harassing because of his adulterous relationship. Are you?
That is his allegation, my lord. But of course, I have denied it, and in my objections, I have clearly stated that I was receiving anonymous emails regarding his adultery, and I had tried to place those documents on record as evidence, my lord. They were not
You have
considered by
awarded, permanent alimony of 34,80,000.
No, my lord, not for me. That is only for my child. It's not permanent alimony,
Whether
it's
of
for
the
the,
petitioner is entitled.
yes, my lord. They have not awarded maintenance against me because I'm an earning member and I didn't challenge that.
What is the age of the child?
She's 19 now, my lord.
19.
Yes, she's studying for medicine. So that is why such an amount has been granted. I filed for enhancement of that amount, but also challenging this divorce decree.
You have already filed another case for enhancement.
No, my lord, in the same prayer because it was awarded in the same decree. In the same appeal, I have prayed for enhancement, my lord. I'm seeking a stay of the operation of that divorce decree against the against me.
There. Let's stay in the registry. Declare divorce.
I've also placed documents as additional evidence. These emails, my lord, I have placed it before the trial court.
To be considered along with the main matter now after his appearance.
Yes, my lord.
You have produced a list of documents.
There's only series of emails, my lord. So I've produced it collectively as one document.
Our office does not raise any objection.
They have not raised objection, my lord. I was not sure how to place it exactly because it's a series of emails back and forth from an anonymous person regarding his adultery. The only reason it was not marked in evidence was because of 65B.
Third admit call for TCS, issue notice to the respondent. 1333. IA 1 of 2025 for additional documents has to be heard along with the main matter. Interim stay of the decree of divorce, impugned decree of divorce till further orders. IA 2 of 2025 is disposed of accordingly. List on
5-6.
Oblige, my lord.
Say number 34, Sunil S. Narayan, M. Sunil Shastri.
Vice
For the
appeals,
respondent, my lord.
wherein husband had filed the decree of death on the ground of cruelty. Same came to be allowed. Wherein the trial court come to the conclusion that husband has proved the
It was the ground acts of cruelty alleged.
acts of cruelty alleged is that the main contention is that there is no cause of action to file the present petition only. Yakendre, as per their averments, cause of action arose in the year 2005 and continued till 2014. 2014 petition came to be filed.
26/9/2014.
14 petition hakira swami.
No, that is the day at the last.
That is from 2005 till 2014. Out of the marriage, there is a child has been born in the year 2009. From 2005 to 2014, both were residing in the same in the matrimonial home only. Petition is of the year 2014.
There were no criminal cases.
No, wife had not filed any criminal case. In fact, without any court order, husband was voluntarily paying the amount to me. He was visiting, seeing me. I have a child. He was talking with the child, and he has not proved. Cards
They've been separated for the past 11 years, my lord. They're not living together. She has harassed him like anything, and she has a suspicion that he has a relationship with his mother and sister and all. That is the allegations, my lord.
We have to re-examine that. We have to re-appreciate the evidence.
ಅದು 11 years ಯಾವಾಗ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಎಲ್ಲಿಂದ ಅಂದ್ರೆ ಸಪರೇಟ್ ಅಲ್ಲ ಸೂಟ್ ಹಾಕದ ಮೇಲಿಂದ 11 years ಕೌಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಇವರು 2004 and from 2014 to 2024.
Father and sister were examined.
Yes.
Yes, my lord.
Petitioner's father and sister were examined. ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೈ ಸೀಯಿಂಗ್ ದಿ ಡಿಪೋಸಿಷನ್ ಅದರಲ್ಲಿ ಎಲ್ಲೂ ಕೂಡ
When the records come will
ಬರ್ಲಿ ಸ್ವಾಮಿ ಬರ್ಲಿ. I have sought for an IA to stay the judgment.
stay of the impugned
I'll
judgment.
file my objections, my lord.
ಅಲ್ಲ ಸರ್ವೆ ಮಾಡಿದ್ದೆ ಅವ್ರಿಗೆ ನಾನು ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್ ಇಟ್
This
ಲಾಂಗ್
is matter of 2014 there. You only said that prior the harassments are started about 10 years prior to that. We'll see. Interim step execution. Interim step the impugned judgment and decree till further orders. I 1 of 2025 is disposed of.
Sure.
Much obliged.
After the receipt of this, yes.
Say number 35, L. Shrikant Rao.
Challenging the liability, the insurer is in appeal. Now, despite the entire prosecution document showing that the negligence is on the part of the deceased himself, because all the documents show that the deceased himself rode the motorbike in a rash negligent one, hit the left side portion of the insured car.
The charge sheet was
And
against
charge sheets are filed on both the rider and
both of them.
both of them. And entire liability is fixed on me.
100% liability
Is fixed on the insurance company.
According to what should have been the
ಅಲ್ಲ
negligence?
ಇದ್ರಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಇಟ್ ಇಸ್ ಜಂಕ್ಷನ್ ಆಫ್ 4 roads.
100%.
ಅಲ್ಲ ಬರೋದೇ ಇಲ್ಲ
100%
ಸುಮ್ಮನೆ
to the deceased.
ಅದು ಕ್ಲಿಯರ್ ಆಗಿ ಯಾಕೆ ಇದ್ರಲ್ಲೇ ಇದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ.
Yes, issue notice to the respondents. Interim stay of the execution of the interim award till further order, subject to appellant depositing 50% of the award amount for this court within
Six
within
weeks.
6 weeks from the date of this order. I have one of estimate
Match.
25 disposed of accordingly. List on 6.
56. Seal number 36, KV Satish Chandra.
Where Satish Chandra. Payments. Respondents are represented by some others, 10 years. IFCO Tokyo and HDFC Irgo, there are two insurance companies. There are IFCO Tokyo and HDFC Irgo. You appear for whom? Yargi, IFCO Tokyo, no? Shri Shankar Reddy. HDFC Irgo, Shrikant Rao, you and HDFC Irgo carry Janardhan Reddy, Pradeep idare,
ಪ್ರದೀಪ್ ಇದ್ದಾರೆ ಶಿವನೇಗೌಡ.
ಈಗ ಪ್ರದೀಪ್ ಅವ್ರು ಬೆಳಿಗ್ಗೆ 2-3 ಕೊಟ್ಟಿದ್ದೀವಿ. BC Shivan and Shri BC Shivanegoda, learners standing counsel for respondent 2 and 5 respectively are requested to take notice for those respondents. Issue notice to respond number 1, 3 and 4. Call for TCS. We will call for TCS. List on
56.
56.
Seal number 37, Manjunath DL.
Satish Chandra generally.
For appellant, you know.
Yes.
This is the wife's appeal, Your Honor, against the judgment and decree of family court.
On what note it was granted?
Cruelty.
13-1-1.
13-1 cruelty, Your Honor. There is no corroborative evidence for that. And there is no discussion, there is a child born, 2-year child. There is no discussion of the welfare of the child in the judgment, Your Honor.
Not admit call for TCS. Issue notice to the respondent. Interim step the infant judgment and decree till further orders. Stake the application anything. I have 1 of 2.
I sought for stay.
Accordingly. List on
56.
I sought for stay, Your Honor.
Granted.
Seal number 38, C Shankar Reddy.
This case appearing for the appellant, my lord. The claimant's insurance company appeal, my lord. The cause of death, my lord, the mother of the deceased was the claimant. Tribunal awarded 21,47,600 with interest, my lord. This, in this appeal, my lord, I am questioning the liability on the ground that, my lord, the driver of the vehicle is not having a valid driving license, my lord. Offending vehicle.
Even if that is the case, pay and recover agbeku. Call for TCS. Issue notice to the respondents. No DL. But still adu servicing case all agide. Immediately has not passed. Interim stay, the execution of the impound award subject to deposit of 50%. ಅದೆಲ್ಲ ಸರಿ. ಅಲ್ಲ ಅದ್ರ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರೆ ತೊಂದರೆ ಆಗ್ತದೆ. Otherwise we are directing to deposit it before the tribunal only. Again records have to go. ಅದೆಲ್ಲ ಆಗ್ತಾ ಇದೆ ಅದಕ್ಕೆ. Before this court. List on
56. Seal number 39, KV Satish Chandra.
6 weeks ago.
Another 2 matters is there, you know. 4 cases.
ಅರೆ ಅವಾಗ
Another
ಸತೀಶ್
2 cases.
ಅಲ್ವಾ ಹಿಂದಿದ್ ಕೇಸ್ ಇದ್ದದ್ದು.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಅಂತ.
ಅಲ್ಲ ಹಿಂದಿದ್ದ ಕೇಸ್ ನೀವೇ ಸತೀಶ್ ಚಂದ್ರ ಅಲ್ವಾ?
ಹೌದು.
MFA ಒಂದು MEC. ಆಯ್ತು ನೋಟಿಸ್ ಆರ್ಡರ್.
Notice.
ಕಾಪಿ ಹೇಳಿದ್ವಿ ನೋಡಿ. ಇದ್ರಲ್ಲಿ
Previous ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನಿಮ್ದೇ ಇತ್ತು, ನೀವು ನಾಟ್ ದೇರ್. This serial number 39 ಅಲ್ವಾ? That was serial number 36
ಅಲ್ಲಿ.
36. ಇದರಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವ್ದಿದೆ?
ಒಂದು HDFC.
ಅದು ಇದೇನ್ ಕನೆಕ್ಟೆಡ್?
ಅಲ್ಲ connected. All the 4 matters is the minor, Your Honor.
ಹೌದು.
4 death cases.
ಹಂಗಂದ್ರೆ
Another 2 matters is there.
What are the other 2 matters?
No,
File
some
ಆಗಿದೆಯಾ?
small office objections is there. That's why.
ಫೈಲ್ ಆಗಿದೆಯಾ?
File ಆಗಿದೆ.
ನಾವು
File
ಎರಡು
ಅಲ್ಲ sir, small office objections is there.
36 and 39 connect ಮಾಡ್ಕೊಂಡು these two matters 36 and these two matters arise out of the common award, therefore they are connected to each other. ಅದಾದ್ಮೇಲೆ we had directed Mr. ಯಾರವರು ಹೇಳಿದ್ರು
ಸಿ ಶಂಕರ್ ರೆಡ್ಡಿ ಮತ್ತೆ ಬಿ ಸಿ ಶಿವಣ್ಣೇಗೌಡ
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಸರ್ ತಗೊಳಕ್
ಮಾಡ್ಕೊಡ್ತೀನಿ.
ಸರ್ ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಸೇಮ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು
5-6
respondents 1, 3 and 4 list on
5-6
5-6.
Much obliged.
for further hearing cell number 40 H Maltesh Kumara KG Janardhan Reddy.
ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಗಿತ್ತು, ಜಡ್ಜ್ಮೆಂಟ್ ಗೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಹಾಕೊಂಡ್ರಿ ಸರ್, ಅವತ್ತಿಂದ ಮತ್ತೆ ರಿಜಿಸ್ಟರ್ ಆಗಿತ್ತು.
ಟೆನ್ 90% ಕೇಸ್ ಅಲ್ವಾ?
Yes, my lordship. And also the income ಅಲ್ಲಿ ರೆಂಟಲ್ ಇನ್ಕಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ರೀಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ.
ಮಾಡಿದ್ವಿ ಅದ್ರಲ್ಲಿ. ಅದೇ ಆ ಶಂಕರ್ ಅನ್ನೋರ್ದೇ ರೆಂಟಲ್ ಇನ್ಕಮ್
ಹೌದು
ಅದರಲ್ಲಿ ಹೀಸ್ 10% ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಡಕ್ಟೆಡ್.
ಹೌದು
ಹೀಸ್ 10% ನೆಗ್ಲಿಜೆನ್ಸ್. ಅದೇ ಟ್ಯಾಕ್ಸ್ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, 6,60,000 ಆಯ್ತಾ ರೆಂಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದಾಗ ಹೀಸ್ ಇನ್ಕಮ್. ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ 2015.
6,62,916.
ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ 2015. It was heard for this bench. ನಾವು 10% ಮಾಡಿದ್ವಲ್ವಾ, 5 lakhs above 5 lakhs ಇತ್ತಲ್ಲ, ಅವರು ಶಿವಸ್ವಾಮಿ ಈ ಸ್ಲಾಬ್ ತಗೊಳ್ಳೋದು 20% ತಗೋಬೇಕಾಗುತ್ತೆ ಅಂತಾರೆ, 10% ತಗೊಂಡಿರ್ತಾರೆ, ವಿಚ್ ಇಸ್ ಕರೆಕ್ಟ್. ನಾವೇನು ಮಾಡಿದ್ವಿ, ಅಬೌವ್ 2,50,000 ಎಕ್ಸಂಪ್ಷನ್. ಅದಾದ್ಮೇಲೆ ಉಳಿದ ಅಮೌಂಟ್ ಎಷ್ಟು ಉಳಿತು? 4,10,000. 4,10,000 ಅದಕ್ಕೆ ನಾವು 10% ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ. ಹೀಸ್ ಇನ್ಕಮ್ ವಾಸ್ ಮೋರ್ ದೆನ್ 5 lakhs. ಇದನ್ನ ತಗೋಬೇಕಾಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ವಿ. ಇದನ್ನ ತಗೊಂಡ್ರೆ ಟ್ಯಾಕ್ಸ್ ಜಾಸ್ತಿ ಆಗ್ತೈತೆ. ಅವಾಗ ಬರೀ 41,000 ಆಗಿತ್ತು, 82,000 ಆಗುತ್ತೆ ಅಂತ ಚೆಕ್ ಮಾಡಿ ಎಷ್ಟು ಕೊಡ್ತೀನಿ. His income as per the IT returns 2013-14 ನಲ್ಲಿ his income was 5,99,823. His income was ಅಲ್ಲ ಅವ್ರದ್ದು IT ರಿಟರ್ನ್ ಪ್ರಕಾರ 5,99,000 ಅಲ್ಲ, ಇಟ್ ವಾಸ್ ಮೋರ್ ದನ್ ದಟ್. ನಾವು ಅದರಲ್ಲಿ 6 ಲಕ್ಷ ರೆಂಟಲ್ ಇನ್ಕಮ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ವಿ. ಅದ್ರ 11,99,823 ಇತ್ತು ಅಂತ ಕಾಣಿಸುತ್ತೆ. ವಾಟ್ ಇಸ್ ದಟ್ ಎಕ್ಸಿಬಿಟ್? ಫೈವ್ ಲ್ಯಾಕ್ 99,823. ಇಲ್ಲ, ಅದು ಲಾಸ್ಟ್ ಬಿಫೋರ್ ಡೆತ್ ಯಾವ್ದಿರುತ್ತೆ ಅದನ್ನ ತಗೋಬೇಕು ಅಂತ 13-14. 5,99,823 ಆನ್ ಎಕ್ಸ್ಕ್ಲೂಡಿಂಗ್ ರೆಂಟಲ್ ಇನ್ಕಮ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ ನಾನು. 6 lakhs ವಾಸ್ ದ ರೆಂಟಲ್ ಇನ್ಕಮ್ ಅಲ್ವಾ? 5,99,823 ಇತ್ತು, ಅದನ್ನ ಅಲ್ಲ ಪ್ಲಸ್ 10% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 10% ಸೇರಿಸಿದೆ ಅದಕ್ಕೆ. ಕರೆಕ್ಟ್, 6 lakhs ಮಾಡಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 10% ಸೇರಿಸಿದ್ಮೇಲೆ 6,60,000 ಆಯ್ತು. ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಷನ್ ನಲ್ಲಿ ಇವ್ರು ಆಮೇಲೆ ಅದಕ್ಕೆ 6,60,000. ನಾವು 2015 ಆಕ್ಟ್ ನೋಡಿದಾಗ ಫಸ್ಟ್ ಲ್ಯಾಬ್ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ 10% ಅಂತ. ಇದೆಲ್ಲ ಜಾಸ್ತಿ ಆಗ್ಬೋದೇನೋ ಅಂತ ಹೇಳಿ. IT return is exhibit
17, my lordship. 17 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಇದ್ರಲ್ಲಿ ಏನ್ರ ಒಂದು ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ರ ಸಪರೇಟ್? They have not challenged it.
ಅವರು
ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವ್ರು ಚಾಲೆಂಜ್
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಸರ್, ಅವ್ರು ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿ. ಇದನ್ನ ಸ್ವಲ್ಪ ತೆಗೆದುಕೊಡಿ, ಅದನ್ನ ಅದು ಸ್ಲಿಪ್ ಹಾಕಿ. P17, ಆ P17 ಅಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮಲ್ಟಿಪಲ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಒಟ್ಟಾಗಿನೇ ಅದು 2013-14 ಅದು ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತಿರೋದು ಬಟ್ these appeals arise out of the common judgment and award in MEC number 1911 of 2015 and MEC 1978 of 2015 passed by the the 18th additional judge, Court of Small Causes and MACT Bengaluru. The particulars of appeal and the parties are set out below in the tabular form. ಇದರಲ್ಲಿ MFA ನಂಬರ್ ಆಮೇಲೆ ನೋಡಿ ಹಾಕೊಳ್ಳಿ. MFA ನಂಬರ್ 1911 of 2021, MEC ನಂಬರ್ 1911 of 2015. ಅದು ಅಲ್ಲಿ rank of the party before the tribunal. Okay, claimant number 4. MFA number 4977 of 2021, MEC 1911 of 2015. Insurer. Respondent number National Insurance Company ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡಿದಾರಲ್ಲ.
New India.
No, appeal is preferred by
United Insurance Company.
United India.
90% ನಮ್ಮ ಮೇಲೆ ಇರೋದು ನಾವು ಫೀಲ್.
ಒಂದರಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿನೇ ಮಾಡಿರ್ಲಿಲ್ವಲ್ಲ.
ಹೌದು, ಮಾಡಿರ್ಲಿಲ್ಲ.
Preferred. United India has preferred the appeal.
ಹೌದು.
Respond number 2. ಇನ್ನೊಂದು MFA number 6435 of 2021, MEC 1911 of 2015. Claimants number 1 to 3. Next MFA number 5036 of 19, MEC 1978 of 2015. Insurer. Respondent number ಎರಡರಲ್ಲೂ ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ? ಮಾಡಿದ್ದಾರೆ. ಒಂದರಲ್ಲಿ ಮಾಡಿರ್ಲಿಲ್ಲ ಅವರು.
ಅದು ಓನರ್ ಕಮ್ ಡ್ರೈವರ್ ಅಂತ ಹೇಳಿ ಅದು ಅದರಲ್ಲಿ ಓನರ್ ಮೇಲೆ 10% ಡಿಡಕ್ಟ್ ಆಗಿದೆ.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಮೆಮೊ ಕೊಡಿ ಸರ್, ಇನ್ನೊಂದು ಅಪೀಲ್ ಮೆಮೊ ಕೊಡಿ. In MEC number 1978 of 2015, the respondents were only 2 persons, that is Lalita and New India Insurance.
ಹೌದು.
ಅಲ್ಲ ಇಲ್ಲಿ 4 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. We do not know, ಅದೇನೋ ತಪ್ಪಾಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ.
ಅಲ್ಲ ಇವರು ಅಲ್ಲಿ ಮಕ್ಕಳ
5036 5036 ಇದೆ.
ಮಾಸ್ಟರ್ ವಿಕಾಸ್ ಅಂಡ್ ಯಶಸ್ವಿನಿ ಅಂತಿದ್ದಾರೆ, ಮಕ್ಕಳಿದ್ದಾರೆ ಲಲಿತಾ ಅವರು.
ಅಲ್ಲ ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ತೋರಿಸಿಲ್ಲ.
ಇಲ್ಲ, ಒಬ್ಬರನ್ನ ಮಾತ್ರ ಓನರ್ ಅವರು ನೆಕ್ಸ್ಟ್ ಸಕ್ಸೆಸರ್, ಹಸ್ಬೆಂಡ್ ತೀರೋದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಸಕ್ಸೆಸರ್ ಅವ್ರನ್ನ ಹೆಂಡತಿನೂ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಆಸ್ಟ್ರೇಟ್ ಅಲ್ಲಿ ತೋರಿಸುವಾಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 and 4 ಅಂತ ತೋರಿಸ್ತಾರೆ. ಹೂ ಆರ್ 1 and 2 ಅಂತ ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ. ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದ್ರ ಈಗ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ಇದ್ರದ್ದು ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಎಲ್ಲಿದೆ? ಅದ್ರ ರ್ಯಾಂಕ್ ನೋಡ್ಕೊಂಡು ಹೇಳಿದ್ರೆ
ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಇದೆ.
ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಕಾಪಿ
ಇದೆ, ನೋಡ್ತೀನಿ.
MEC ನಂಬರ್ ಎಷ್ಟಂದ್ರೆ 1978. MEC ನಂಬರ್ 1978 of 2015. ಅದನ್ನ ನೋಡಿ ಬರ್ಕೊಳ್ಳೋಣ ಬಿಡಿ. MEC ಅಂದ್ರೆ MFA 6436 of 2021. Claimants. The For the purpose of convenience, the parties are referred to. ಅದು ಹಂಗ್ ಮಾಡಿದ್ರು ಇಲ್ಲೊಂದು ಇದಾಗುತ್ತೆ. ಒಂದ್ ಕೇಸಲ್ಲಿ ಇಬ್ರು ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ, ಇಬ್ರು ಮಾತಾಡ್ತಾರೆ. ಆಮೇಲೆ the three facts cases are as follows. ಒಂದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ. ಆದ್ರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಅದು ಕಾಣೋದಿಲ್ಲ. ರ್ಯಾಂಕ್ ಆಫ್ ಟೂ ಪಾರ್ಟೀಸ್ ಇಲ್ಲಿ ಹಾಗೆ ತೋರಿಸ್ಬಿಡಿ ಪಾಪ, ತೋರಿಸಿ. ಇಲ್ಲಿ ತೋರಿಸಿ. ದಿಸ್ ಇಸ್ ನಾಟ್ ಶೋನ್ ಇನ್ ದ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್. ಪಿಟಿಷನರ್ 4 ಜನ ಇದ್ದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಅಲ್ಲೇನಾಗಿದೆ ಸ್ವಾಮಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇನ್ ಬೋತ್ ಕೇಸಸ್ ವೆಂಕಟೇಶ್ವರಯ್ಯ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಯುನೈಟೆಡ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇನ್ MEC 1978 ಅಲ್ಲಿ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಲಲಿತಾ ಅಂತ ಹೇಳಿ, ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಅವರು ಅವ್ರದೇ ವೆಹಿಕಲ್ ಇತ್ತಲ್ಲ, ಅವ್ರನ್ನ
ಹೌದು.
ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ. ಆ ಇನ್ಶೂರರ್ನು ಪಾರ್ಟಿ
Yes.
ಮಾಡಿಲ್ಲ ಅಂತ 1911 ಅಲ್ಲಿ.
ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರ ಮೇಲೆ 10% ಮಾತ್ರ ಲೈಬಿಲಿಟಿ ಇರುತ್ತೆ.
Shankar's, in case of death of Shankar,
ಹೌದು.
only 2 parties were there.
Yes.
ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. ಆಯ್ತು. The key facts of the case are as follows. On 10/2/2015 at 4 AM, Bhanu Prasad and T. Shankar were proceeding in a car bearing registration number. Car number ಹೇಳಿಲ್ಲ ಇಲ್ಲಿ.
Car number KA04MH
KA04
MH54.
Toyota Qualis car bearing registration number KA045499. And the car being driven by T. Shankar. The car was proceeding near near Panchayat office, Narsipura village, Somapura Hubli. The car hit the lorry bearing registration number K315161, which was parked on the road. Due to the injury suffered in the accident, both car driver T. Shankar and Bhanu Prasad died. Okay. The claimants in MEC number 1911 of 2015 are the legal representatives of wife. Claimants 1 to 3 in MEC number 1911 of 2015 are the wife and children. Claimant number 4 in the said petition is the mother of Shankar. Respond number 1 and 2 in MEC on 1911 of 2015 are the registered owner and the insurer of lorry bearing registration number K315161. The claimants in MEC number 1978 of 2015 are the wife. I'm sorry, claimant number 1 and 2. I'm sorry. Claimant number 1 and 2 in MEC number 1978 of 2015 are the wife and child, the son. Claimant number 3 in the said case is the mother of deceased T. Bhanu Prasad. Respondent number 1 and 2 in MEC 1911 of 2015 are the wife of respondent number 1 and 2 ಅಂತ ಹೇಳಿದ್ರೆ wife of Shankar, the registered owner of the car in question and insurer of the said car. Response 3 and 4 are the registered owner and insurer of lorry number K04MH5499. Both the claim petitions were filed against the respondents, alleging that the this car was being driven by ಒಂದು ಕೇಸಲ್ಲಿ ಅವರೇ ಹೇಳ್ಬಿಟ್ಟಿದಾರಲ್ವಾ ಅವಂದೇ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇತ್ತು ಅಂತ ಹೇಳಿ. The car was being driven by Shankar by following the traffic rules, but the driver of the lorry had parked the lorry on the road without displaying the parking lights. Therefore, the accident and death of Shankar and Banu Prasad occurred. They further contended that the deceased were the sole breadwinners of their families, and due to their death, they have suffered damages, and the respondents are liable to compensate the said damages. In MVC number 1911, the claimants sought compensation of this 2 crores. In MVC number 1978 of 2015, the claimant sought compensation of rupees 1,53 lakhs. 53 lakhs. Next one. It is to be noted that the car in question was owned by deceased T. Shankar himself, and on his death, his wife T. Lalita, who was the first claimant in MVC 1911 of 2015, succeeded to his estate. The said property succeeded to the said property. Therefore, she was shown as the respondent number 1, and the insurer of the said insurer of the said car was shown as respondent number 2 in MVC number 1978 of 2015, whereas they were not arrayed in the claim petitions in MVC number 1911 of 2015. Next paragraph. Respondent Respondent 1 did not contest the petition in the cases, and registered owner does not contest.
ಇಲ್ಲ
ಎರಡು ವೆಹಿಕಲ್ contest ಮಾಡಲಿಲ್ಲ.
Insurance.
The registered owners of both the vehicles did not contest the petitions. ಎರಡು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. Whereas respondent number 2 and 4 in MVC number 1978 of 2015, and respondent number 2 in MVC 1911 of 2015 contested the petition, denying actionable negligence on the part of the driver of the lorry and the car. They imputed the insurer of the car, insurer of the lorry contended that the lorry was parked by following complying all the road rules, and the deceased himself was rash and negligent in driving the car and hit the vehicle. Therefore, it had no liability to pay the compensation. The insurer, the same as the defense, the same as it. The defense of the other insurer was that the driver of the lorry was solely responsible for the accident. Further, the insurers disputed the age, occupation, and income of the deceased and their liability to pay the compensation. The tribunal consolidated both MVC 1911 of 1911 and 1978 of 2015 and recorded the common evidence on behalf of the claimants. Claimant number 1 in MVC number 1911 of 2015 was examined as PW1. Claimant number 1 in MVC number 1978 of 2015 was examined as PW2. This Alimullah is PW3, are you know?
Yep. Income tax office. IT returns or chartered accountant.
Chartered account. That is regarding Shankar's income.
Shankar's income.
Also, to prove the income of deceased Shankar, each chartered accountant was examined as PW3. On behalf of the claimants, exhibits P1 to P43 were marked. The fourth respondent. The insurer of the lorry, that is United India Insurance Company Limited, examined the driver of the lorry as RW1 and got marked exhibit R1. The other parties did not reduce any evidence. The tribunal, on hearing both sides, by the impugned judgment and award, held that the driver of lorry and deceased Shankar, that is the one driver of the car, contributed in the ratio of 90-10% negligence in occurrence of the accident. The tribunal, on considering the tribunal further the tribunal on considering the evidence on record awarded compensation of 70 lakhs 3,000 to the claimants in MVC 1911 of 2015 and rupees compensation of 42 lakhs 23,000 in MVC number 1978 of 2015 with interest at 6% per annum. The compensation, liability was apportioned between the driver of the car and lorry as in accordance with the ratio of their contributory negligence. Driver, insurer of the lorry driver. In MVC number 1911 of 2015, correct, 2015, the mother of the deceased ಬರೀ 10% ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅವ್ರಿಗೆ
ಹೌದು ಸರ್.
ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಯ್ತಾ 90%. Very difficult to find out from the award. Hmm. 55% portion in favor of petition number 1, 20% each. ಅಲ್ಲಿ ಹಿಂಗೆ ಬರ್ಕೊಂಡು in MSc number 19 and 11 of 2015, the tribunal apportioned the compensation awarded amongst the claimants under the following ratio. ಅಲ್ಲಿ 1 to 4 ಹಾಕೊಂಡ್ಬಿಡಿ. 1 ಗೆ claimant number 1 to 4 ಹಾಕೊಂಡು 55%, 20%, 20%, the 2 and 3 ಗೆ claimant number 4 5%. 5%. Okay. The mother of the deceased has challenged the said award in MFA number 1911 of 2021, questioning the adequacy of the apportionment made to her share. Okay. MFA number in MFA number 4977 of 2021, the insurer of the lorry challenges the question finding of negligence and contempt. In MFA number 6435 of 2021, the claimants of MSc 1911 of 2015 questions the adequacy of the compensation award. Claimants 1 to 3 ಮಾಡಿ. MFA number 5036 of 2019 is filed challenging the finding of negligence and contempt in MSc number 1978 of 2015, and MFA 6436 of 2021 is filed by the claimants in the said case questioning the quantum of compensation. Next paragraph. ಮಾಲ್ತೇಶ ಈ ಕೇಸಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ ಅಲ್ಲ ಮಾಲ್ತೇಶ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಅವರಿಗೆ ಅಲ್ಲ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಅವರೇ ಮೇನ್ 90% ಕೊಡ್ಬೇಕಾದವರು ಅಲ್ವಾ?
ಅದನ್ನೇ ಸ್ವಲ್ಪ ಕೇಳಿರೋ ನೆಗ್ಲಿಜೆನ್ಸ್ ಎಂಟೈರ್
ಇಲ್ಲಿ submissions of Shri Janardhan Reddy, Leonard, Counsel for United India Insurance Company. That is appellants in MF number 40.1 and sorry, MF number 4977 of 2021 and 5036 of 2021. The evidence on record shows that the lorry was parked on the extreme left side in the Bay Area. Exhibit the sketch of scene of accident shows that the lorry was parked on the Bay Area, following all the layway, following all required safety instructions, the safety rules. The evidence on record, the motor vehicle inspector's report show that the driver of the car itself was in a high speed, rash and negligent, and he was solely responsible for the accident. The quantum of compensation awarded in both the cases is on the higher side. Submissions of Shri. ಈಗ ಬರೀ ಅವರಂತೂ ಏನು ಕ್ವಶನ್ ಮಾಡಿಲ್ವಲ್ಲ ಇವರು?
ಇಲ್ಲ ಅವ್ರೇನ್ ಮಾಡಿಲ್ಲ.
ಮಾಲ್ತೇಶ್ ರಿಪ್ರೆಸೆಂಟ್ಸ್ ಇನ್ ಆಲ್ ಕೇಸಸ್ ನೋ.
ಇಲ್ಲ
ಒಂದ್ ಕೇಸ್
ನೀವು
ಓನ್ಲಿ ಮದರ್ಗೆ ಅವರು
ಕುಮಾರ ಕೇಸ್
ಇನ್ನೆರಡರಲ್ಲಿ ನಾನು.
So he is in 1911 Albara.
1911.
So you have some say in
ಅದೇ 5%
negligence.
ಇಲ್ಲ ಸರ್, ಅವ್ರ ತಾಯಿಗೆ 5%
5%
ಕೊಟ್ಟಿದ್ರು ಅಂತ.
ಅಷ್ಟೇ.
You represent ಮುನಿಯಮ್ಮನ್ ಅವ್ರ
ಮುನಿಯಂ.
ಬಟ್ ಅವ್ರ ಎಲ್ಲಾರ್ಸು ಹಾಕಿದಾರೆ ಲಲಿತಾ.
ಹೌದು, ನಾನು
You
ಅದ್ರಲ್ಲಿ
represent. So you have a say in
yes, my lords, as per the exhibit P3, my lords, she was parked in the middle of the road. It's not
submissions of Shri Kumara Kesi.
my lords, if you
That
see the sketch, my lords, it can be
For
seen.
the appellants, appellants, claimants, for the legal representatives of,
Yes.
this is Shankar.
Please.
Shankar. ಅಲ್ಲ ನೀವು ಎಲ್ಲರಿಗೂ ಇಲ್ಲ ಬರೀ claimant number 1 to 3, you are 3 in MEC number 1911 of 2015. ಅವ್ರು ಮೊದಲು ಲಾರಿ ವಾಸ್ ಮೂವಿಂಗ್ ಅಂತ ತಗೊಂಡಿದಾರಲ್ಲ ಡಿಫೆನ್ಸ್.
ಇಲ್ಲ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇಟ್ಸ್ ವಾಟ್. ಹೌದು, ಇನ್ಶೂರೆನ್ಸ್
ಕಂಪನಿಯವರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಲಾರಿ
was moving
ಮೋಷನ್ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ.
yes.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದೆ. ಮೈ ವೆಹಿಕಲ್ ವಾಸ್ ಪಾರ್ಕ್ಡ್ ಆನ್ ಲೆಫ್ಟ್ ಸೈಡ್ ಆಫ್ ದಿ
Correct, but
For
your
nature
initial defense was that was
he was moving.
The defense of the insurer of the lorry was inconsistent. Initially, it was contended that the lorry was in motion and Shankar drove the car in rash and negligent manner and hit the same. The said defense was contrary to the evidence of RW1. The on investigation charge sheet ಇರೋದು ಅವ್ರೊಬ್ಬರ ಮೇಲೆ.
ಅವ್ರ ಮೇಲೆನೆ ಲಾರಿ
Charge sheet was filed against the owner of the, the driver of the lorry. The evidence on record also clearly show that the driver of the lorry was, lorry had parked the lorry had parked the said vehicle with and there was a culpable negligence on his part in parking the lorry without parking indicator lights. Therefore, the tribunal was in error in fastening 10% contributory negligence to car driver. The compensation awarded to the legal representatives of Shankar is on the lower side. What do you say for mother-in-law?
The 10% my lords, last time we said.
Oh.
Lords, 5% was given, my lords, 10% it will be
Considering the age of, last time you hage ಹೇಳಿದ್ರಿ, considering her age, whatever granted is sufficient ಅಂತ.
ಹೌದು, 88%,
Age of
85 ವರ್ಷ ಏಜ್.
Whatever compensation was apportioned to her is just and sufficient. Next, submissions of Shri H. Malfish for claimant number 4 in MEC number 1911 of 2015. Admittedly, claimant number 4 was the mother of the deceased. At the time of his death, she was aged 75 years. She had the equal share in the estate of her son along with his other heirs. Therefore, compensation apportioned to her is totally inadequate. The same needs to be corrected in this appeal. Submissions of Innobraru. You represent in both cases, Kumar.
ಹೌದು,
ಯಾರು ಎಲ್ಲಾರ್ಸ್
ಆಫ್ ಡಿಸೀಸ್ ಪರ್ಸನ್ಸ್.
ಭಾನು ಪ್ರಸಾದ್ ಅಲ್ಲ?
ಹೌದು, ಭಾನುಪ್ರಸಾದ್.
ಅದನ್ನ ಎರಡರಲ್ಲೂ ಒಂದ್ಗೆ ತಗೊಂಡ್ಬಿಡೋಣ ಹಾಗಾದ್ರೆ. ಒಂದ್ರಲ್ಲಿ
ಒಂದ್ರಲ್ಲೇ
ಅಲ್ಲಿ ಹೇಳಿದ್ವಲ್ಲ ಕುಮಾರ ಕೇಸಿ ಅದು. ಆಮೇಲೆ ಫಾರ್ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ಯಾರು ಕ್ಲೇಮೆಂಟ್ಸ್ 1 to 3 and LRs of Shankar in MEC number 1911 and claimants in MEC number 1978 of 2015. The amount compensation awarded for the death of Shankar, Bhanu Prasad is also on the lower side. The same needs to be enhanced. Next. ಅವ್ರದಂತೂ ಏನು ಇದೆ ಇಲ್ವಲ್ಲ? ಹರಿಣಿ ಶಿವಾನಂದ ಅವರಲ್ವಾ? submissions of ಶ್ರೀಮತಿ ಹರಿಣಿ ಶಿವಾನಂದ, the insurer of car number
KA 50.
K. ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ K04 MH 5499 ಅಲ್ವಾ?
Double 9.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ K04
5499.
ಇಲ್ಲಿ MH ಅಂತ ತೋರಿಸಿದ್ರೆ ಮಹಾರಾಷ್ಟ್ರ ಪಾಸಿಂಗ್
ಇಲ್ಲ K.
549 ಅಲ್ಲಿ ಅದ್ ನೋಡೋಣ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಕೊಂತಾರೆ. On investigation, the charge sheet was filed against the driver of the lorry. The insurer of the car, accepting the finding, has deposited 10% of the compensation awarded. There is no reason to disturb the said. There are no grounds to reverse the said finding. Hence, the findings of the tribunal shall be maintained. The compensation awarded is in both the cases just and proper. Next. And hearing both submission of the advocates on record for the parties and an examination of the findings, examination of the material on record. The following questions arise for consideration of this court. Number one, whether the finding of the tribunal that on 10/2/2015 at 4 AM, the near Narsapura village, the accident between Toyota car number K04 5499 and lorry bearing registration number K31 5161 occurred due to contributory negligence of the driver of car and lorry in the ratio of 10% semicolon colon 90% is sustainable. Number two, whether the compensation awarded in MVC number 19 and 11 of 2015 is just and fair one. Whether the tribunal was justified in apportioning only 5% of the compensation to claimant number 4 in MVC number 19 and 11 of 2015. Claimant. Okay. Next, whether the compensation awarded in MVC number 1978 of 2015 is just and fair one. Next one. Regarding point number 1, negligence. There is, please take your seat. Good. There is, the parties are not a dispute that on 10/2/2015 at 4 AM, deceased, I'm sorry, Shankar was driving his car number K045499 along with Bhanu Prasad was parked there, and the car hit the said lorry. It's also not disputed that both Shankar and Bhanu Prasad succumbed to the injuries suffered in the said accident. It's also not the parties initially claimed, the parties in both the cases claimed that the driver of the lorry was the lorry had parked the said lorry negligently on the road without displaying the parking lights, which led and the victim, Shankar, was unable to notice the lorry and rammed into the hit the same from the hind side. Thus, it was claimed that the driver of the lorry was solely responsible for the accident. To to substantiate their claim, they relied on the evidence. They relied on Exhibit P12, P8, the FR complaint sketch spot measure, IM report, IM report, Exhibit P1 to P5 and P1 to P5 and P8, and the charge sheet. It is not in dispute that the charge sheet was filed. It's not in dispute that the complaint Exhibit P2. Filed by one Kempana, the Abbaspet police registered a FIR in crime number 37 of 2015 against the driver of the lorry, and an investigation. Charge sheet is Exhibit Krishna. The charge sheet as per Exhibit P8 was filed against the driver of the lorry for the offences punishable under Section 279, 304 IPC and Section 122 of Indian Motor Vehicles Act. It is a settled principle of law that the proceedings under Section 166 of the IMV Act are summary in nature and strict. The claimants do not have the burden of proof beyond reasonable doubt as required in a criminal case. They have their burden of proving gets discharged if they satisfy the degree of preponderance of probability. Exhibit P8. Though much was contended referring to IME report and sketch of scene of offense. Exhibit P3. The spot sketch itself shows that the lorry was parked on the road. Though it was contended that the lorry was parked in a layaway, the sketch does not show any such layaway. It only shows that road at that spot was little broader. But the vehicle, the lorry was, though the lorry was on left side, it was on the road. Admittedly, the accident has taken place at 4 a.m. Exhibit P3 does not indicate that there was any street light or any other source of light. Light ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳಿದಾರಲ್ವಾ. Driver has admitted that there was no parking light. RW1.
ಇಲ್ಲ ನಾನು ಲೆಫ್ಟ್ ಸೈಡ್ ಲೇಬೆಯಲ್ಲಿ ನಿಲ್ಸಿದ್ದೆ ಅಂತಾನೆ ಎವಿಡೆನ್ಸ್.
ನಿಂತಿದ್ದಲ್ಲ, ಲೈಟ್ ಹಾಕಿದ್ರ ಬಗ್ಗೆ.
ಆ ಲೈಟ್ಗಳು ಹಾಕಿದೀನಿ ಅಂತ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿರೋ. ನಾನು ಲೆಫ್ಟ್. My lorry was parked on the extreme left side of the road for nature call by putting indicators.
Which is something else, ಆ ತರ ಇಲ್ಲ. He admits in his cross-examination that he claimed in his cross-examination that he filed a complaint regarding the incident before the police, but he admits in his cross-examination that he has not challenged the charge sheet. Though exhibit P3, the spot sketch was confronted to him, he was not able to show any parking space in the said document. He admitted that as per the said sketch, he had sufficient space on the left side of the parked lorry. Except his, I'm sorry, it was denied in the cross-examination of RW1 that he had put on the parking lights of the lorry. Except his interested evidence, there was nothing to show that he had displayed the parking lights. But the tribunal considered that despite such being the things, if the driver of the car also had exercised some due diligence, the accident could have been avoided. The motor vehicles inspector's report shows that there was extensive damage to the car also. PW1 and 2 were not the eyewitnesses to the incident. Except them, no other witnesses were examined. Under the circumstances, this court does not find any ground under circumstances. The trial court, the tribunal, on considering all these aspects, has rightly fastened the negligence to the driver of the lorry and car in the ratio of 90 and 10% each. There are no grounds to interfere with the said finding. There are no grounds. Okay, quantum will take up in the afternoon. On 30th. Quantum afternoon.
That's on submission, my lord.
50%.
My lord.
Correct ಇದೆ ಆದ್ರೆ ಅದರ ಮೇಲೆ
57.
On submission.
yes.
My lords, serial number 21, my lords. Date was given on 20th, my lords. There is a small inconvenience on that date, my lords. Maybe given for 18th or 19th, my
It
lords.
was given in your presence, no?
Yes, my lords, but later I inquired with my senior and
It is only for appearance. What is your convenience?
the other side has filed vakalat, my lords.
ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರಾ
Undertake ಮಾಡಿದ್ರು.
ಯಾವತ್ತಂತೆ
20ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಈಗ ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ನಾವು ಚೇಂಜ್ ಮಾಡೋದಿಲ್ಲ ಡೇಟ್.
I was only present, my lords.
ಅರೆ ಯು ಸೇ ಹಿ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ವಕಾಲತ್
No, in other connected matter.
ಗೊತ್ತಿಲ್ಲ ನಾವು ಮಾಡೋದಿಲ್ಲ.
My lords, in the another connected matter.
51, my lord. Matter is settled
mention on that day. Yes.
serial number 51, my lord. Matter is settled before the mediation now, my lord. Both the parties are present before this court.
ಆಯ್ತು ಮಧ್ಯಾಹ್ನ 2:30 ನೆನಪು ಮಾಡಿ.
My lord,
on submission, my lord.
Sorry, please don't insist.
43 of the matters I appear for the appellants in 43.1 I represent the respondents. A fixed accommodation is paid because some of the papers are missing. I will, that's.
Who is for the other side? Subramani.
I have informed him also.
Okay. You are for the
The first matter.
43 attended at the request of the appellant's counsel.
One.
ಏನಾಗ್ಬೇಕಿತ್ತು ಅದ್ರಲ್ಲಿ ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಇದೆಲ್ಲ ಅದು ಮುಗಿಸೋಣ. 44.1 ನಲ್ಲಿ ಮತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ 72 ಡೇಸ್ ಡಿಲೇ ಇನ್ ಫೈಲಿಂಗ್ ಅಂತ ಪೆಂಡಿಂಗ್ ತೋರಿಸ್ತಾ ಇದೆ ನೋಡೋಣ. ಕನೆಕ್ಟೆಡ್ 44.1 ನಲ್ಲಿ ಅದು ಆಗಿಲ್ಲ ಅಂತ ಕನ್ಸುತ್ತೆ. ಅಂದ್ರೆ ಒಂದು ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಂದಿದ್ದು ಕನೆಕ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಬಂದಿರ್ಬೇಕು. ನೋಡೋಣ ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅದ್ರಲ್ಲಿ.
Serials of 48, my lord.
ಮಾಡಿ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ adjourn
My lord,
ಮಾಡಿ.
serial number 45, my lord, serial number 45, I have. Personal income
10
is,
people speak together, we can't hear any of you, sorry. We'll take it up in afternoon.
serial number 45.
Court officer. Court officer. Serial number 44 ಇದೆಯಾ ಮೇಡಮ್?
ಹಾ ಸರ್ ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಹಾಗೆ 47 ಇದೆ ಅಲ್ಲ?
ಇನ್ನೇನ್ ಬಂದಿಲ್ಲ ಚಂದ್ರ?
The Lordship's kind permission. Serial number 48, Nalini. The respondent number 2 advocate has indicated that there was a connected appeal which has been disposed of in MFA 6447 of 2016, which has been disposed of on 3rd of September 2020. Madam. If it is put up with those records, because it arises out of the same accident.
If you have, you can take a printout from the High
ನನಗೆ
Court
ಇವತ್ತು
website.
ಹೇಳಿದ್ರು ಅವರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.
Ramakrishna counsel has also told, that's some inconvenience, that's what he told me.
He has indicated.
Then but why the record should be put up? You can produce a copy of that.
That
order.
is what even I was under the
As requested.
once he intimated.
You are appearing for?
Appellant, madam.
As requested for Appellant's counsel. You want any particular date?
Date may be given, madam.
It's on
17th or 19th of March.
19.
Grateful. 19th March.
Yeah.
Serial settlement.
Serial.
Serial number 51 for settlement. Rajmani P, Maruti GP.
I am the.
Cost of this 3,000. Why costs were imposed? Who has to pay the cost?
They are paid. We have received the cost.
Last time we have.
On the last date of application, my lord, your lordship has imposed the cost on the petition, appellant, my lord. On the last date of application, my lord, they did not bring the DD and gold.
ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಸ್ಟ್
ಇವಾಗಿಲ್ಲ ಕಾಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಡಿಡಿ ಮತ್ತೆ ಗೋಲ್ಡ್ ಕೊಟ್ಟಿಲ್ಲ.
both parties. And their counsel are present in the court. Counsel for respondent submits the answer is therefore officer complaint. Parties are really identified the respective counsel. ಇದು ಹಾಕಿದ್ದಾರೆ mediation.
Mediation ಅಲ್ಲಿ settle ಆಗ್ತದೆ. They agreed to pay sum of rupees 5 lakh, my lord. To DD.
Resolution, last time.
DD.
Xerox.
DD Xerox.
Xerox ಕೊಡ್ತಾರೆ.
I'm giving DD also.
ಅಲ್ಲಿ DD Xerox ಅಲ್ಲಿ ಇದೆ ಆಲ್ರೆಡಿ mediation.
Yeah.
rupees 2 lakhs.
5 lakh, my lord, out of 5 lakh, my lord, 3 lakh to the child, 2 lakh to the respondent.
3 lakhs for the child.
Valuables are exchanged. This history note. The name of the parties.
Vijay Kumarian,
Vijay Kumar.
Nandita GK.
His Vijay Kumar and his Nandita. ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್ಗೆ ಇದು ಬರ್ದಿರೋದು ಓದಿದ್ದೀರಾ ಇದ್ರಲ್ಲಿ ಬರ್ದಿರೋದೆಲ್ಲ ಮೀಡಿಯೇಷನ್ ಸೆಟ್ಲ್ ಬಂದು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿರೋದೆಲ್ಲ ಓದಿದ್ದೀರಾ ಡಿ ಕೊಟ್ರಾ ಈಗ ಬರೀ 2 lakhs 3 lakhs ಅಷ್ಟು ತಗೊಂಡು ಫೈನಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಮತ್ತೆ ಅವ್ರ ಮಗುನ್ ಬಂದ್ ಭೇಟಿ ಆಗ್ಬೋದು ಅಂತ ಹೇಳ್ತಾರೆ ಅವರೆಲ್ಲ ಪಾರ್ಟಿ ಇರೋರು ನೀವಲ್ಲ ಪಾರ್ಟಿ ಬಟ್ ವೆದರ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಹ್ಯಾಸ್ ಎನಿ ರಿಸರ್ವೇಶನ್
Sorry, my lord.
ಯುವರ್ ಕ್ಲೈಂಟ್ ಹ್ಯಾಸ್ ಎನಿ ರಿಸರ್ವೇಶನ್ ಫಾರ್ ಶಿ ಮೀಟಿಂಗ್ ದ
Illa, he is the only son to her. She is very much interested on.
We have given the visiting rights, that's why, my lord. We have given the visiting rights. Whenever they are asking, they come and see.
ಭೇಟಿ ಆಗ್ಬೋದು ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ನೀವು ಈ ಕೇಸಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ ನೀವು ಹಾಕೋದಲ್ಲ ಅವ್ರಿಗೆ ವಿಸಿಟೇಷನ್ ರೈಟ್ಸ್ ಕೊಡೋದಕ್ಕೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರಲ್ಲ ಈಗ ಮತ್ತೆ ಅಲ್ಲಿದ್ದ ನಿಮ್ಮ ಮಗನೇ ಹೋಗಿ ಒಪ್ಕೊಂಡು ಬಂದಿರ್ತಾರಲ್ಲ ಈಗ ಅಲ್ಲಿ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಮುಂದೆ ಭೇಟಿ ಆಗ್ಬೋದು ಪರ್ಮಿಟ್ ದೆಮ್ ಟು ಸಿ
ನಾವು ಯಾವಾಗ ಬಂದ್ರು ನಾವು
ಡಿಫರೆಂಟ್ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ಲವ್ ಮ್ಯಾಟರ್ಸ್ ಲಾಟ್ ಬಂದ್ರೆ ನಿಮ್ ಮನೆಗೆ ಬಂದ್ರೆ ಭೇಟಿ ಆಗೋದಕ್ಕೆ ಕೊಡಿ ಅಷ್ಟೇ
ಮಗು ಯಾವಾಗ ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ಅವಕಾಶ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ಒಂದು ಇದು
ಹೇಳ್ತಾರೆ
we agreed.
but they should maintain only that not other things but what these ladies will do sometime is they traverse beyond that ಅದು ಹಾಳಾಗೋಗ್ಬಿಡುತ್ತೆ ಎಲ್ಲ ಕೆಡ ಇಲ್ಲೇ ನೋಡಿ ನಿಮ್ನೆಲ್ಲರನ್ನು ಓವರ್ಟೇಕ್ ಮಾಡಿ ಮಾತಾಡ್ತಾರೆ ಅವರು ಪಾರ್ಟಿನ ಅಡ್ವೊಕೇಟ್ನ heard the there is a place that memorandum of settlement entered into by the parties before the mediation, Karnataka Mediation Center. Heard the parties on the memorandum of settlement. Parties admit due execution of memorandum of settlement and the terms of the same. Respondent admits that she has agreed for a dissolution of marriage on receiving the sum of 2 lakhs plus 3 lakhs as maintenance for herself and her child in full settlement of her claim. She admits DD ಕೊಟ್ಟಲ್ಲ the respondent admits the receipt of DD for a sum of this 2 lakhs and 3 lakhs as mentioned in para 3 of memorandum of settlement.
And also extend the gold ornament. Gold ornament also extend.
Party submit.
I have handed over.
That the gold articles as mentioned in para. Para 6 alva. 7. Para 7 of the memorandum of settlement are exchanged. ಇದು ಮೊದಲು ಅಲ್ಲ admits the terms of settlement ಅಂತ ಹೇಳೋದಲ್ಲ ಅಲ್ಲೇ the memorandum of settlement reads as follows ಅಂತ ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿಬಿಡಿ ಅದಾದ್ಮೇಲೆ ಮುಂದಿನ ತಗೊಳ್ಳಿ satisfied that the memorandum of settlement is admissible under law and the memorandum of settlement is voluntary one and admissible under law. Therefore, the same recording the same court passes the following order. One day appeal. You had filed only one appeal against 2 orders, no? 5876. ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರು ಎರಡು ಒಂದೇ ಜಡ್ಜ್ಮೆಂಟ್
ಒಂದೇ ಜಡ್ಜ್ಮೆಂಟ್
ಅಲ್ಲ ಇದರಲ್ಲಿ She has agreed to withdraw the cases also, no?
Yes, my lord.
Adams and
Deemed case has to be withdrawn.
Seems. The respond further admits and respond further admits that. Withdraw ಮಾಡ್ತೀನಿ ಅಂತಲೇ ಕೋಆಪರೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, withdraw ಮಾಡ್ತೀನಿ.
Paragraph number
4, my lord.
paragraph. She has agreed to
4,
withdraw
4.
criminal misdemeanor number 474 of 2022. ಎರಡಿದೆಯಾ 2017
ಇಲ್ಲ, execution ಒಂದು ಹಾಕಿ. 125 proceedings against execution.
as agreed in para 4 of the memorandum of settlement. The appeal is allowed. The support past the appeal is allowed. The improved judgment and decree in December 8 of 2022. Passed by the additional senior civil judge and James Chandrai Patna is hereby set aside. The petition in MC number 8 of 2022 is allowed in terms of the memorandum of settlement. Executed by the parties. Settlement date is there. Settlement date. Dated memorandum of settlement dated 29/1/2025, executed by the parties before the Karnataka Mediation Center. Bangalore is incidentally petition is allowed in terms of science. The marriage of the appellant and respondent solemnized on 19/2/2016 at Srimati Lalita Devanatha Kalyana Mandapa, Shravana Belgola is hereby dissolved. God is in Fine.
And then 58 also, that is also settled out of the court, serial number 58. Both the parties are present, my lord.
Okay. I thought here in particular you are in the other case. Where is your counterpart?
For the
Serial number 58. ಅವ್ರಿಗೆ ಒಂದ್ಸಾರಿ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಬಂದ್ರೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ಸಿ ಅಂತ. You are representing, no? ಅದೇ 51 ನಲ್ಲಿ advise your client if at all they want to see, let her see ಅಂತ. Yes, 58. Serial number 58.
Filing joining memo.
For withdrawal, no?
Settlement. Matter has been settled out of the court, my lord.
Vacating interim order memo for. What was the decree here? There it is. What was this? So wife's petition for restitution was allowed. Is that correct? Wife's
Yes,
petition
wife's
for
petition.
restitution of conjugal rights is allowed,
Yes.
and husband's petition for divorce.
Yes, yes, yes. My petition is the section 9 of Hindu Marriage Act that came to be allowed. And divorce petition filed by him dismissed. The matter has been settled, my lord. Now.
No other cases are pending in this.
No other. The DD has been given and the articles.
There, both of them are from West Bengal. Both of them are from West Bengal. Ranos CG Chakravarti. Is it? Payali Kundu.
Yes, by Alex. Please present.
No elders have come outside. Who has come with you? Any elders?
Any elders?
Correct. Come this side.
Come this side. Come here. You have nothing here, Kitty. Not enough.
Where are you staying? Oh, your father is? Yes. What are you doing in Bangalore? You are presently, where are you staying? In Forum. What are you doing here? What are you doing here? You are in employment. What is your educational qualification? Fine. Okay.
We tried our level best, my lord, to join him. He is not interested.
Okay, but it seems to be not from this place, that's why we.
Yes, my lord.
You have gone through the memorandum of settlement? Yeah, you have agreed for a divorce? What are the terms of the settlement? Can you tell us what is the term of settlement? What have you agreed for? How much? Okay, that's all, full settlement. So jewelries are exchanged now? Okay, you two have gone through this? You know the terms of this? You have agreed to pay 4.5 lakhs. You can go. So
Yes, ma'am.
there are no children in the marriage?
No children.
They don't have. Give her duty. Both parties. ಇದರಲ್ಲಿ 258 and 58. Both parties and the respective counsel are present. Parties are duly identified by the respective counsel. Parties present.
Aita.
Submit. Joint memorandum of settlement. Heard the parties on the memorandum of settlement. They admit the execution of the memorandum of settlement and the terms of the same. Respondent admits that she has agreed for dissolution of marriage and receiving rupees 4.5 lakhs from the appellant in full settlement of her claim towards permanent alimony. She further admits that she has received the demand draft as stated in para 5A of the memorandum of settlement and exchange of their gold jewelries. 5A, as stated in para 5B of the memorandum of settlement. The appellant also admits the receipt of the exchange of gold jewelries as mentioned in para 5 of the memorandum of settlement. Satisfied that the compromise between the parties is voluntary and admissible The law,
What she has.
since when they are staying separately? As since 2020.
2015.
It is
2015. 2015, my lord.
That parties are residing separately since 2015. Next. The these appeals arise out of the common judgment and decree in MC number 1110 of 2020 connected with MC number 2460 of 2020 by the improved judgment, the trial court has the trial court has dismissed the fiction of the husband, appellant hearing for dissolution of marriage and allowed the petition of respondent wife for execution of conjugal rights. In view of on hearing the parties and on perusal of the record, satisfied that there is no chance of union between the parties and memorandum of settlement is admissible under law. Therefore, the same is recorded. Recording the same, the court passes the following orders. And, the appeals are allowed. The MFA 60096, 23 and 88.
Lord, the marriage was registered also. Marriage certificate is also there.
Oh, right. But this can be intimated.
Okay.
Anyhow, this goes with in the decree. The judgment and decree passed by the third additional principal judge family court, Bangalore, in MC number 1110 of 2020 and 2462 of 2020 are hereby set aside. MC number 100, MC number 1110 of 2020 and MC number 2462. This has to be dismissed now and 2462 restitution.
Yes.
Is allowed in terms of the memorandum of settlement / compromise petition filed by the parties. The marriage of the appellant and respondent solemnized on 13/7/2014 at Basant Bahar Chowk Bazaar, Hooghly, West Bengal, is hereby dissolved by mutual consent in terms of the memorandum of settlement. MC number 2462 of 2020 is hereby dismissed.
Much of that.
No problem.
Signatures.
Come.
Take the signatures.
Yes, yes, yes.
Pending IS to dispose.
For further hearing. To number 40.
$51,000 tax is for the last time calculation ನಲ್ಲಿ tax deduction ಸ್ವಲ್ಪ mistake ಆಗಿದೆ.
ಇದ್ರದ್ದು ಅಷ್ಟೇ ರೆಂಟ್ ಒಂದು ಮೆಲೋಡ್ಸ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಕನ್ಸಿಡರ್.
Rent cannot
ರೆಂಟ್
be
ಅದು
considered.
ಬಿಟ್ರೆ ಬೇರೆ
ನಾವು tax 41,000 ಆಗುತ್ತೆ ಅನ್ಕೊಂಡಿದ್ವಿ, ಅದು ಅಷ್ಟಾಗೋದಿಲ್ಲ, ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 57,000 ಆಗುತ್ತೆ.
ಹೌದು.
ಅಲ್ಲಿ 6,60,000 ನಲ್ಲಿ ಎಷ್ಟು 57,000 ಕೆಳಗಡೆ ಎಷ್ಟು ಅವಾಗ ಸ್ವಲ್ಪ ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಬೇರೆ ಆಗುತ್ತಲ್ಲ. ಎರಡು ಒಂದೇ ಅದು ಹಾಗೆ ಮಾಡಿದ್ರೆ ಹಾಗೆ ಆಗುತ್ತೆ, ಈಗ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ ಔಟ್ಕಮ್ ಇಲ್ಗಿದೆ ಸೇಮ್. 6,60,000 minus 57,000. 6,03,000. ಡಿಡಕ್ಷನ್ 1/4 ಇತ್ತಲ್ಲ,
1/4 ಕರೆಕ್ಟ್ ಇದೆ.
ಸೊ ಇದ್ರದ್ದು 3/4 ಎಷ್ಟಾಗುತ್ತೆ? 4 lakh 52,250 into ಇಲ್ಲಿ ಮಾಡಿದ್ಮೇಲೆ ಸರಿ 64 ಮಾಡಿದ್ವಲ್ಲ. ಹಾ 4,52,250 into 11. 9 lakhs 24,007. ಇವಾಗ ಇದು ಎಲ್ಲ ಎಷ್ಟಾಗುತ್ತೆ ಅಂತ ನೋಡಿ. ರಿಗಾರ್ಡಿಂಗ್ point number 2 and 3. The quantum of compensation in MEC quantum of compensation in MEC number 90 and 11,050 and apportionment of the compensation to claimant number 4. Point. Please take. This case, the claimants contended that Shankar, deceased Shankar was carrying on granite business. In this case, claimants contended claimants contended that deceased Shankar was the proprietor of Vikas International, a proprietary concern, and he was carrying on the business of granites. It was contended that he was earning ₹1 lakh per month, which was disputed by the other side. To prove the income of the deceased, the claimants relied on the evidence of PW1 and PW3 and income tax returns of the deceased. The exhibit P13 ಹಾಕಿ ಸ್ಲಿಪ್ ಹಾಕ್ಬಿಡಿ. 2013-14 the income tax 17 ಅಲ್ಲ 17 ಅಂತ ಹೇಳಿ 13-14 date of accident is 2015 13-14 is reliable. ಸ್ಲಿಪ್ ಹಾಕಿದ್ದಿದ್ದಾನೆ ಇದೆ. ಇಲ್ಲ ಇದಲ್ಲ. Which income tax return last time?
17.
ಅಲ್ಲ
P17.
ಒಂದ್ರಲ್ಲೇನೆ P17 ಅಲ್ಲಿ have submitted more than one income tax returns. Now 2013-14 ಅಂತ ಹೇಳಿದ್ವಿ.
Last.
That is IPR.
Page number 38. Para 31.
We got 18. ಅಲ್ಲ ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದೆಲ್ಲ we saw one income tax return
Last 68, 67.
2012-13 submit assessment year 2013-14 yes. Notes ಇದೆ ಅಲ್ಲ?
32 ಇದೆ. 32. ಇಲ್ಲ 32 SBI account.
Exhibit number ಇಲ್ಲ ಇದಕ್ಕೆ. There is
40
no-
ಇದೆ ಸರ್.
Huh?
40 ದಿಂದ ಒಂದು.
Exhibit P14.
ಹೌದು 25 ಈ ಕೊಟ್ಟಿದ್ದಾರೆ.
14, 15. That is exhibit P39.
ಹ್ಮ್.
P39, correct?
ಎಸ್ ಶಂಕರ್.
Assessing ಸಂಜಯ್ ನಗರ್ ಒಂದೇ ಇದ್ರಲ್ಲೇನೆ ಮಲ್ಟಿಪಲ್ relied on exhibit P39, the income tax returns. The trial, the claimants also relied on exhibit P17, the income tax returns for the year 2014-15. The tribunal ಅದು 1 year ಮುಂದಿಂದ ರಿಲೈ ಆಗಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ನವರು.
13 in.
Relying on the evidence of Article 1 and 3 and the aforesaid documents and VAT registration certificate relating to the deceased, accepted the contention of the claimants that T. Shankar was dealing in granites under the proprietary concern Vikas International. Absolutely, there are no grounds to. Absolutely, there is no fault in the said finding. However, the trial court, the tribunal, in assessing the income of the deceased, relied on the income tax assessment, income tax returns for the assessment year 2013 and 14, which was submitted subsequent to the death of T. Shankar. As per the said document, his annual income was 6,62,916. Since the same was submitted subsequent to the accident, there is a chance of inflation. Therefore, it's not safe to rely on the same. Hence, the income tax return submitted by the deceased soon before his death, that is for the assessment year 2013-14, which is marked in exhibit P39, can be relied. As per the said document, the annual income of the victim was rupees 5,99,820. Put it there. 5,99,823. IT returns 2013-14. IT returns are 5,99,000. Right. Really 60,000 was rental income. Rental income. Rent received 2,40,000. Then deduct. This is on deducting the rental income. Exclude ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳಿದಲ್ಲ, ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕಂತ ಕಮಿಷನ್ ಇದು ಬರುತ್ತೆ, ಕಮಿಷನ್ presumptive profits, total income from business, correct? ಏನಂತ victim from his business and commission agency was rupees 5,84,478 and income from other sources like bank interest was 14,503. Therefore, his total income was 5,99,823. That can be rounded to rupees 6 lakhs. Deceased was aged, last time now 10%. Future prospects.
10%. 54
Age
years.
53 years, sir. 53 to 54.
Deceased was aged 54 years as per the judgment of 10% share. It's this.
Oh, the 10%.
Having regard to nature of his employment and as he was aged 54 years.
54.
In view of the judgment of Supreme Court in this case, 10% of his income has to be taken, granted towards future prospects. Therefore, his annual income would be 6 lakhs plus 60,000, 6 lakhs 60,000. It is material to mention at this stage that the income, while assessing the above income, the income received by the deceased towards rental income is not included, as the same is lost to the claimants on account of his death. She has admitted also. It's also material
Taking
to note that
25,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
PW1
PW1.
has admitted that she is receiving that rent even after the death of the deceased, death of victim. As per the Finance Act 2015, the tax payable on rupees 6,60,000 is 57,000. Therefore, his net his contribution to the family would be contribution. His income available to the family will be 6,60,000 minus 57,000 is equal to 6,03,000. As deceased had how many? 4 dependents, Allah? 4 dependents. 1/4 has to be deducted for his personal expenses in view of the judgment of Supreme Court in Sada or Mas case. Therefore, his contribution to his family would be 6,03,000 into 3/4 madi is equal to 4,52,250. Applicable multiplier is L1. Therefore, compensation payable on the head of loss of dependency is 4,52,250 bracket and bracket into L1 is equal to 49,74,750. In view of the judgment of the Supreme Court in Proceedings case and Magma Corporation, Magma General Insurance Company's case, the claimants are entitled to compensation of this 40,000 each on the head of consortium with escalation at 10%. Similarly, they are entitled to compensation of this 15,000 plus 15,000 with escalation at 10% on the heads of loss of estate and the funeral expenses. This is just compensation payable in these cases is as follows. Loss of dependency 49,74,750. Consortium 1,76,000. Loss of estate 16,500. Funeral expenses and transportation of dead body 16,500. Total is the total correct madadralla 51,83,750. Then minus ಮಾಡೋದು ಬೇಡವಲ್ಲ, modify ಮಾಡೋದ್ರಾಗುತ್ತೆ. Next madam. ಏನು ಕಾರಣನೂ ಕೊಟ್ಟಿಲ್ಲ ಅವರು, ಬರೀ 5% ಯಾಕೆ ಕೊಡ್ತೀವಿ ಅನ್ನೋದಕ್ಕೆ. Admittedly, claimant number 4 is the mother of the deceased and class 1 heir. ಯಾವುದು section 8 ಬರುತ್ತೆ.
8 ಪ್ರಕಾರ ಬರುತ್ತೆ. She is the first legal.
Under Hindu Section Act, she is entitled to equal share with the other claimants in the estate of the deceased. However, that tribunal without assigning any reasons has apportioned only 5% of the compensation to her. In a motor accident claim tribunal, the rights of the parties are not, though the rights of the parties are not, the rights of the parties are decided not on the basis of their entitlement under the succession law, but based on the fact of the dependency of the claimants on the deceased. Since widow and minor children are, since the dependency of the widow and minor children is higher as compared to claimant number 4, and considering the age of claimants number 1 to 4, and having due regard to the fact that due regard to the motherhood of claimant number 4, the tribunal should have apportioned 10% of the compensation to claimant number 4. Hence, these points need to be answered accordingly. Okay. Next, regarding compensation in MVC, please kutkol in MVC number 1978 of 2015. You know what answer. We have not worked it out on that day. We have not worked it on that day, no? This we have not worked it. Because age 35 years, salary 22,728.
That's correct. They have not challenged that quantum melody, only they have challenged contempt. Already melody hardship has said.
Last occasion, correct income tax correct.
In one case, quantum, they have not challenged quantum. Only melodies, the negligence, contempt negligence challenge, melodies are already has answered. Negative melodies.
The appeal memo note 2597. This is the MEC 1978.
1978, MEC 1978 2015.
Our 506. 5036 is 1978. Grounds of appeal alli negligence, 90% liability.
Don't do it, but considering to the income tax returns, it is just.
The higher side ಅಂತ ಹೇಳಿದ್ದಾರೆ
But
ಬಟ್ ಅದನ್ನ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಲ್ವಾ? ಆದ್ರೆ ನಿಮ್ ಕನ್ಸೆಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಲ್ವಾ?
Considering the documents, it is just and proper ಅಂತ ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡಿದೀವಿ ಅದು
6435.
ದಿಲಿಂದ್ರಲ್ಲಿ ಮಾರ್ಕ್
435.
ಫಸ್ಟ್ ಯಾವ್ದೋ ನೋಡ್ತಾ ಇದ್ನಲ್ಲ ಅದರಲ್ಲೆಲ್ಲ ನೋಟ್ಸ್ ಮಾಡಿ
6436.
In this case 1978 the claimants are the wife and
children.
Wife,
Mother is
son and mother of deceased Banu Prasad. They claimed that he was working under Shankar. Banu Prakash was working under T. Shankar in Vikas International and getting monthly salary of rupees 50,000 per month. Our income tax returns ಎಲ್ಲಿ ಕೊಟ್ಟಿರೋದು?
ಅದ್ರ 3 ವರ್ಷ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ತಗೊಂಡಿರೋ ಸರ್ ಅದಕ್ಕೆ ಅವ್ರು ಕೊಟ್ಟಿರೋದು
ಎಷ್ಟು ತಗೊಂಡ್ವಿ?
42,000.
ಲಾಸ್ಟ್ ತಗೊಂಡ್ವಿ ಅಷ್ಟೇ.
3 years
his income that claimants relied on exhibit P25 and 40 no?
Also
25 and 40 by declaring gross total of the income tax returns for the year 2011-12
13
12-13 25 ಎರಡೇ ಕೊಟ್ರು ಮತ್ತೆ ಇದನ್ನ
12-13
ಎರಡು 25 and 40 ಅಂತ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ 3 ವರ್ಷದ ಹೇಳ್ತಾರಲ್ಲ.
11 and 12, 12 and 13 and 14 and 15 ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. 3 ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ
ಬಿಟ್ಸ್ ಹೇಳೋದೇ ಬೇಡ. And 14 and 15 the tribunal took average of, considered average of the 3 years income tax. Based on that, assessed his monthly income at rupees 22,728 per month. There is no dispute of the fact that he was aged 35 years. 35 years. The insurer also seriously does not dispute the method adopted by the tribunal in assessing his income at rupees 22,728 per month. ಇದರಲ್ಲಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದೆ ಸರ್, 40% ಕೊಟ್ಟಿದೆ. ಯಾರ 53 ಅಲ್ಲಿದೆ.
50. And considering the age of the deceased and his employment and the judgment of the Supreme Court in Proceedings this case, referred to Supra, the tribunal rightly awarded future prospects at 40% of the income of the deceased and assessed his gross monthly income at rupees bracket 22,428 plus 9,091, 31,819. ಇದು ಟ್ಯಾಕ್ಸಬಲ್ ಲಿಮಿಟ್ ಅಲ್ಲಿ ಬರೋದಿಲ್ವಾ? ಎಷ್ಟು ಮಾಡಿದ್ರೆ
ಇವ್ರು ಬರೋದಿಲ್ಲ. 20
ಬರೋದಿಲ್ವಾ?
2 lakhs.
ಅಲ್ಲಿ ಎಷ್ಟು 31,819 into 12 ಮಾಡಿ 819. 3,81,000. 2,50,000 ಕರೆದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಬರುತ್ತೆ ಅದ್ರೆ.
But my lords, up to now ಇವಾಗಂತೂ ಬರೋದೇ ಇಲ್ಲ because up to 12
ಈಗಲ್ಲ ಅವಾಗಿನ ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲ.
ಅವಾಗ್ಲೂ 5 lakh ಇತ್ತು. up to 5 lakh
ಎಕ್ಸಾಂಪಲ್ 2,50,000 ಇತ್ತಲ್ಲ. ಅದು ನಾವು ಬೆಟರ್ ಅಂತಂದ್ರೆ ಲಾಸ್ಟ್ ಇಯರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಎಷ್ಟಿರುತ್ತೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮಾಡ. 70,000 ಇರ್ತದೆ ಲಾಸ್ಟ್ ಇಯರ್. ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ನಲ್ಲಿ ಅಡಾಪ್ಟ್ ಮಾಡಿದ್ದೆ, ಈ ಕೇಸ್ ನಲ್ಲಿ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೋಬಹುದು. ಇಷ್ಟೆಲ್ಲ ಹೇಳಕ್ಕಿಂತ
3 lakhs.
previous case ನಲ್ಲಿ we took the income tax returns which was submitted by him soon before his
may
death.
be considered my lords. Last year ತಗೊಂಡ್ರು ಲಾಸ್ಟ್ ಇಯರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ತಗೊಂಡ್ ಮಾಡಿದ್ರು
ಸುಮ್ನೆ ಬರ್ಸಿದ್ರು.
3,81,828 ಬರುತ್ತೆ.
3 lakh
2014-15 ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲೇ ಸಾರಿ ಅಂದ್ರೆ ಸುಮ್ನೆ ಅನ್ನೆಸೆಸರಿ ಕಾಂಪ್ಲಿಕೇಶನ್ ಆಗುತ್ತೆ ಇದರಿಂದ.
2014-15 ಅಲ್ಲಿ
ಅದು
ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರಿ ಸರ್.
ನೋಡೋಣ ಇಲ್ಲ 2012-13 ಅದು 2,37,849 ಇತ್ತು. ದಟ್ ವಾಸ್ ವಿದಿನ್ ದ ಎಕ್ಸಮ್ಟೆಡ್ ಲಿಮಿಟ್ಸ್. ದಿಸ್ ಇಸ್ ಎಕ್ಸಿಬಿಟ್ P25 40 ಇರ್ಬೇಕು. 39 ಇತ್ತಲ್ಲ, ಇನ್ನೊಂದು 40 ಇರ್ಬೇಕು. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎನಿ ಆಫ್ ದೆಮ್ ಜಾಯಿನ್ ಟುಗೆದರ್ ದೇ ವರ್ ಮಾರ್ಕ್. ಇದೆಲ್ಲ ಮಾಡ್ಕೋಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ ಶಂಕರ್ ಇಲ್ಲಿವರೆಗೂ P40 ಅಂತ ಬರ್ಕೊಳ್ತಾರೆ. ಆದ್ರೆ P40 1011 ಶಂಕರ್ ಇದು IT returns from
25 ಇವರು ಭಾನುಪ್ರಸಾದ್.
ಒಂದು ನಿಮಿಷ ನೋಡಂತ. ಇಲ್ಲಿ ಭಾನುಪ್ರಸಾದ್ 2009 ಅದು ಬೇಡ ನಿಮಗೆ.
14-15 ತಗೊಂಡ್ರೆ ಸಾಕು.
8-9 ಅದು ಬೇಡ.
P25 ನೋಡಿದ್ರೆ ಸಾಕಾಗುತ್ತೆ.
Okay.
14 ತಗೊಂಡ್ರೆ.
1011 it was submitted.
14-15
ಅದು 12-13 ಅದು ಮಾಡೋಣ. All 13 submitted in 2012. ಇದು 1/12/2015 ಸೇಮ್ ಅಲ್ಲಿ ಮಾಡಿದಂಗೆ ಮಾಡಿದ್ದಾರೆ 11/12 ಇವ್ರದಲ್ಲಿ 13/14 ಇದ್ದಂಗೆ ಕಾಣ್ತಾ ಇದೆ 11/12 ಇದೆ 11/12 his income was 2,37,849 ಅದನ್ನೇ ತಗೊಂಡ್ ಮಾಡೋಣ ಹಾಗಿದ್ರೆ
2,10,000.
it is submitted after his death 1/12/2015 ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ತೋರಿಸುತ್ತೆ ಜಾಸ್ತಿ ತೋರಿಸಿದ್ದಾರೆ 14/15 ಅಲ್ವಾ ಇಲ್ಲಿ 1/12/2015 ಇನ್ಕಮ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ 3,70,28 ಮಾಡಿದ್ದಾರೆ ಇದನ್ನೆಲ್ಲ ಹಿಂದೆ ಅದನ್ನ ನೀವು ಮಧ್ಯದ್ದು ಏನು ಸ್ಯಾಲ್ರಿ ಎಲ್ಲ ಹೇಳಿದ್ವಲ್ಲ ಅಲ್ಲಿಂದ ಟೈಪ್ ಮಾಡಬೇಡಿ ನಿಮ್ಗೆ ಅನ್ನೆಸೆಸರಿ ಅದು ವಾಸ್ ವರ್ಕಿಂಗ್ ಅಂಡರ್ ಹಿಮ್ ಸೊ ಅಂಡ್ ಸೊ ಅದೆಲ್ಲ ಇರಲಿ ವಾಸ್ ವರ್ಕಿಂಗ್ ಅಂಡರ್ ಸೊ ಅಂಡ್ ಸೊ ಅಂತ ಹೇಳಿ ಈಗ ಅದು ಅಲ್ಲಿಂದ ಮುಂದೆ ಈಗ ಹೊಸದಾಗಿ ಬರ್ಕೊಂಬಿಡಿ ಅದೇ ಮಧ್ಯದ ಟೈಪ್ ಮಾಡಬೇಡಿ ಆಸ್ ಪರ್ the income tax return for the year 2011-12 for the assessment year 2000 ಇದರಲ್ಲಿ 13-14 ಕಾಣ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ ಇದರಲ್ಲಿ
12 and 13 and 14 and 15 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
14 ಹಾಕಿದ್ದಾರೆ.
ಹಿಂಗೆ as per exhibit P40 the income tax returns the deceased had submitted his income tax returns for the year last income tax returns for the year 2011-12 for the assessment year 2. Thereafter, the income tax returns were submitted for the assessment year 2014-15 on 1/12/2015. That is after the date of the accident. Therefore, the income declared under the for the assessment year 2011 and 12 has to be for the assessment year 2012-13 for the financial year 2012-13 has to be considered as per the said returns. His annual income was 2,37,849. ಈಗ ಇದ್ರ ಪ್ರಕಾರ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಏಜ್ ಇಸ್ 40% ಬರುತ್ತಲ್ಲ
40%.
3 lakh 2 lakh 2,35,020 ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ 2,35,000 ಎಷ್ಟಂತ ಇದೆ ಇನ್ಕಮ್ ಇಲ್ಲ ಇಲ್ಲಿದೆ 2,35,000 ಇದು ಮಾಡಿ ಟೋಟಲ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಇದು ಟೋಟಲ್ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಸೀಲಿಂಗ್ ಅಂತ ಅಲ್ಲ ಲೈಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಫೈನ್ಸ್ ಹಂಗಂದ್ರೆ 2,37,000 ಅದನ್ನ ಒಂದು ರೌಂಡ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅದನ್ನ 2,37,000 2,38,000 which can be rounded to 2,38,000. Having regard to the age of the deceased and his employment, 40% has to be added to the same by way of future prospects. The 40% is 95,200. 95,200. Thus his total annual income will be 200. 3,33,200. As he had 3 dependents, you would go to 1/3 ಬರುತ್ತೆ ತಾನೆ ಅಲ್ಲ 1/3 ಬರುತ್ತೆ 1/3 as he had 3 dependents 1/3 has to be deducted towards his personal expenses and 2/3 will be his contribution to the family 33,200 into 2 upon 3 2,22,000 which comes to rupees 2,22,133.33 2,22,133 around it to 2,22,200 ಮಾಡಬಹುದು 200. In this case also the claimants are entitled to compensation of this 40,000 each on the head of loss of consortium. Okay, in this case with escalation at 10%, similarly they are entitled to compensation of this 15,000 plus 15,000 with escalation at 10% on the head of loss of estate and funeral expenses. Therefore, just compensation payable in this case is just 3 ಜನ ಇದಾರಲ್ಲ ಡಿಫರೆನ್ಸ್ ಎಷ್ಟು 1,32,000 1,32,000 ಬರ್ತದೆ Loss of dependency, 2,22,200. Consumption. Multiplier. Oh, sorry.
16 multiplier is 16.
Sorry.
16 birth.
Sorry. Applicable multiplier is 16, huh?
16 birth.
Correct, yeah?
Correct.
Age
Correct.
is 36. He was 35.
ಹೌದು.
Applicable multiplier is 16, therefore the compensation payable on the head of loss of dependency is 2,22,200 into what is 16? Into 16. This so ಎಷ್ಟಾಗುತ್ತದೆ ಟೋಟಲ್?
55,200.
ಎಷ್ಟಾಗುತ್ತೆ?
35,55,000.
25 lakhs 50
55,200.
1,32,000
33,000.
plus 33,000.
37,20,200.
37 lakh
20,200.
20,200. ಅವಾರ್ಡ್ ಮಾಡಿದ್ದು ಎಷ್ಟಿದೆ ಇದರಲ್ಲಿ?
40 lakh.
40 lakhs. ಕಡಿಮೆ ಆಯ್ತಲ್ಲ?
ನಮಗೆ ಕಡಿಮೆ
ಅಲ್ಲ 42 ಡಿಪೆಂಡೆನ್ಸ್.
ಒಂದು ನಿಮಿಷ. ಒಂದ್ರಲ್ಲಿ 70 lakhs ಆಗಿತ್ತು 1900 ಅಲ್ಲಿ ಕಡಿಮೆ ಆಯ್ತಲ್ವಾ? ಅಲ್ಲಿ 51,83,750 ಆಗಿತ್ತಲ್ಲ, ಕರೆಕ್ಟಾ? ಅಲ್ಲಿ ಅವ್ರು 70 lakhs ಕೊಟ್ಟಿದ್ರು, ಎರಡರಲ್ಲೂ ಕಡಿಮೆ ಆಗುತ್ತೆ.
ಹೌದು.
ಇದರಲ್ಲಿ 42,23,300. ಸೊ ಅಪೀಲ್ಸ್ ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್ ಆಗುತ್ತೆ. The enhanced compensation shall carry interest at
6% ಇದೆ.
ಬರೀ ಇನ್ಕಮ್ ಅಲ್ಲಿ ಮಾತ್ರ ವ್ಯತ್ಯಾಸ ಆಯ್ತಲ್ಲ?
ಅಷ್ಟೇ ಬೇರೆ
ಇಂಟ್ರೆಸ್ಟ್ at 6% per annum. ಅಲ್ಲ ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ.
ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ಅವ್ರದ್ದು
ಫಸ್ಟ್
ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಅಲ್ಲ
ಪಾರ್ಟ್ಲಿ
ಆಗುತ್ತೆ, ಪಾರ್ಟ್ಲಿ ಅಲೋ ಆಗುತ್ತೆ. 40 ಅಲ್ಲ, ಮುನ್ನೆಮ್ಮ ಅವ್ರದ್ದು ಅಲೋ ಆಗುತ್ತೆ, ಇವ್ರದಿಬ್ರದ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಪಾರ್ಟ್ಲಿ ಅಲೋ ಆಗುತ್ತೆ.
ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಪೀಲ್ಸ್ ಡಿಸ್ಮಿಸ್.
ಯಾವ್ದ್ರಲ್ಲೂ ವೇರಿಯೇಷನ್ ಆಗಿಲ್ವಲ್ಲ ಈಗ ಕ್ಲೈಮೆಂಟ್ಸ್ ಎನ್ಹಾನ್ಸ್ ಎಲ್ಲೋ ಆಗಿದೆ. ಫಾರ್ ದ ಅಪೋಸಿಟ್ ರೀಸನ್ಸ್ the appeals of the insurer and claimant number 4 in MEC number 1911 of 2015 deserve to be allowed in part, and the appeals of claimant number 1 to 3 in MEC number 1911 of 2015 and 1978 of 2015 deserve to are liable to be dismissed. Hence the following order. MFA number 6435 of 2021 and MFA number 6436 of 2021 are dismissed. MFA number 2597 of 2021, MFA number 4977 of 2021 and MFA number 5036 of 2021 are partly allowed. The award in MEC number 1911 of 2015 is modified as follows. Correct ಆಯ್ತಲ್ವ? ಅವಾಗ ಎಲ್ಲ the claimants are entitled to compensation of this 51,83,750 with interest thereon at 6% per annum from the date of the petition till its realization. The out of the compensation amount, claimant number 4 ಇದೀಗ ಮತ್ತೆ ರೀಡು ಆಗ್ಬೇಕಾಗುತ್ತಲ್ವಾ ಅವ್ರದ್ದು ಮಕ್ಕಳದನ್ನು? Children it will be reduced for the children otherwise.
ಇವರು 5% ಅಲ್ಲ ಸರ್ ವೇರಿಯೇಷನ್ ಆಗುತ್ತೆ. 5% ಇಂದ 10% ಆಗ್ತಾ ಇದೆ.
ಆ 5% ಯಾರಿಗಾದ್ರೂ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಇಲ್ಲಿ ವೈಫ್ ವಾಸ್ ಗಿವನ್ 55%, ಅಲ್ಲಿ 50 ಮಾಡಬಹುದು.
ಅಲ್ಲಿ 50
Each of them will get 50 plus 2020.
20, 50 and 10 odd.
Out of the compensation amount, claimant number 1 to 4 are entitled to, out of the compensation amount, claimant number 1 to 4 are entitled to compensation amount in the ratio of 50%, colon haki, 20%, 20%, and 10% respectively. The award in MVC number 1978 of 2015 is modified as follows. The claimants are entitled to compensation of rupees 37,20,200 with interest thereon at 6% per annum from the date of the petition till its realization. The award of the tribunal in MVC number 1978 of 2015 with regard to apportionment is maintained. Further, the award of the tribunal with regard to apportionment of liability of liability and the rest of the contributory negligence is confirmed. Respond number 2 in MVC number 1911 of 2015 and respond number 2 and 4 alla innond case alli 2 and 4 in MVC number 1978 of 2015 shall deposit the compensation amount on adjusting the amount already deposited, if any, before the tribunal in the at the ratio of ಎಷ್ಟು ಇಲ್ಲಿ ನಿಮ್ದು ಮೇಲಿಂದ್ರಲ್ಲೂ 90% ಆಗುತ್ತೆ ಒಂದು ಕೇಸಲ್ಲಿ
ಅಲ್ಲಿ ಓನರ್ ಮೇಲೆ ಫಿಕ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ಮೆಲಾಟ್ಸ್ ಒಂದರಲ್ಲಿ ಓನರ್ ಮೇಲೆ ಆಗಿರೋದ್ರಿಂದ ಇವ್ರು 90% ಕಟ್ತಾರೆ. ಇನ್ನೊಂದರಲ್ಲಿ ಮೆಲಾಟ್ಸ್ ಅನದರ್ ಇನ್ಶೂರೆನ್ಸ್ ಆಲ್ಸೋ ದೇರ್ ದೇ
ಅವ್ರು ಕಟ್ತಾರೆ. ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಕೂಡ ಅವ್ರು ಬಿಕಾಸ್ ಈ ಹಿಮ್ಸೆಲ್ಫ್ ಆಸ್ ದ ಡ್ರೈವರ್ ಅಲ್ಲ, ಅದೇ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಇನ್ಶೂರೆನ್ಸ್
the claimants in respond number 2 in MVC number 1911 of 2015 shall deposit. ಇದು entitled to ಇಲ್ಲೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ, ನಾವು ಅದ್ರ 10% ಕಡಿಮೆ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಈ 51,83,750 ಅಲ್ಲಿ 10% ಡಿಡಕ್ಟ್ ಮಾಡಿ ಮಾಡ್ಬೇಕಿತ್ತು.
ಇಲ್ಲ ಇವ್ರು ಅದು ಬರಲ್ಲ. ಅಲ್ಲಿ 90 ಔಟ್ ಆಫ್ ಮೈ ಲಾಟ್ಸ್ 51 lakh
90% himself as the driver ಅಲ್ಲಿ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ ಅಲ್ಲಿ ಡಿಡಕ್ಟ್ 10% ಡಿಡಕ್ಟ್
ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ, ವಿಲ್ ಕರೆಕ್ಟ್
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಹ್ಯಾಸ್ ಟು ಡೆಪಾಸಿಟ್ 90% ಅಲ್ಲ
83,000 ಎಷ್ಟಾಗುತ್ತೆ ಅಂದ್ರೆ 5,18,000 372 ಅದನ್ನ ಮೈನಸ್ ಮಾಡಿ 51,83,750 ಅಲ್ಲಿ
46,65,380.
46,65,380 ಅಲ್ಲಿ ಒಂದು ಕೆಲಸ ಮಾಡಿದೆ. ಫಸ್ಟ್ 1911 ನಲ್ಲಿ ಟೇಬಲ್ ಹಾಕುವಾಗ 51,83,750 ಅಂತ ಹಾಕಿದ್ವಲ್ಲ, ಅದ್ರ ಕೆಳಗಡೆ ಮೈನಸ್ ದ contributory negligence on the part of the deceased ಅಂತ ಮಾಡಿ 5,18,372 ಮಾಡಿ compensation payable 46,65,380 ಮಾಡಿದ್ದ. ಇಲ್ಲಿ MVC number the award in MVC number 1911 of 2015 is modified as follows ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, ಅಲ್ಲಿ claimants are entitled to compensation of this 46,65,380. So I'll correct the order. ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಷೀನ್ ಅದ್ರ ಜೊತೆಗೆ the claimant 1911 ಅದು ಮುಗೀತಲ್ಲ. In MVC number 1978 of 2015 respond number 2 and 4 and shall deposit
90% and
the
10%.
compensation at the ratio of
90 and 10%.
ಅವ್ರು ಅದ್ರಲ್ಲಿ 4 ಇದಾರೆ ಅವರ ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ they are 4 10 and 90 10 is to 90% 10 is to 90% respectively and adjusting the amount already deposited if any, the amount in deposit if any and the TCR shall be transmitted to the tribunal. we'll edit that ಸ್ವಲ್ಪ ಇಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ because the notes is there. Correction ಮಾಡೋದು.
For final disposal, seal number 41, B.S. Sumesh, Vikketi Gorge Prasad.
Where is Umesh?
ಅದ್ರಲ್ಲಿ ಒಂದ್ ಅಪೀಲ್ ಅವ್ರದ್ದಿದೆ, ಒಂದ್ ಅಪೀಲ್ ನಮ್ದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
ಇದರಲ್ಲಿ withdrawal application is pending.
ಹೌದು.
Date of accident is
29/12/14.
Hmm. 29/12/2014.
ಹೌದು.
ಅವ್ರದ್ರಲ್ಲಿ ಏನಾರ ಇದ್ರನ್ನ ಸಿನಾಪ್ಸಿಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದಿದಾರ ನೋಡಿ ಇದ್ರಲ್ಲಿ ಸರಿ ಇಲ್ಲ. 29/12/2014.
Three vehicles involved in the accident.
One motorcycle wearing registration number ones. Tata Ace vehicle number.
The deceased was
A.
deceased was riding the motorcycle and he stopped near the intersection junction. This Tata Ace came and dashed against him. He fell down. Immediately
He fell down,
Ah.
sustained grievous injury.
Tata Sumo
Vehicle ಯಾವ್ದು?
Tata Sumo came from his behind on the wrong side and ran over him.
ಇದರಲ್ಲಿ issues ನೋಡುವಾಗ ಏನ್ he was riding a motorcycle at that time. One Tata Ace bearing number K13 A518 came in a rash and negligent manner, hit him ಅಂತ ಇದೆ.
ಹೌದು.
He fell down and sustained injuries.
Such simple injuries. Immediately the Tata Sumo came and dashed him, causing head injury.
Issue ನಲ್ಲಿ
On the way to the hospital, he succumbed to the injuries.
ಬಹುಶಃ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
It is a case of composite negligence.
Meanwhile, so two Tata Sumo.
ಅಲ್ಲ, ಒಂದು Tata Sumo, ಒಂದು Tata Ace.
Tata Ace and
Yes.
two four wheelers. Two four wheelers and one two wheelers. One two wheeler.
Scooty,
So charge sheet was filed against whom?
both the drivers.
Both drivers. The tribunal is finding
They say it's a case of composite negligence. It does not give the.
60-40 ಮಾಡಿದಾರಾ?
ಇಲ್ಲ.
Entire
Giant.
composite negligence ಮಾಡಿದ್ರು.
ಎಲ್ಲ ಪೂರ್ತಿ composite negligence, joint and several ಅಂತ ಮಾಡಿ.
I can proceed against any one of the tortfeasor and recover ಅಂತ ಮಾಡಿ.
That is.
I can proceed anyone ಅಂತ ಹಾಗೆ ಮಾಡೋದು incorrect ಅಂತ
That's the-
ಅನ್ಸುತ್ತಲ್ಲ?
ಅಲ್ಲ, that is on the basis of the Supreme Court judgment.
Tata Ace did not held a valid insurance as on the date of.
Insurance ಇಲ್ಲ ಅನ್ನೋ ಒಂದೇ ಕಾರಣಕ್ಕೆ
no.
entire negligence is settled on me.
He was
That is-
included as an insurer of the Tata Ace.
ಅವ್ರು
He
evidence
took up a
ಮಾಡಿದ್ರು.
contention saying that the policy was not valid as on the
ಹಾಗಾಗಿ
date of accident.
Why policy was
Policy had
It
expired much
expired
prior to the date of accident.
date of accident?
It was not renewed. So the insurer, Tata Ace insurer we have exonerate ಮಾಡಿ.
ಅಲ್ಲ ನಿಮ್ಮನ್ನ exonerate ಮಾಡಿದ್ರೆ ಓನರ್ ಮೇಲೆ ಹೋಗ್ಬೇಕು.
ಹೋಗ್ಬೇಕು, but the principle applied by the tribunal is on the basis of the Supreme Court
That is not
judgment.
correct.
Taken.
Yes,
So this is the crux of the matter.
yes, yes.
About quantum ಮೇಲೆ?
Quantum value, quantum value.
I taken.
Quantum value ನಾನು ಚಾಲೆಂಜ್.
Yes.
Your Lordship will kindly see, as Manad just noticed, the initial impact is between Tata Ace and the scooter.
Yes.
Now, my other friend contended just now that it is Tata Sumo which ran over the.
Hmm. Yes,
No, my lord. The complaint is lodged by my lord. One. Keshav Prasad. My lord, he is a co-employee, my lord.
now the tribunal also said that both of them are negligent.
Yes, ma'am. But in fact, I'll come to that. my lord. The tribunal holds, my lord, it does not give composite negligence principle apply ಮಾಡಿ. All the my lord, owner and the Tata Sumo and its insurer are held jointly and severally liable.
So one hit and one ran over.
That is their case. ma'am. I'll come to that. That is
Oh,
basically
that's also not admitted.
not.
So involvement of the vehicle itself is disputed,
No, I'm not disputing the involvement of the vehicle.
but negligence.
Yes, ma'am. It's
So
absolutely.
yours is which Tata is or Tata
Tata
Sumo?
Sumo.
Tata Sumo. K41, no?
Yes.
K41,
A30.
K3034.
Yes, ma'am.
3034.
My lord, Tata yes number, NID that number.
K13, A5128. A2. Yes,
My lord, the exhibit P1 is the complaint. P1 is the,
first PW1 is one of the victims.
he is one of the
Whom they have
co-employees.
examined?
My lord, the
PW1 is claimant number 1.
claimant number 1, my lord. No other witness is examined.
PW1 claimant number 1.
One, as far as
But she is not eyewitness.
he is not, she is not, she admits she is not.
PW2,
My employer. He is also not there.
ಅದೇ income prove ಮಾಡೋದಕ್ಕ?
That's it. That's it.
Jose Matthew, employer.
Yes.
Employer
No, he
official.
is the HR of the company.
Employer's staff.
Yes. Yes.
They have examined. ಮತ್ತೆ ಯಾರನ್ನಾದ್ರೂ
P1 complaint of Milad Mukherjee.
ನಿಮ್ ಕಡೆಯಿಂದ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀರಾ?
Milad, we have examined
Take
the
a witness mapping.
investigation officer.
RW1 is
Investigation officer, Milad.
investigation officer of insurance.
Yes. And
RW2,
my employee.
employer.
RW3 is the employee, Milad, employee of the other insurance company.
ನಿಮ್ಮ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವುದು ಇದರಲ್ಲಿ?
RW2 is my Vasundhara.
Claim petition ಅಲ್ಲಿ
Oriental is the claimant, appellant.
you represent Orient.
Yes.
So RW1 is
RW1
the
is the
investigating officer of respond
Yes,
number
sir.
4.
Investigation officer of the
R4.
police investigation officer.
Police I want.
Yes, ma'am.
Not in,
Police officer.
in internal investigation.
I'm sorry, police officer. Police officer.
I go in CC.
I would have used, yes. I should have used.
So this RW2
He
is
is my, one of my,
employee of,
yes, ma'am, appellant. Insurance official. Official,
that is respond number 4.
yes. RW3 is the
RW3 is
the official of the other insurance company.
employee of Tata is
Yes.
of R2 insurance. ನಿಮ್ದು ಓರಿಯೆಂಟಲ್ ಅಲ್ವಾ? Yes. Exhibit P1.
PW1 is not the eyewitness. No, my lord, the complaint is, as I said, my lord, is lodged by one Keshav Prasad. PW, exhibit P1 may tell you.
Yes.
May,
P1 is FIR.
FIR jotane written complaint to us. P1 A.
P1 is. Yes. What?
With reference to the above subject, I am working in
Design.
KT Systems Private Limited as a software engineer. Today at about 10:30 PM, I received a message from my colleague regarding Mr. Senthil Nathan involved in the road traffic accident in front of land Infotech company. Immediately I reached the spot, found my colleague Mr. Senthil Nathan lying on the road and injured in the accident.
Then 108 ambulance staff shifted the.
Vide hospital.
Yes, sir. After I heard one Tata is similar, he says, I heard one Tata is number so and so. A is equal to A518. This is the number of Tata is here. Driver drove his negligence in a rational negligent manner from the Marriott Hotel towards KTPO, in junction on LNT Road and hit to my colleague. Change in Honda Activa number so and so, who is coming from KTPO towards LNT also. Tata Sumo number, driver drove his way in a rational negligent manner from KTPO towards LNT and hit from the back to the Honda Activa. This is what he has heard, my lord. This is the complaint.
His version is also hearsay.
As a result, Honda Activa rider by name Saint Nathan fell down on the road along with the Honda Activa and sustained injuries to his head and after please take necessary action. He is also not trying with this, my lord. Now, my lord, I have examined the police investigation officer, my lord, may kindly. Before that, my lord, probably the sketch may kindly be taken, my lord. Exhibit P2A. My lord, got it?
Yes.
My lord, your lordship may kindly see. Tata Ace is coming on the main road. And my lord, its path is towards, it has turned to the left. Now, my lord, Honda Activa is coming towards the main road. My lord.
That is 413034.
Yes, Honda Activa is coming towards the main road. My lord, my vehicle may kindly be seen, nothing on the extreme left side, Tata Sumo.
Tata Sumo. Nim gadi number ishto?
My lord, 41A3034. In between the lord, KA034.
This disease was coming from which side to which side?
Tata Sumo and Honda Activa are on the same road, partner.
Same.
They were in, yes.
So this Tata Sumo was coming
On the left of the.
back side. On
It
the
is
back
on the
side.
left side of the motorcycle. Even the path shows, my lord, it is on the left side. Now, my lord.
Yes.
Now, my lord, may come to the IMA report. Exhibit 1.
Page number, sorry, P5. Yes.
3 vehicles, separate market, KA041A3034 is Tata Sumo. KA30A5182 is Tata Ace. Second vehicle. Third vehicle is motorcycle.
9386 is the motorcycle.
That's right. 9386. Milad may kindly see the damages caused to the Tata Sumo.
Yes.
Front right side door damaged. Milad may kindly notice. It is not the front portion, Milad.
Your vehicle.
Yes, ma'am. My vehicle door is damaged. And then, Milad, front right side fender damage. Front of the fender, Milad knows is above the wheel. Fender. That is damaged.
Yes.
Milad, now Milad will come to the now Milad, as far as Tata is concerned, there is absolutely no doubt, Milad, he is commenting today. Now Milad, the other vehicle. Scratches found on the right side, front right side.
That is Tata is.
Motorcycle. Tata is the Milad that doesn't come to picture. There is no doubt. Yes.
Front right side of shape.
How? No, Milad. The entire theory of My lord, the Tata Sumo hitting the two-wheeler from that side is totally false.
So there was no damage to that motorcycle from behind the side.
Yeah, not only that, my lord, it should be read coupled with the damages to the front portion of the Tata Sumo. There are no damages. It is on the, my lord, what has happened is, my lord, the sketch, my lord, just now found. It is on the left side. He has come and hit the motorcycle. The motorcycle has fallen on my. And naturally, my lord, right side door is damaged because it has fallen from this side. And my lord, your lordship also may kindly see, it is the fender and the door, not the bumper. Absolutely, my lord, Tata Sumo front has not in.
Charge sheet is exhibit?
Charge sheet, my lord, I need.
P12. ಅಲ್ಲೇನ್ ಹೇಳಿದ್ದಾರೆ?
ಅದರಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಹೊಡಿತು ಅಂತಾನೆ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಹಾಗೆ ಇದೆ, ಅಲ್ಲೂ ಹಾಗೆ ಬಂದಿದೆ. ಅದಕ್ಕೆ ನಾನು ಒಂದ್ ನಿಮಿಷ ಬಿಟ್ರೆ ಅವ್ರ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀನಿ ಈ ಕಾರಣಕ್ಕೆ.
Any person is shown as ಐ ವಿಟ್ನೆಸ್. ಏನು ಇದು ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ವೈಫ್ ಅನ್ನು ಸಿಂಧು.
ಇಲ್ಲ ಸರ್, ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರ ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಕಾಣ್ತೀನಿ. And one Praveen Kumar is shown as eyewitness. Jay Kumar is shown as eyewitness. ಮೂರು ಜನರನ್ನ eyewitness ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಅದು ಸುಳ್ಳು ಅನ್ನೋದಕ್ಕೆ ಅವರು ಐವನೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಯಾರು ಐವಿಟ್ನೆಸ್ ಸಿಕ್ಕಿಲ್ಲ ನನ್ಗೆ ಅಂತ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
Their driver is examined.
ಅಲ್ಲ, ಐವೋ has said I have not examined any eyewitness. Also, I will come to that. ಅದು ತಾವು ಚಾರ್ಜ್ ಶೀಟ್ ಅಂತ ಕೇಳಿದ್ರೆ your lordship may see that. Then I will take my lord to the ಐವೋ's evidence.
You want to read IVO's evidence?
Yes.
Yes,
Now, my lord, we come to
RW.
1. I've got it 27/6/2016. ನಾನು ವೈದ್ಯನಾಥ
ಯಾರಿಗೆ ಯಾವ ರೀತಿ ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ದಾರೆ. RW2 ಅಲ್ಲ?
RW1.
Yes.
ನಾನು 2013-14 ಟ್ರಾಫಿಕ್ ಪೊಲೀಸ್ ಆಗಿ ವೈದ್ಯದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೇನೆ. ನಾನು ಅಪರಾಧ ಸಂಖ್ಯೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾನೇ ತನಿಖೆ ಮಾಡಿರುತ್ತೇನೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಒಬ್ಬ ಕೇಶವ ಪ್ರಸಾದ್ ಎನ್ನುವರು ಫಿರ್ಯಾದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದರು. ಅದನ್ನು ನಾನು ದಾಖಲು ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. 29/12/24 ಕಾಣಿಗಳಿಕೆ ಬೆಳಗ್ಗೆ 11:30 ಗಂಟೆಗೆ ದೂರನ್ನು ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಟಾಟಾ ಎಸಿ ವಾಹನ ಸಂಖ್ಯೆ ಇದರ ಟಾಟಾ ಸುಮೋ 2 ವಾಹನಗಳ ಚಾಲಕ ಅಧಿಕ ವೇಗ ಮತ್ತು ಜಾಗರೂಕತೆಯ ವಾಹನ ಚಲಾಯಿಸುತ್ತಿದ್ದು ಮೃತನ ಹೋಂಡಾ ಆಕ್ಟಿವಾ ವಾಹನಕ್ಕೆ ಜಂಕ್ಷನ್ ನಲ್ಲಿ ನಿಂತಿದ್ದ ಡಿಕ್ಕಿಪಡಿಸುತ್ತಾರೆ. ಟಾಟಾ ಎಸಿ ಚಾಲಕನ ಪಡಿಸುವ ಟಾಟಾ ಸುಮೋ ಹೋಂಡಾ ಆಕ್ಟಿವಾ ವಾಹನದ ಮೇಲೂ ಹಾದು ಹೋಗಿರುತ್ತದೆ. ಸಲ್ಲಿಸ ಪ್ರತ್ಯಕ್ಷದರ್ಶಿ ಇರುವುದಿಲ್ಲ. ಬೇರೆಯವರ ಕಡೆಯಿಂದ ತಿಳಿದುಕೊಂಡು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿರುತ್ತಾನೆ. ನನ್ನ ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಯಾವುದೇ ಪ್ರತ್ಯಕ್ಷದರ್ಶಿ ಹೇಳಿಕೆಯನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಯನ್ನು ದಾಖಲು ಮಾಡಿಕೊಂಡ ನಂತರ ಆಪಾದಕ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಸ್ಥಳದ ಪಂಚನಾಮೆ ಮತ್ತು ನಕ್ಷೆಯನ್ನು ಮಾಡಿರುತ್ತೇನೆ. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಹೊಸ ವಾಹನಗಳು ಇರಲಿಲ್ಲ. ಸಾಕ್ಷಿ ಹೇಳಿದ್ದರಿಂದ ಟ್ರಾಫಿಕ್ ಜಾಮ್ ಆಗಿದ್ದರಿಂದ ವಾಹನಗಳನ್ನು ತೆಗೆದಿರುತ್ತಾರೆ. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಭೇಟಿ ನೀಡಿ ಮೃತನ ಶವ ತನಿಖಾ ಮಾಡಲು ಸಂಬಂಧಪಟ್ಟ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನಂತರ ನಾನು ವಾಹನಗಳ ಜಪ್ತಿ ಮಾಡಿ ಠಾಣೆಗೆ ಕಳೆದುಕೊಂಡು ಹೋಗಿರುತ್ತೇನೆ. ನಂತರ ಸಂಬಂಧಪಟ್ಟ ವಾಹನಗಳು ಸಲ್ಲಿಸುತ್ತಾರೆ. ನಾನು ದೋಷಾರೋಪಣ ಪತ್ರ ಸಲ್ಲಿಸುತ್ತೇನೆ. ಕ್ರಾಸ್ ಇರ್ಬೋದು. ಫಿರ್ಯಾದಿ ಆಕ್ಟಿವ್ ಹೋಂಡಾ ವಾಹನವು ಮುಂದೆ ಸಾಗುತ್ತಿದ್ದಾಗ ಎದುರುಗಡೆಯಿಂದ ಮೊದಲು ಟಾಟಾ ಎಸಿ ವಾಹನವು ಡಿಕ್ಕಿಪಡಿಸುತ್ತದೆ ಎಂದನೇ ನಿಜ. ನಾನು ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿದಾಗ ಅಲ್ಲಿ ನಿಮಗೆ ಅಪಘಾತ ಸ್ಥಳ ಡಿವೈಡರ್ ಕಂಡು ಬರುತ್ತದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಅಪಘಾತ ಸ್ಥಳದಿಂದ 10-15 ಅಡಿ ಹಿಂದಕ್ಕೆ ಇರುತ್ತದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನನ್ನ ಸಾಕ್ಷಿಯ ನಕ್ಷೆಯ ಪ್ರಕಾರ ಟಾಟಾ ಸುಮೋ ವಾಹನವು ರಸ್ತೆಯ ಎಡಭಾಗದಿಂದ ಬರುತ್ತಿತ್ತು, ಬಲಭಾಗದಿಂದ ಆಕ್ಟಿವ್ ಹೋಂಡಾ ಬರುತ್ತಿತ್ತು ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿಯು ಹೇಳುವುದೇನೆಂದರೆ ಸಾಕಷ್ಟು ರಸ್ತೆ ಇತ್ತು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಟಾಟಾ ಸುಮೋ ಎಡಭಾಗಕ್ಕೆ 2 ಅಡಿ ರಸ್ತೆ ಜಾಗ ಇತ್ತು. ಟಾಟಾ ಸುಮೋ ಮತ್ತು ಆಕ್ಟಿವ್ ಮುಂಭಾಗ ಬಲಭಾಗದಲ್ಲಿ ಇತ್ತು ಎಂದರೆ ಸುಮಾರು 1-2 ಮೀಟರ್ ಅವಕಾಶ ಇತ್ತು ಎಂದು ಹೇಳುತ್ತಾರೆ. On the right side of a Tata two-wheeler also there was about 2 meters. ಡಿವೈಡರ್ ಮಧ್ಯೆ ಅಂತರ ಇತ್ತು ಎಂದರೆ 1 ಮೀಟರ್ ಇತ್ತು ಎಂದು ಹೇಳುತ್ತಾರೆ. CPI ಇದರ ಪ್ರಕಾರ ಆಕ್ಟಿವ್ ಹೋಂಡಾ ಇದಕ್ಕೆ ಮುಂದಿನ ಅಂಚಿನಲ್ಲಿ ಜಖಮಾಗಿದ್ದವನ್ನು ಹೇಳುತ್ತಾರೆ. ಟಾಟಾ ಎಸಿಯ ಮುಂಭಾಗಕ್ಕೆ ಬಲಭಾಗಕ್ಕೆ ಬೀಚಿರುವ ಗುರುತುಗಳು ಕಂಡು ಬಂದಿರುತ್ತವೆ. ಅದೇ ರೀತಿ ಟಾಟಾ ಸುಮೋ ವಾಹನದ ಮುಂದಿನ ಬಲಭಾಗದ ಬಾಗಿಲು ಮತ್ತು ಫೆಂಡರ್ ಬಳಿ ಜಖಮಾಗಿರುತ್ತದೆ. ಆಕ್ಟಿವ್ ಹೋಂಡಾ ವಾಹನದ ಮುಂದೆ ವಾಹನದ ಪ್ರಕಾರ ವಾಹನದ ಹಿಂಭಾಗಕ್ಕೆ ಯಾವುದೇ ಜಖಂಗಳು ಆಗಿರುವುದಿಲ್ಲ. ತನಿಖಾ ವರದಿಯ ಪ್ರಕಾರ ಮೃತ ವ್ಯಕ್ತಿಯ ಮೇಲೆ ವಾಹನ ಅರಿವರೆಗೆ ಹೇಳಿರುವುದಿಲ್ಲ. ಆಕ್ಟಿವ್ ಹೋಂಡಾ ವಾಹನವು ಮುಖ್ಯ ರಸ್ತೆಗೆ ಬಂದು ಟಾಟಾ ಎಸಿ ವಾಹನಕ್ಕೆ ಡಿಕ್ಕಿಪಡಿಸಿದ್ದು ಅಪಘಾತಕ್ಕೆ ಕಾರಣವಾಗಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಟಾಟಾ ಸುಮೋ ವಾಹನವು ಈ ಅಪಘಾತದಲ್ಲಿ ಭಾಗಿಯಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತದ ನಂತರ ಟಾಟಾ ಸುಮೋ ವಾಹನ ಅಲ್ಲಿಗೆ ಬಂದು ವಾಹನದ ಮೇಲೆ ಸುಳ್ಳು ಹೇಳ್ತಾನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆದ್ಮೇಲೆ ಈ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಯಿತು. ಸ್ಥಳದಲ್ಲಿ ಯಾವುದೇ ಭಾಗಗಳಲ್ಲಿ ರಸ್ತೆಯ ಮೇಲೆ ಯಾವ ಕಂಡು ಬಂದಿಲ್ಲ. ಟಾಟಾ ಸುಮೋ ಮತ್ತು ಆಕ್ಟಿವ್ ಸರ್ವಿಸ್ ರಸ್ತೆಯ ಮೇಲೆ ಬರುತ್ತಿದ್ದವು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅವು ಚಿಕ್ಕ ರಸ್ತೆಯಲ್ಲಿ ಬರುತ್ತಿದ್ದವು. LNT ರಸ್ತೆ ಡಿವೈಡರ್ ಕೂಡುತ್ತವೆ ಎಂದರೆ ಸರಿ. ಟಾಟಾ ಸುಮೋ ಮತ್ತು ಆಕ್ಟಿವ್ ಹೋಂಡಾ ಹೋಗುವ ರಸ್ತೆ ಎಡಗಡೆ ಮತ್ತು ಬಲಗಡೆ ಹೋಗಲು ರಸ್ತೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸೀತಾರಾಮ್ ಮತ್ತು ಬಲಭಾಗ ಮ್ಯಾರಿಯಟ್ ಕಡೆ ಹೋಗುತ್ತಾರೆ. ಅಲ್ಲಿ ಹೋಗೋಣ ಯಾವುದೇ ಸಿಗ್ನಲ್ ಹಾಗೂ ಫಲಕಗಳು ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಜಂಕ್ಷನ್ ಇರುವುದರಿಂದ 3 ಕಡೆಯಿಂದ ಯಾರೂ ಪ್ರತ್ಯಕ್ಷದರ್ಶಿಗಳು ಸಿಕ್ಕಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ನಾವು ಪ್ರತ್ಯಕ್ಷದರ್ಶಿಗಳ ಹೇಳಿಕೆಗಳನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ನನ್ನ ತನಿಖಾ ಅವಧಿಯಲ್ಲಿ ಮೃತ ವ್ಯಕ್ತಿ ಹೆಲ್ಮೆಟ್ ಹಾಕಿಲ್ಲ ಎಂದು ಕಂಡು ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮೆಲಾಡ್ ಕೈಂಡ್ಲಿ ಸಿ ಹೌ ವಿ ಗೋಸ್ ಟು ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಸೇವಿಂಗ್. ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿ ಹೆಲ್ಮೆಟ್ ಕಂಡು ಬಂದಿರುತ್ತದೆ, ಆದರೆ ಅದನ್ನು ತೋರಿಸಿರುವುದಿಲ್ಲ. ವಾಹನವನ್ನು ಜಪ್ತಿ ಮಾಡಿದಾಗ ಹೆಲ್ಮೆಟ್ ಅನ್ನು ಜಪ್ತಿ ಮಾಡಿರ್ತೀರಾ ಎಂದರೆ ನನಗೆ ಅವಶ್ಯಕತೆ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಶವ ತನಿಖಾವಧಿ ಮತ್ತು ಮರಣೋತ್ತರವಾಗಿ ಮೃತನಿಗೆ ತಲೆಪೆಟ್ಟಾಗಿರುತ್ತದೆ ಎಂದು ನಮೂದು ಇತ್ತು ಎಂದರೆ ಸರಿ. ಮೆಲಾಡ್ ಕೈಂಡ್ಲಿಸಿ ಇಟ್ ಈಸ್ ದಿ ಓನ್ಲಿ ಹೆಡ್ ಇಂಜುರಿ. ಮೃತ ವ್ಯಕ್ತಿ ಟಾಟಾ ಎಸಿ ವಾಹನಕ್ಕೆ ಡಿಕ್ಕಿಪಡಿಸ್ತಾನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಎಸಿ ವಾಹನವು ಡಿಕ್ಕಿಸುವಾಗ ಮಾತ್ರ ಜಖಂಗಳು ಆಗಿದ್ದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಟಾಟಾ ಸುಮೋ ವಾಹನ ಮೃತ ವ್ಯಕ್ತಿ ಮತ್ತು ಹೋಗಿದ್ದರೆ ತಲೆಗೆ ಗಾಯ ಆಗಿರುತ್ತವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಟಾಟಾ ಎಸಿ ಸಹ ಅಪಘಾತಕ್ಕೆ ಕಾರಣವಾಗಿರುತ್ತದೆ ಎಂದು ಸದರಿ ಆಕ್ಟಿವ್ ಹೋಂಡಾ ವಾಹನ ಸವಾಲ ತಪ್ಪಿನಿಂದಲೇ ಆಗಿದ್ದರೂ ಸಹ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ದಾಖಲೆ ಸರಿಯಲ್ಲ. Melody, totally, absolutely no inquiry. Only on the basis of the complaint of a hearsay witness. Melody, case is lodged against. Melody, sketch. Melody, the complaint itself also says, now Melody, the theory of saying that Melody Tata Suma went over the body of the deceased. Melody, apparently false. Apparently.
You examined the driver of the Tata Sumo also? Driver of Tata Sumo is not examined.
Not. The driver himself was examined, so obviously he said there were no eyewitnesses. He himself says.
As examination, ಪೂರ್ತಿ ಓದಲಿಲ್ಲ ಅವರು.
ಸರ್ ನಿಮ್ಮ ಪರವಾಗಿ ಓದಿ ಸರ್.
ನಿಮಗೆ ಏನ್ ಬೇಕೋ ನೀವು ಓದಿ ಹೇಳಿ.
ಓದಿ ಖಂಡಿತ ಓದಿ ಸರ್. ಬೇಡ
ಅವರಿಗೆ
ಅಲ್ಲ ಹೌದು ಸರ್, ದಟ್ ಈಸ್ ಹೌ ಇಟ್ ಈಸ್. ನೀವು ಇರೋದೇ ಅದಕ್ಕೆ ನಿಮ್ಮ ಪರವಾಗಿ ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ನೀವು ಹೇಳಿ.
ಸ್ಪೀಡ್ ಅಪ್
ಆಗ್ಲಿ ಸ್ವಾಮಿ, 4 ಸೆಂಟೆನ್ಸ್ ಇದೆ. ಓದ್ಬಿಡ್ತೀನಿ ಅದನ್ನು ಅವ್ರಿಗೆ
ಅವ್ರದವ್ರು ಓದ್ತಾರೆ ಬಿಡಿ, ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಅದನ್ನ ಓದಿ.
ಅಷ್ಟೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ
So you said PW1 is
Milord,
admitted that she is not the eyewitness.
yes, ma'am. I'll check Milord, that portion.
You respond number ಎಷ್ಟು? 2 not 4 ಐದು confusion ಇದೆ. ನೀವು ಬರ್ಕೊಂಡಿದ್ದ notes. Oriental is respond number 4. Your class exam PW1 our class exam. He said she has admitted. Ali chapter like an eyewitness ಅಂತ.
Cross examination page 6 ಮೇಲೆ
Page 6 is
ಪಾಠಿ ಸವಾಲು 1ನೇ ಇದು 2ನೇ ಇದುದಾರ ಪರ ವಕೀಲರಿಂದ ಸ್ಟಾರ್ಟ್ ಥರ್ಡ್ today I have not seen the place of accident.
ಎಲ್ಲಿ?
Milord, I have not seen the accident. I do not know the name of the person.
Page 6 ಅಲ್ಲ?
Page 6 of the deposition, PW1.
Yes.
You Milord got it, cross examination.
Yes, yes.
ಸಾಕ್ಷಿ ಕರೆಯಿಸಿ ಪ್ರಮಾಣ ಬೇಂದ್ರೆ ಕಾಪಲ್ಲಿ 24/7/2015 ಕರೆಯಿಸಿ ಪ್ರಮಾಣ ವಚನ ಬೋಧಿಸಲಾಯಿತು ಅಂತಿದೆ. ಕೆಳಗಡೆ ಕ್ರಾಸ್ ಇದೆ.
ಆಯ್ತು ಓದಿ ನೋಡಿ.
I have done my MBA. I am not working anyway. I have not seen the accident. I do not know the name of the person who had informed about the accident. My husband had dared to drive two-wheeler. Till today, I have not seen the place of accident.
And I was shows her as eyewitness.
Yes. The complainant himself is not.
Witness ಅವರೇನು ಹೇಳಿಲ್ಲ. Whether she has said in the affidavit that she is the eyewitness.
ಸರಿ, ಅದು ಅವರ ಐ ವಿಟ್ನೆಸ್ ಆಗಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ನಾವು ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹೇಗೆ ಸುಳ್ಳು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತ. She doesn't claim that she is eyewitness. IO himself says in the cross examination.
That RW1 is not helpful to either to the insurance company nor to me. ಯಾಕಂದ್ರೆ ಅವ್ರು ನೋಡಿಲ್ಲ ಅಂತಾರೆ, ಅವರು ನೋಡಿಲ್ಲ ಅಂತಾರೆ. ಅವ್ರೇನ್ ಹೇಳಿದ್ರು?
He has conducted the investigation and he says this lady was the eyewitness. On what basis he says that she was the eyewitness?
He has conducted the Mazar, he draw the sketch. He has the Mazar witnesses have signed.
He asked you, this witness has shown her as eyewitness in the charge sheet. And now their own evidence unfolds that.
On the basis of the circumstantial evidence, he has filed the charge sheet. Yeah.
Correct ರೀ, ಆದ್ರೆ ಆಕಿನ ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಯಾಕೆ ತೋರಿಸ್ಬೇಕಿತ್ತು? ಸುಮ್ನೆ ಕೊರಾಬರೇಟಿಂಗ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ಕೊಡಬಹುದಿತ್ತಲ್ಲ ಅವ್ರು.
ಅವ್ರು ಹೇಳಿದ್ರು ನಾನು
conducted fair investigation, then he could have shown her only as a corroborating witness.
IO cannot be an eyewitness. He cannot be an eyewitness at all.
Yes.
Milord, precisely this indicates, Milord, the object of the police officer was to implicate Tata Sumo. Because by that time, Milord, by the time he started the inquiry.
In the complaint, there was no mention of a second vehicle.
It is. What has happened is probably, Milord, the moment accident has taken place, they have realized, Milord, the other vehicle has no insurance. That immediately, Milord.
In fact,
the presence of your vehicle is that, but you only deny the negligence on the part of.
Yes, that's, Milord, I am not not even for a moment I am saying that my vehicle was not there.
No, your Lordship may kindly see, they have not, correct, they have not denied the involvement of the vehicle. And they have not even examined the driver also.
Argue the matter. ಅವ್ರದ್ದು ಮುಗಿತಾ ಇದೆ, ಅವ್ರದ್ದು ಮುಗಿದ್ಮೇಲೆ ನೀವು ಮಾಡಿ. Yes.
Milord, from the beginning, Milord directly asked me one question. Are you disputing involvement? I said I am not. What I am trying to bring to Milord's notice is.
Right, we got you say that your driver was not negligent.
No kind of negligence can be attributed to my vehicle. Now, Milord, the claim is based on top. It's a claim petition under section 166. Negligence has to be proved. Now, Milord, the negligence about my vehicle, Milord, apparently is brought into picture only because the other vehicle had no insurance.
But your vehicle owner also did not.
Milord, he has appeared, he has filed statement, Milord, but
further he did not.
Participate. Milord, yes, Milord knows. The moment there is insurance, they don't have. Ultimately, Milord, we are made to fight. Well, that is the case both in the courts and with the police also, Milord. Unfortunately, that is the case. No, Milord, the entire Milad reading of the, I was in evidence coupled with the complaint. Milad, it clearly demonstrates, Milad, my vehicle is brought into picture as far as negligence is concerned, only because the other vehicle had no.
Yes.
Now, Milad, the other aspect is, assuming for a moment, Milad, it's a case of composite negligence. No, Milad, the Supreme Court has clearly held, if the claimant chooses to sue one vehicle, he may do so because it is a case, the two vehicles are involved and their involvement is not disputed. No, Milad, when one of the vehicle, when both the vehicles dispute negligence, no, Milad, the tribunal has to go into that aspect and give a right. No, Milad, the judgment relied on by the tribunal may kindly be seen. Or idide, nanu I will not take my lords to the entire judgment. At judgment ಅಲ್ಲಿ relay ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. I will just read up that.
Page number?
Milord, page. Any case Milord is relied on. Page 13 of the judgment.
Page 30.
Paragraph 39.
Internal page 30, no?
Milord, like internal pages, my paper 39, Milord, external.
Judgment internal page number.
30, Milord, please.
30.
Paragraph 39.
Yes. Yes.
2015 is see, between Kenny versus the India Assurance. That is the case on.
Yes.
No, Milord, this is the. No, Milord, with the very same judgment, Milord. There, Milord, the High Court, Milord, Supreme Court has said that it is for the claimant to choose.
Yes.
Now, Milord, in judgment, Milord, may I pass on? I will take my lords to the relevant portion without. 1451 minutes. In case all the giant figures have been included and negligence is sufficient, evidence is sufficient, it is open to the court. 1451 minutes.
Yes.
11 portion.
Yes.
Roman 3 minutes.
Yes.
In case all joint figures have been included and evidence is sufficient, it is open to the court rather to determine, let's say, extent of composite negligence of divers. However, determination extent of negligence in joint part figure is only for further inter-alia liability, so that one may recover the sum from the other. in case both of them have been implemented and apportionment the extent that negligence has been determined by the court in the main case, can recover the amount from the other end. But this fact has been ignored by the tribunal. My case is, Milord, there is no negligence.
So even this is pay and recover.
Allah, interest but the tribunal has to determine the Milord negligence when the composite negligence only Milord has the principle is Milord, if two vehicles are negligent, Milord, the claimant can proceed against any one of them. And they can ignore the increase Milord other vehicles. It is for them to choose. That is the Milord principle of complicated case. That is Milord, when they have chosen to impede only one vehicle. Now, Milord, they have chosen to impede both the vehicles. And Milord, the moment they have chosen to impede another vehicle, and when the stand is taken by the other vehicle that there is negligence of the other vehicle, Milord, without referring to the evidence, Milord, the tribunal could not have said case of negligence and composite negligence and
Yes. Yes.
no Milord, the two vehicles are involved. Milord, my evidence and the argument put forth by me showing that Milord, there can be no negligence on my part could not have been totally ignored and this entire negligence could not have been said. Milord, the tribunal clearly holds that the other vehicle is also negligent.
Yes. No,
It is not, Milord, that the negligence is on. Milord, the sketch clearly shows that Tata has come and did the two-wheeler. And Milord,
no repetition.
yes. So, Milord, the tribunal has totally ignored this aspect.
So this is a negligence.
Yes. And
Quantum.
finding on negligence should have been given. It could not have just said, Milord, that.
But you have to argue on both the points.
Now, Milord, on liability, quantum, Milord, the income tax returns are filed. And Milord, the returns.
What was his age?
Sorry, Milord.
Age, what was the age of the?
Age of the deceased was
33 years.
33 years. So, based on what it is taken? 33 years is taken on what basis? Income tax returns.
Yes.
Quantum is discussed in which page?
Milord,
Quantum deductions. Okay. 33 years. Para 23 onwards. Engineer by profession at design systems. Okay. 26 lakhs per annum.
Yes.
One week later.
Milord,
Exhibit P18 is appointment letter.
32 in it is pertinent to note the fact that he is the wife, second petitioner, the lateral person.
Case is P19 to 20. Room number 16 is 22 and 23.
Yes. Petitioner, one witness,
First
Matthew
official
TW2, the HR manager, para 24. He has also produced one letter of full and final payment. Further produced Form 16 marked as Exhibit 47 to 49. He has also produced appointment letter of the this is marked as Exhibit 250. The increment letter copy which is marked. Filled and earned a salary of more than 17 lakhs per annum in the year 2014. After perusal of 45 payslips for the month of December 2000 disclosed, the total earning of deceased was 2,14,867 and net pay 2,14,000. But as per the income tax returns are disclosed that the deceased was declared the amount of 13,48,000 as income. 13,48,000 pound. Amount 70, if the respondents are not denied the income tax assessment. The income tax assessment is filed after the death,
I think there are more than one. ಒಂದೇ ಇಲ್ಲ ಫಾರ್ಮ್ ನಂಬರ್ 16 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಇದನ್ನು ಕೊಟ್ಟಿಲ್ಲ, ಅಸೆಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ ಇದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ ಸ್ಯಾಲರಿ ಇನ್ಕಮ್ ಆದ್ರೆ ಬರುತ್ತಲ್ಲ,
ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಫಾರ್ಮ್ ನಂಬರ್ 16 ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟದು? ಫಾರ್ಮ್ ನಂಬರ್ 16
49. ಫಾರ್ಮ್ 16 is
P22 income tax return.
forms.
ಈ ಕಡೆ ಫಾರ್ಮ್ ನಂಬರ್ 16 ಅಂತ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಅಂತ ಬಂದಿದೆ. 47 to 49 also 3 income tax returns ಅಂತ ಇದೆ.
Mm-hmm.
22 and 23 no income tax returns ಅಂತ ಇದೆ.
49.
ಇದನ್ನ ಅವ್ರಿಗೆ ಹೇಳ್ಕೊಟ್ಬಿಡ್ತಾರ ಬರೆಯೋದಕ್ಕೆ.
49 ಅಲ್ಲಿ 1,60,000 ರೆಂಟಲ್ ಇನ್ಕಮ್ ಇದೆ. that should have been excluded.
ಇದ್ರಲ್ಲಿ ನೋಡೋಣ, ಅದು ಎರಡು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಏನಂತ
ಇಲ್ಲ
22, 23 ಆರ್ ಫಾರ್ಮ್ ನಂಬರ್ 16 ತಪ್ಪಾಗಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಅಂತ ಇದ್ರಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
49 ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ರಿಟರ್ನ್ಸ್ ಫೈಲ್ ಮಾಡಿದೆ.
ಇದು ಫಾರ್ಮ್ ನಂಬರ್ 16, 22, 23. ಇನ್ನೊಂದು 46 to 49.
49 ಅಲ್ಲಿ ಇನ್ಕಮ್
Date of accident is 29/12/2014. ಅದ್ರ ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಅದು ನೋಡ್ಬೇಕು.
ಫೈಲಿಂಗ್ ಡೇಟ್ 31 July 2015.
48 is for the assessment year 2014-15. Submitted, last updated 22nd May 2014.
Yes.
So this can be accepted, 48. Because it submit ಮಾಡಿರೋದು 22
31 July
2020, 2014.
after the date.
No, not after the accident. Date of 2014 December. ಇದು ಮೇದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಲಾಸ್ಟ್ ಅಪ್ಡೇಟೆಡ್ ಅಂತ ಇದೆ. ಕ್ವಾರ್ಟರ್ಲಿ ಕೊಡ್ತಾರೆ. So here is amount of tax deducted ಎಷ್ಟಿದೆ? So amount of tax deducted, amount paid credited 20,17,794. ಅದರಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ 3,65,919 ಅಂತ ಇದೆ. So this can be accepted, exhibit P48, because it was submitted.
No, my lord, which document?
Exhibit P48.
40.
Exhibit P48.
48.
IT return for the assessment year 2014-15.
ಅಲ್ಲ ಅದು ನೆಕ್ಸ್ಟ್ ಫೈಲಿಂಗ್ ಡೇಟ್ ಇದೆ ನೋಡಿ.
ಅದೇ ಫೈಲಿಂಗ್ ಡೇಟ್ ಲಾಸ್ಟ್ ಅಪ್ಡೇಟ್ 22nd May 2014 ಅಂತ ಇದೆ. ಮೇಲೆ ಲಾಸ್ಟ್ ಅಪ್ಡೇಟೆಡ್ ಅಂತ ಇರುತ್ತಲ್ಲ. First April 2013 to
47 is for
31st March. Assessment year 2014, financial year 13-14. ಎಷ್ಟು salary?
statement of accounts 49 ಅಲ್ಲಿ ಇದೆ.
Salary is ಎಷ್ಟು annual? 20 lakhs.
Savings estimation.
ಅಲ್ಲ, amount credited ಅಂತ. ಅಲ್ಲ, ಇದು amount credited ಅಂತ ಇದೆ. At least reasonably can take this ಅಲ್ಲಿ ಏನೋ ಬೇರೆ ಇತ್ತು ಅಂತ ಅವ್ರ ಪ್ರಕಾರ ಸ್ಯಾಲ್ರಿಡ್ ಅಂತ ಅನ್ನೋದಾದ್ರೆ ಸ್ಯಾಲ್ರಿ ಇನ್ಕಮ್ ಒಂದೇ ತಗೊಂಡ್ರು you can take this 20 lakhs 17,000 unfortunate for person 794 will minus ಮಾಡಿ tax 3,65,000 20 lakhs 17,794 17,794 minus 3,65,919 ಏನಾದ್ರು ಒಂದು ರೌಂಡ್ ಕ್ಲೋಸರ್ ಇರೋ ತಗೊಂಡು 16 lakh 875 ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದೆ his annual income they have taken annual income or monthly income
annual income ಅಲ್ಲ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ ಮೇಲೆ ಒಟ್ಟಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ
annual
income ತಗೊಂಡು
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
ಮಲಾಡ್ it is
will continue tomorrow
13,84,952. The tribunal has taken the income of the deceased at 13,84,952 per annum.
taken it ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ
Income assessed is 17,50,000 after deduction, 13,84,952.
ಅವ್ರದ್ದು ಅಪೀಲ್ ಇದೆ ಬಟ್ ಇದನ್ನ ಬರೀ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ತಗೊಂಡು 16 lakhs after deducting income tax 16,57,000 we'll see that ನೋಡೋಣ ಹೇಗಿರುತ್ತೆ ಆಯ್ತು we'll continue day after tomorrow we'll continue
Day after tomorrow.
Friday holiday
Okay.
ಅದು 13th is holiday ಸರಿ 14th 14th
Monday.
ಬೇಡ ಶುರು ಮಾಡಿದೀರಾ ಮಾಡಿ ಮುಗಿಸ್ತೀನಿ ಮಂಡೇ ನಮ್ದು ಯಾವ್ದೋ ಪಾಠ ಇರ್ಬೇಕು ಮತ್ತೆ ಅಲ್ವಾ hard in part for further hearing. Let's start. 14:3.
My lordship's permission.
Number 42. Shri Gurudev Prasad. Please for appellant manage.
ಯಾವ್ದು appearance ಗಿತ್ತ parties appearance ಯಾವ್ದು
44.
42.
parties ಯಾವ್ದು 50
57 serial.
is appearance consultant. Who is for the other side? You know, for what appearance parties were directed to appear?
Lord, what had happened is I'm filing an affidavit to the until
The last date in the order ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Kindly see the order of the.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಕೊಡ್ಬೇಕು whatever you want. And not directly here, you should file it in the registry.
In case there was a direction to give clarification.
28 through 25.
So
27th, the appellant was directed to be present.
ಈ ಕೇಸ ಇದು
27th ಗೆ appellant was directed to be present. 27th morning, what happened?
we cannot give any priority in this case even if he appears to a senior counsel.
No, my lord. I'm only saying what transpired. I'm not saying anything.
No, look at the order sheet. Have you seen the previous thing?
Some miscommunication. I would like to clarify on that. That is the only thing I like to do.
It's not a miscommunication. It is apparent on the face of the record.
Lord, once I make a service, just try to convince your lordship on this. What happened on 27th? His son was infected with diarrhea, and morning he was taken to the primary health center. I have furnished a copy document.
It is not about he not appearing before the court or any other thing. The way he made allegations against a judicial officer.
That also I will try to convince your lordship on that. What happened on the last date of the last date when he was supposed to take his son for visitation. Right? Normally, what used to happen after the direction of this honorable court, between 2 to 4, he would leave his son in the district legal services premises, and he would go out, and he would come back at 4 o'clock and sign a register, pick his son. So that happened at the previous occasions as well. Last occasion at 4 o'clock, he goes there, he signs the registers and see that his son is not coming from outside. Then he asks his son, why is he coming from outside? Then his son says that the respondent was pestering me, hence I ran out of the premises at 3 p.m. Then he says, why? Then what happened? When the son says that I ran out of the premises, came to clean that, again started pestering, again I ran out of the premises,
and was sitting in the room next to the lift in the next building, which is the new court premises. This, my lord, naturally as a father was a bit,
No, for that, whether he should make allegation against the judicial officer.
my lord, what he did was, he asked, there was some reason that you should have taken care of the son, my lord. He is a 6-year-old.
No, even before that, when he came before us in the chamber conciliation, he makes allegations against the officer saying that that officer keeps calling him.
I understand, my lord, I have instructed him on that, let him not, my lord, it's only natural that a father, when he sees that his son came from
If
outside.
everyone says this is nature, then where is the rule of law?
My lord, I have instructed my client on that, it was only his natural reaction, seeing his son crying and coming
It is
out.
unnatural reaction, not natural reaction.
When he sees his son crying and coming from out of the premises, is not.
So that is subsequently.
No, my lord.
Even earlier to that also, he kept on making this kind of allegations.
My lord, I would make a submission. I have instructed my client to be calm and composed, that he will take care of.
But how does he compensate that?
My lord, I would say, but I would make submissions that one, my lord.
Now we cannot take up your matter because now it is 4:51.
Yes, my lord, I am.
Don't subject us to domestic violence.
No, my lord, I am not into it.
Yes,
As
we'll have it
as there was an
on-
appearance to be made, I
And
want.
we have already permitted them to execute the decree order, they can execute it.
Lord, I would make a submission.
And if that is the case, you could have mentioned it in the morning only. We are taking it up at 1:30 or 2:30. This is also again a tantram.
No, my lord, I did not want to disturb your lordship and mention about.
See,
this
there
case,
were
my lord. I was
parties-
Waiting from
Connect-
2:30 till 4:30.
There were other councils where the parties appeared. They mentioned at 2:30. We recorded so many compromises at that time.
My lord, that I saw, my lord. Here I was actually.
You are there at 2:30.
Yes, my lord, I am here from 2.
Did you watch how the proceedings went on?
I saw.
Then the parties, then you could have mentioned it.
Lord, here it was only.
And
for-
if your party should mention to you that he is coming to the court at such and such a time,
My lord, he is
in
here from
advance.
10:30.
You could have mentioned it.
I'm
See,
sorry, my lord, I
Mr.
did-
Counsel,
I was not aware of that. I will take care of that.
I'm also a mother. I never made a child to wait in the court even when I was working in the family court as or any senior citizens.
I understand. Because
Then
I was
why
not
did he
aware of
not
that.
mention or why it was not mentioned at 1:30?
Lord.
Now only to show that you made it. This is a violence for the child also.
I'm sorry, my lord, I'm.
And he wants to make allegations against others saying that child was not comfortable.
My lord, one in respect of not making a mention of the case, my lord, it is I took a call, I was not.
You
aware of
want discount for everything.
I'm sorry.
You say
I
it is
could have done-
natural for the father. We did not mention for this reason. He did not tell this for this reason.
I will make a submission.
No,
One-
Today not possible.
Yes.
At 4:50 mention ಅಂತಾನೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ನಾವು ಅಷ್ಟೇನೆ. ಅವ್ರ ಹೆಸರೇನು senior counsel. ಅಲ್ಲ ಇವರೆಲ್ಲ ಮೊದಲು ಬೇರೆ ಯಾರೋ ಅಪಿಯರ್ ಆಗ್ತಿದ್ರು.
ಹೌದು, ನಾನು ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಅನ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Only see that I know ಈಗ he has not produced the child there again before the DLSA.
ಅಲ್ಲ,
It
that-
was on every date of hearing, my lord. There is
ಅಲ್ಲ,
every
previous
occasion.
late
whenever he
ಆದ್ಮೇಲೆ
was-
ಒಂದು ಆಗಿತ್ತಾ date
ಅಲ್ಲ,
ಅಂತ?
ಮೊನ್ನೆ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಐ ಥಿಂಕ್ ಶಿ ಹ್ಯಾಸ್ ಆಲ್ಸೋ.
Other day.
ಎಸ್.
Shall I-
Serial number 57. At about 4:50 PM, Lord Counsel for the appellant mentions before this court that the appellant is present with the child before the court. ನೀವು ನೋಡಿದ್ರಾ? ನಿಮ್ಗೆ ಏನಾದ್ರು ಗೊತ್ತಿತ್ತಾ? ಬೆಳಿಗ್ಗೆಯಿಂದ ಇದ್ರ ಅವರು ಅಲ್ಲಿ?
ಇದ್ರು.
ನೀವು ಯಾರು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ವಾ? ಪಾಪ ಆ ಮಗು
ಅಲ್ಲ,
ಬೆಳಿಗ್ಗೆ
ನಾನು
ಸಾಯಂಕಾಲ
ನೆನಪು ಮಾಡಿದೆ. ನಾಟ್ ಇನ್ ದ ಮಾರ್ನಿಂಗ್, ಆಫ್ಟರ್ನೂನ್ ಐ ರಿಮೈಂಡೆಡ್.
ಈ ಡಿಕ್ಟೇಷನ್ ಅಲ್ಲ ಬಂದಿದ್ಯಾವಾಗ ನೀವೇನಾದ್ರು ನೋಟಿಸ್ ಮಾಡಿದ್ರ? ಯಾವಾಗ ಕರ್ಕೊಂಡ್ ಬಂದ? ನಾವ್ ಇಲ್ಲೇ ಇದೀವಿ, ನಮ್ ಕಣ್ಣಿಗೇನು ಕಂಡಿಲ್ಲ ಇವರು.
ಹೊರಗಡೆ ಕೂತಿದ್ದು, was not here.
ಈಗ ಮತ್ತೊಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಹೊರಗಡೆ ಕುತ್ಕೊಂಡಿದ್ರು.
Lord, there is no occasion for me to tell lies before your lordship, my lord.
Your client has said
That with
several
respect to
lies.
that, my lord, if there is anything, I apologize for that, my lord, but I am making a submission that he was here at 10:30.
However, such mention was not made during the course of the day since morning. Though in several cases where the parties appeared, the respective counsels made a mention and such cases were disposed of. The appellant is said to be waiting with the child age, eಷ್ಟದು?
7 years.
7 years since morning, which is again not appreciable. List the matter on. Now we have permitted you to execute. If you want, you can
Not
execute.
any shorter
List
date.
the matter on.
25-3.
Now, last time, he was asked to be present with the child before the court, no?
Allah, only appellant,
ಮಾಡಿಲ್ಲ ಬರೀ
appellant is asked to be present. Only appellant.
Only appellant is.
appellant's counsel. ನೀವೇ ಹೇಳಿದ್ದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು. Appellant's counsel submits that an opportunity be given to the appellant to explain his conduct.
Yes.
Therefore, the court defers referring the matter for contempt ಅಂತ ಮಾಡಿದ್ದೀವಿ. We had not directed him to be present with the child.
No, my lord,
On their own
my
request.
lord, I gave the instruction to the appellant for the reason that if there is any clarification that the court would have, because there is an allegation made by the respondent that the appellant had directed the son to not cooperate with her whenever she meets. If your lordship is, my only concern
is
was if there was
coughing.
any requirement to meet the
But-
child, it could be made.
Not, though, I'm sorry, apparently in the order sheet, under the order dated 28/2025, there was no direction that he should be present before the court along with the child. Such conduct of the appellant is again unappreciable. The list on date
My lord, any shorter date, my lord, because it's an ex parte judgment and decree. That is-
25.
Any shorter date, my lord,
Not possible.
on submission, my lord.
ಯಾವಾಗ ಚಾನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೋ ಅವಾಗ ಯೂಸ್
I
ಮಾಡ್ಕೊಂಡು.
agree, my lord, I apologize for whatever has transpired, my lord. One
What
submission,
is that you are submitting?
that's an explanation regarding the,
You submit it in the register and serving the copy and
I have served a copy, my lord.
Lord, I will file my reply to this.
I can file it. Next cut.
My lord, shall I make a submission? One submission if your lordship permits me.
Now we have
Aಲ್ಲ,
out
ಏನಿಲ್ಲ,
of time.
date, shorter date.
We had
ಅದಕ್ಕೆ-
forgotten we have a program somewhere.
I'm sorry, I will not.
Arbitration center ನಲ್ಲಿ there is one program in arbitration center I have to go for.
For dismissal, serial number 42.
For
Amulya.
appellant, my lords, seeking 3 days time for filing necessary application, my lords.
After lapse of time granted by the honorable court. ಏನಿದು what is that memo filed? Process memo.
Yes, my lords. 18 days delay, my lords.
Did you not file an application for that?
Not yet, my lords. I'll file, I seek it 3 days time, my lords. I'll file a application here on.
Who is speaking? ಇಲ್ಲಿ.
Yeah, ma'am.
Now all ನೋಡ್ತಾ ಇದ್ವಿ. All right. We'll impose some cost and take it on record.
I'm a new counsel on record, my lords. Yesterday only I filed a wakalat.
MVC,
Yeah, yes, my lords.
Clements appeal or
MV.
trial court ಅಲ್ಲಿ ಹೋಗಿಲ್ಲ ಯಾರು? What had happened before the trial? Hello, ಆಗಿ.
I'm for victim, my lords.
the process memo ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಅದ್ ಕೊಟ್ಟಿರೋದಾದ್ರು
Yes, my lords. It's sufficient, my lords.
the process memo submitted is correct in order and list on. In the meantime, if you want to file application, list after list on date ಕೊಟ್ಬಿಡಿ.
21-3.
Much
For final hearing. Serial number 43 adjourned, 44. Getting Gurudev Prasad. C.R. Ravishankar.
Appellant in this case, Your Honor. Short date, Your Honor.
44
Yes, Your Honor. 44 and 46.
44 ಅಲ್ಲ ನಮ್ದು.
41 number, sir.
list on
19-3.
19-3. Yes.
Let's see. I appear for respond in this case, my lord. Kindly a date may be fixed, my lord. I appear for
23. 46 KT Gurudev Prasad.
much obliged.
My lord.
Very list on
19-3.
Short date.
whatever is available date we have given.
47 VC Sitaram Rao. Pallava R.
List on ಇದರಲ್ಲೂ ಏನೋ ರಿಲೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿಲ್ಲ. ಡೇಟ್ ಶಾರ್ಟ್ ಡೇಟ್ ಹೇಳಿ.
21-3.
21.
48 adjourned, 49 adjourned, till number 50. Chauri HR.
50.
Serial number 50, I appear for appellant, my lords.
Sorry, list on date
22.
22 ನಾ? ಏನು ಅರ್ಜೆಂಟ್ ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ? have taken the amount? List after 2 weeks. Yes.
Seal number 51 at dispose.
You file the wakalat in, so one case wakalat is also not filed.
Seal number 52 Kevani B Pradeep.
Short date may kindly be given, my lord. Short date may kindly.
List after 2 weeks. Permission for production. Really, claimant's appeal is, claim petition is dismissed or allowed?
Short date may kindly.
ಅಲ್ಲ
Claim petition is dismissed or allowed?
claim petition dismiss ಆಗಿದೆಯಾ ಅಲೋ ಆಗಿದೆಯಾ?
Allow ಆಗಿದ್ರೆ no, list after 2 weeks.
Seal number 53
Upper-
Hemanta B
Appellant,
The appellant in
53.
53.1.
53.2.
Yes.
Involvement of vehicle is in dispute.
Release pending ಇದೆಯಾ?
Houses, madam. Short date may be given, ma'am.
24-3.
20.
Much.
Seal number 54 Uday Kumar RN.
Current liability, shouldering the liability.
My lord, I appear for the respond.
There are 11 cases are connected, my lord. Only one ground it was shoulder
List of
liability
receipt
and
of TCRs
My lord,
in all the matters.
my submission in 54.11, the victim is a 12-year-old girl, my lord. 11. She's a 12-year-old victim, my lord. On the last occasion, they had filed an application for stay. We had not yet been served with notice. They have not pressed their
Yeah, I'm not
application
pressing
for
that,
stay
sir.
because
Last
they don't want to deposit any money. She's
No order.
No, I'm not, last occasion, I'm not pressing for any of the interim order for stay of the order.
My
There
lord-
are- Some of them are already filed in execution.
It's not showing that IA is pending.
That was last occasion, it was shown, but I was made a submission that I'm not pressing for the
Not
stay.
pressed. No order is passed on the
my lord, my
They are
submission
already,
is
some
this.
of them are already filed in execution also.
interim order. If you want, he can execute the order.
That's, there are already somebody are filed.
May
Therefore,
may
it
a
may be
short date be?
Short date
He
maybe.
will not be able to deposit, so he will not press for the application.
No, the-
ಅದು ಹನ್ನೊಂದಿದೆ, there are 3 deaths are also there. Therefore, my application is there for order 41 rule 27. There is only on one ground it was shoulder the liability and the
Not here.
owner. On permit ಇಲ್ಲ ಅಂತ.
Rudrappa P.
Date may be given, my lord, in this case.
List after 2 weeks ಅಂತ ಹೇಳಿದೆ. ಎಷ್ಟು?
My lord, one date may be fixed.
Receipt of TCR.
See, list after receipt of TCR. in all the-
54.8 ಇಂದ TCRs ಬಂದಿಲ್ಲ ಸರ್ awaiting ಅಂತ ಇದೆ.
ಸರಿ.
One date
50.
put
55 Rudrappa P. Jayashree Kulkarni.
ಹ್ಮ್.
tomorrow. I filed IA for stay.
ಏನೇ what is the to be executed interim alimony na? Sorry, permanent alimony ಎಷ್ಟಿದೆ? ಡೆಪಾಸಿಟ್ ಮಾಡಿ interim stay ಕೊಡ್ತೀವಿ. You have not pressed it, though you have filed it in 2022, you have not pressed so far. It appears interim stay application itself is filed in 2025, after 3 years. Wait. This on date here. Just 2 weeks between date.
25-3.
25.
56 Tejas N SPP. The date might.
List after 2 weeks. Yes.
57 urgent, 58 at dispose, 59 urgent, seal number 60 Abubakar
Serial
Shafi.
number 60, my lord, 60 appears for the appellant. It's very, very simple matter, my lord. Matter has to be remanded because
Not
of the
simple for us
expert.
after 5 o'clock. Yes.
So 14th date ಕೊಡಿ, 14th, on 14th. It's very simple matter, my lord.
26-3.
My lord,
26-3.
ಅಲ್ಲ 14ಕ್ಕೆ ಕೊಟ್ಟರೆ ಒಳ್ಳೇದು. ಏನ್ ಸಿಂಪಲ್ ಮ್ಯಾಟರ್ ಇದು.
Appear for us.
Not possible.
Vasanta AK.
Appear for respondent, my lord.
First week of April.
They are not following the directions of this honorable court. They are supposed to produce the baby, till now they have not produced. Last time also they did not give the child to me. Without my knowledge, they shifted the residence. Last time also they did not follow.
How they are related to each other?
Not,
Because
I am the father.
you are the father.
I'm the
Grandfather.
grandfather of that,
Maternal grandparents.
Maternal grand.
Yes, ma'am. From the day only custody. with
Child
me.
court passed orders
But
again.
now the children.
In my favor.
26 parties are directed to appear for the court along with the child.
Last time
Last date
also.
of hearing, they were appear before this.
No,
court.
they did not
Along
come
with
in
child
time,
also.
later
Kindly
they
see the
came.
order sheet, my lord.
And they
And
have,
today, the child is not good health,
No,
my lord.
they have
He's in hospital.
they have to hand the child to me every alternate Sunday.
Today is not well, my lord. He's in hospital.
ಏನಾಗಿದೆ?
ಅವ್ರಿಗೆ ವಾಮಿಟು ಮತ್ತೆ ಹುಷಾರಿಲ್ಲ ಅಂತೇಳಿ ಹಾಸ್ಪಿಟಲ್ ಇನ್ನೂ ಹಾಸ್ಪಿಟಲ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
Medical records ಕೊಡಿ.
Where is the present?
Today only, my lord.
Where is the record?
Next date of hearing, I will produce the medical record.
Submits that the child is.
My
hospitalized, therefore-
And also,
Let them follow the
children's,
orders of this honorable court.
examination is going on. First week of April, date maybe.
ಏನಾದ್ರೂ ಬರ್ಬೋದಿತ್ತಲ್ಲ.
ಅಲ್ಲ 2 weeks ಇನ್ನ exams ನಡಿ.
Leave.
So LKG.
He is the maternal grandfather.
Maternal grandfather.
Grandmother is there?
Grandmother is also there.
Why she is not made party?
Now we have not made them party, only grandfather is alone.
The custody of grandmother.
They came here, they came along with the child, they came. They vacated the house without information to where they are, I do not know.
No, my lord. I'll produce the document.
Not appear for the court today. We shall produce the medical.
My request is this honorable court can direct them to follow the orders earlier passed first.
Earlier order.
So use the child every week.
No, exams going on, and it's not
Have
with,
exams.
maintaining the
Baby.
book.
Earlier order audits.
Sunday
Earlier
exam ಇರ್ತಾವ್ರಿ.
Sunday ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
Every Sunday.
Earlier order date.
Dated I
ಹೇಳಿ ಅಂದ್ರೆ ನೋಡ್ತೀವಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಮಗೆ ನೋಡಕ್
Second Sunday ಮತ್ತೆ fourth Sunday ಮಗುನ
ಸೆಕೆಂಡ್ ಅಂಡ್ ಫೋರ್ತ್
ಕೊಡ್ತಾ ಇಲ್ಲ.
ಮನೆಯನ್ನು ಶಿಫ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀನಿ.
either to the court or to the other side.
I'm filing the affidavit next interview. Before that, I'll file that application and also I'll serve that.
If his child is unwell, should he not know that?
He was very much present in that. When I'm shifting the house, he was standing in front of my house only. Everything is watching every day. Every day he's standing in there, my house, and he watching everything, my lord.
ನೀವು ಹೇಳೋದದು ಅವ್ರಿಗೆ ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದು ಏನಾದ್ರು ಇದೆ?
I'll pass it in the address. ಅಲ್ಲ ಜಾಸ್ತಿ ದೂರ.
visitation in Bangalore madam.
So temporarily ಅಷ್ಟೇನೆ ಸ್ವಾಮಿ.
Yes madam. Will Friday ಹೇಳಿ.
ಅಲ್ಲ ಎಕ್ಸಾಮ್ ಆಗ್ತಾ ಇದೆ ನೆಕ್ಸ್ಟ್.
ಅವ್ರ ಎಕ್ಸಾಮ್ ಅಂದ್ರೆ ನೀವು ಬಂದು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ನೋಡ್ತೀವಿ.
No representation, grandparent.
Next week.
One submission, my lord.
Appellant shall produce the medical records of the child on 17. Right.
Oblige.
One submission, my lord.
Madam, new matters ಕೇಳಕ್ಕಾಗಲ್ಲ please.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ 2015 ಇಂದ ಈ ಸಸ್ಟೈನ್ ಇಂಜುರಿ ಅಂಡ್ ಬೆಡ್ ರಿಡನ್ 2015 ಇವ್ರಿಗೆ ಅಮೌಂಟ್ ರಿಕವರ್ ಆಗಿಲ್ಲ.
Sir, signature parties.
Appellant ಬಂದಿದೆ.
Court officer, serial number 60 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟದ್ ನೀವು?
ಇಷ್ಟೇ ತಗೊಂಡಿದ್ದು.
Hello.
ಮೇಡಮ್ ಅದೆಲ್ಲ 2010 ಎಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಇರೋದ್ರಿಂದ ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಇದು serial number 60 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು?
RFA ಬರ್ತಾ ಇದೆ.
ಅಲ್ಲ serial number 60.
17. ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡ್ಬೇಕು ಚೈಲ್ಡ್.
ಫೈನಲ್ ಕಾಲ್ ಆಗಿ ಬೆಡ್ ರಿಡನ್
ಯಾವ್ದು ಹೇಳಿ? 60ನೇದಲ್ಲ 26 3.
26
ಬಿಸಿಲಿದಾರ ಅವ್ರು.
Sign ಮಾಡಿ.
ಮೇಡಮ್ ನಾನು ಒಂದ್ ನಿಮಿಷ ಹೋಗ್ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟಿದೀರಿ ಓಡೋಗ್ಬಿಟ್ಟು.
Sign ಮಾಡಿ ನಿಮ್ಮ ಹೆಸರು
ಏನ್ ಆನ್ಸರ್ ಮಾಡ್ತೀವಿ?
ಮಂಡೇ ಬರ್ತದೆ ಮಂಡೆಗೆ మీకు ಹಾಕಿದಾರಲ್ಲ
ಶಿಕ್ಷೆ ಮೇಡಮ್.
ಮೇಡಮ್ ನಾನು ಏನು ಆಗಲ್ಲ.
15 ನಿಮಿಷದಿಂದ ಬೆಡ್ ರಿಡನ್
ಮೇಡಮ್ ಹೆಸರು ಬರಬೇಕಾ? ಬರುತ್ತೆ 5400.
told me.
Madam, 60. ಅಲ್ಲ ಅವ್ರಿಗೆ ಸಬ್ಮಿಷನ್ ಏನಾದ್ರು ಮಾಡ
ಅದೇ ಡಿಸ್ಪ್ಲೇನ ಆಫ್ ಮಾಡಿ.